You can start the clock again. It was a brief pause, just a little. Thank you for helping to clarify, Ms. Epley.
Now, Mr. Garrison, interesting times during COVID as a banker. Yeah?
Without a doubt.
I'm sure your customers took out PPP loans. Yes?
They did.
And you were probably working that all from March forward. Yes?
We were.
With major clients of the bank, I'm sure. True?
Yes.
You had loans in workout from customers who couldn't transact as much business probably as they wanted to. True?
No.
You didn't have any loans in workout during COVID?
Three.
Three total for the bank?
Yes, sir.
All right, we're going to go one by one through them here in just a minute.
Okay.
You familiar with the CARES Act that prompted the PPP loans?
Objection, Mr. President. Relevance.
It's about to get real relevant.
I'm willing to let that question in, overruled.
Okay. You familiar with the CARES Act?
I am familiar in as much as I know it exists. I did not read it in its entirety.
There was an eviction moratorium, wasn't there?
Objection, providing facts not in evidence. He said he's not familiar with it.
Sustained.
Let me try again. Did you know there was an eviction moratorium under the CARES Act?
Yes.
Did you know there was a foreclosure moratorium under the CARES Act?
Yes.
Did you know that it went until July 30th of 2020?
I did not.
As the president or CEO of your bank, was you president or CEO or both?
Both.
As the president and CEO of the bank of Amplify Credit Union, why don't you tell ladies and gentlemen of the jury when the foreclosure moratorium ended under the CARES Act?
Objection, relevance.
Overruled.
If you would.
I don't know.
You don't know? Okay.
No.
Amplify wasn't Nate Paul Senior lender or anything, was it? You had three
Objection,
loans.
speculation.
Sustained.
Was Amplify Nate Paul Senior lender?
Objection, speculation.
If you know.
He asked the question, overruled. You can answer.
We were with respect to these three properties.
Three special purpose entities that Mr. Paul set up, true?
Yes.
Okay. I want you to take a look at what's been marked as Exhibit AG 1031. And Your Honor, at this time, we move for admission in bulk of Exhibits AG 1031 through 1044.
Any objection?
Your Honor, I don't know. He has not provided me a copy.
I handed it to you, didn't I? Big stack right there.
Oh, I don't know.
Got a sticky note, it's purple. That's the ticket.
I
Ms.
stand
Epley.
corrected. Your Honor, or Mr. President, I think they're exact duplicate of what I've already provided. No objection.
Not quite. These are actually in chronological order, but no objection, right?
No objection, Ms. Epley?
No objection, Mr. President.
Mr. Arroyo, if you would.
Hold on 1 second. Let me
sorry.
submit them to evidence. AG 1031 to 1044, please. AG 1031 through 1044, please admit to evidence.
Mr. Arroyo, if you would. AG Exhibit 1031. Your lawyers are Streisand, Landon, Osborne, and Lemon, correct?
Yes.
And Steve Lemon is a partner in that law firm, correct?
His name's on the letterhead, so one would presume.
Yeah, and he was actually the lawyer representing the receiver in a separate Nate Paul case, correct?
Objection, speculation, and relevance.
Overruled.
I don't know.
You don't know. Okay. What's the date of this item here?
The date is May 27th of 2020.
Okay. And what is this document?
This is a notice of default and demand for payment.
Okay. At least as of May 27, 2020, the bank had hired, I'm referring to Amplify Credit Union as the bank. Is that okay with you?
Perfectly fine.
Great. The bank had hired an attorney, and it had hired an attorney to make a demand on WC Alamo Industrial Center LP, a Nate Paul entity, true?
In this case, yes.
Mr. Arroyo, Exhibit 1032, please. Same thing with regard to WC 707 Cesar Chavez. Yes?
Yes.
AG 1033, Mr. Arroyo. Same thing with regard to WC Custer Creek Center Property LLC, correct?
Yes.
All three of those entities are in default at the bank as of May 27 of 2020, right?
Yes.
So you posted them for foreclosure in July of 2020, right?
We would have had to post those.
Object not responsive.
Sustain, answer the question.
So you posted them for foreclosure in July 2020, right?
Yes.
No, you never did you?
Then I object to relevance, Your Honor.
Did your bank post?
Well, overruled.
Did your bank post these three properties for foreclosure in July of 2020?
Objection, relevance.
Overruled.
Can you ask the question again?
Let me try for the fourth time. Did your bank post these three properties for foreclosure in July of 2020? Yes or no?
I don't know when we posted them for foreclosure, but they were posted for foreclosure.
That wasn't my question. And I believe the answer to my question is you don't know, right?
Okay, guys,
And
I'm back.
if that's my only choice, then I don't know when we posted them for
They
foreclosure.
weren't posted for foreclosure in July of 2020 because there was a foreclosure moratorium under the CARES Act, true?
Y'all remember that? Y'all remember the foreclosure
If-
moratorium?
I am not aware of that, how long that moratorium was actually in place. But if you want to foreclose
much
on a
through
property,
most
you
of
have to
COVID.
file a foreclosure, I believe, 21 days before the scheduled foreclosure date.
That's right.
So filing is not a foreclosure. It is the notice of intent to foreclose on the first Tuesday of every month as foreclosures take place
Y'all
in
give me a
Texas.
5 by 5
And
if
surely
you
the
can hear
bank
me and
wanted
let
to
me
get
know if
its
I'm
money
too
back
loud.
through foreclosure as fast as possible, right?
Objection, argumentative.
Sustained.
Did the bank want to get its money back as fast as possible through foreclosure?
We wanted to receive repayment by whatever means necessary.
Very good. Mr. Arroyo, exhibit AG 1034, if you would. Now, this is an affidavit of posting of a property for foreclosure, right?
It appears to be, yes.
And the date of this is July 10 of 2020, yes?
Yes.
And the entity that's being foreclosed upon is WC Custer Creek Center Property LLC, yes?
Yes.
And that's in Plano, Texas, my neck of the woods, Collin County, Texas, right?
Yes.
This is
So you
important,
posted
what
this
they were
one on
doing
July
to
10th
Nate
for
Paul.
August
This
foreclosure,
matters.
yes?
It appears to be that, yes.
Your testimony on direct was you posted all three of them for August foreclosure, correct?
That is my recollection.
That's not right, is it? Let's take a look at what's marked as Exhibit AG
That's crazy. He
1035.
didn't seem concerned over whether his statements were accurate just then. That was odd.
This is an email from Nate Paul to some people at the bank, yes?
It is.
And Nate Paul says, I'm writing to confirm you're aware of the attached announcement. Ms. Epley went through that with you, correct? Correct?
Can you ask that once again, please?
Ms. Epley went through this email with you, correct?
Yes, and I saw the email at the time.
Last sentence of that first paragraph, it says, in light of
I'll remember
foregoing,
DOJ
please confirm
Aaron
before
Epley.
5 p.m. today that you will not be attempting to proceed with a foreclosure tomorrow. A foreclosure tomorrow, not three. True? That's what Nate Paul says in this email, right?
He does use the words a foreclosure.
And on when responds the next day. That's House Board of Managers Exhibit 676 that was on the screen earlier. And she says, Brian, it is, and she's writing to Brian Elliott at World Class. It is our position that the restrictions cited in the unsigned informal guidance would not apply to our particular foreclosure sales. However, as a courtesy to borrowers and per your/their request, Amplify is willing to postpone the foreclosure sale to September 1, 2020, right?
I don't have that document on my screen, so I can't confirm or deny that's what it says.
Would you like to look at my copy?
Sure.
Mr. President, the House is willing to concede that the email written by them, his client, is in the singular.
It's a little late for your concessions. I'd like the witness to answer my question if I could, Mr. President.
Let him read it, and then you can repeat the question.
Thank you.
She does use the word the.
Mr. Arroyo, Exhibit AG 1036, please.
Is that
You
the,
didn't even notice the substitute trustee sale for WC 707 Cesar Chavez until August 7, after the AG's opinion was issued, correct? Correct?
I have a different recollection of those events.
Well, that's why we have documents, right?
I believe this was the second posting
Oh, really?
to make it for the September sale.
Do you have a document with you, perhaps, or in that massive pile of documents somewhere where your bank posted the other two properties for foreclosure in August?
I do not.
It seems kind of important-ish, isn't it? You don't have that, do you?
I do not have a document of that nature before me.
Well, in any event,
sorry about that, guys. My computer glitched up.
WC Alamo Industrial Center also posted on August 7 of 2020 after the opinion was issued. True?
Yes.
Exhibit AG 1038, if you would. A separate notice regarding substitute trustee sale, August 7 of 2020 for WC Alamo. True?
Yes.
After the opinion, yes?
Yes.
And just to be clear for the ladies and gentlemen of the jury and for the media who's gathering information on this, you told the media you had all three properties posted for foreclosure in August of 2020. And we read about it in the newspaper. True?
Yes.
In fact,
you-
not in evidence.
But you don't have,
Objection.
What is your objection?
Facts not in evidence, relevance, and counsel's testifying.
he just said yes.
Sustain the objection.
Come on.
You told the media you had all three properties posted for foreclosure in August of 2020, correct?
I don't recall my exact words, but I did tell the media that we had those, that we had world-class properties posted for foreclosure. Yes.
You don't have a document to prove the other two, do you?
No.
Show you what's marked as Exhibit AG 1039. This is the affidavit of posting for WC 707 Cesar Chavez, correct?
Yes.
Exhibit AG 1040, if you would, Mr. Arroyo. We're going fast, but I think you can keep up. Mr. Garrison, was it? We're at August 10 of 2020. It says notice regarding substitute trustee sale. This is for WC Custer Creek. True?
Yes.
You re-noticed it for the next month. Is that right?
Yes.
Tell the ladies and gentlemen of the jury, were any foreclosures being stopped in Collin County, Texas at this time?
I wouldn't have knowledge of that.
You don't know, do you?
No.
So when you testified on direct that for whatever reason,
All of them were.
this opinion disrupted the business of foreclosing these properties at the bank, you don't really know whether Collin County stopped doing any foreclosures at all, do you?
Objection asked and answered as to Collin County.
Overruled.
You don't know, right?
I only have knowledge of what Amplify Credit Union did in response to the midnight opinion.
That really wasn't my question, so let me try again. Do you know whether Collin County was doing foreclosures at this period of time or not?
I do not.
Mr. Arroyo, Exhibit AG
Yes, they
1041,
were.
if you would.
It wasn't for Nate Paul. This was a statewide and nationwide issue. Remember, we covered that already. We we showed the the articles confirming that, articles from that time confirming that it was a nationwide, statewide concern. They halted.
And this is your
foreclosures.
affidavit of posting of W.C. Custer Creek Center property for foreclosure on August 10 of 2020, correct?
Yes,
Now, you sold all 3 notes, right?
we did.
So you didn't have to foreclose any of the 3 properties, correct?
Ultimately, we did not have to foreclose on any of the 3
So-
properties.
And you didn't have to foreclose any of them because your bank lost $0.
Yeah, they lost no money.
You sold all 3 notes and your bank lost $0
So it didn't hurt any process.
as a result of whatever this informal legal guidance was, correct?
That is correct. We ultimately sold those notes.
And you didn't lose a single dollar. Just tell the jury.
We did not.
Why? Well, let's put our heads together. How did all 3 notes get sold at the same time? Doesn't that seem coincidental?
It was not a coincidence at all.
It wasn't a coincidence because Brian Hardiman, it's a man who his name may or may not have come up in this trial at some point. He put together 3 special purpose entities and he had his agents come and buy these notes from your bank. Yes?
I have no idea. I know that the notes were purchased. I do not know who formed the special purpose entities. I only know who I interacted with.
Isn't it true that all 3 of these notes were sold to special purpose entities of Brian Hardiman?
I don't know.
Isn't it true this is the same Brian Hardiman who's the subject of the bid rigging investigation in Travis County District Attorney's Office referral number 2, and the same man who sent Ken Paxton a picture of a dead
Objection,
deer?
Your Honor.
Oh my
I'm sorry,
Mr.
not quite
President,
done yet.
no, absolutely not. Facts not in evidence and
Oh my
absolutely
God.
staining someone who's not here without any basis.
Wasn't quite finished, but
Sub-
Mr. President.
Sustained.
Oh, come
Very
on.
well. Who did you interact with on the sale of these 3 notes?
Justin Bain.
Justin Bain. Okay, so I guess what we would need to do if we wanted to see if there was any connection between Justin Bain and Brian Hardiman, we could just probably Google Justin Bain
Objection,
and
Your
Brian
Honor, if
Hardiman,
I
right?
could, Mr. President.
Yeah, we can do that right now. In fact,
Sustained.
Thank you.
If you would, Mr. Arroyo, exhibit AG 1042, please.
we can do it right now.
Statute. I'm now opening the bidding. Do I have an initial bid?
It's auction day in the state capitol. The scheduled foreclosure of some of Austin's priciest pieces of real estate, all owned by one of Austin's most famous real estate developers, Nate Paul.
$11,750,000 right here.
More than $11 million being bid. That's big money. And among the bidders is a familiar face, despite the mask, to us here at Dolce Fino Consulting. His name is Ali Chowdhury. Why do you think so many people accuse you of fraud? Chowdhury's facing a mountain of accused real estate racketeer with money to burn in Austin's this failed condo project up in the Heights. Yet there he is, Houston's accused real estate racketeer with even the lawyer who helps Chowdhury a lot is caught on tape critiquing the Houston real estate investor. Chowdhury's latest trouble here at home, this failed condo project up in the Heights. Yet there he is, Houston's accused real estate racketeer with money to burn in Austin's frenzied real estate wars.
Going once, going twice, sold.
When the bidding was over, it looked like Chowdhury had won. But now he's gone to court, claiming the auction guy, Houston attorney Mark Riley, was conspiring with another bidder to rig the result. It's the guy standing next to Chowdhury, Will Hardiman, son of Austin car dealer Brian Hardiman. If you buy a car in the state capital, chances are you got it from a Hardiman car dealership. But that fight between Chowdhury and Hardiman, it pales in comparison to the real estate war going on between Nate Paul and Hardiman.
We are tendering funds on you to fully pay the loan. You're not accepting it, right?
We're gonna
Yeah. So you're refusing to accept the funds, right?
go around and go find you a court in this building to come and stop this.
Paul's company, World Class Property, had fallen behind on the payments on some of their biggest properties in Austin. And companies linked to Hardiman had swooped in to buy some of the debt. On video, you can clearly see Paul is trying to pay the debt off on the properties before the auction even starts. And the law says he can.
We've delivered funds to pay off.
Funds are here, cashier's checks.
By redeeming the amount, the deed is ours.
But the lender helping Paul pay off those loans said in a sworn affidavit, quote, "In my 30 years of experience, I've never encountered a situation such as this." But the trustee holding the auction, he doesn't seem to care. We'll talk about him a little more later, but you can tell it got ugly.
Amount due, mother. We've tendered the amount due.
The real estate battles in Austin are making headlines across the state, and that nasty confrontation is captured from all kinds of angles. Everyone seems to want to document what happened for the courtroom.
Go around and go find you a court in this building to come and stop this.
Okay.
Why don't you try that?
Okay.
Wonder why Hardiman seems so confident of the results he'll get in a Travis County courtroom. This is the following month, June, protesters trying to shut the auction down. And yes, you heard right, they're chanting F you. The Austin American-Statesman reported that Paul's company, World Class Properties, had 9 properties foreclosed on that day. The largest portion, a $100 million property, the 3M campus. A California company called Carlin bought properties at that foreclosure supposedly worth, wait for it, $139 million. The July auction was even uglier. There's a photo of Ali Chowdhury being escorted away by Travis County Sheriff's deputies. That auction fight over another Nate Paul property, the building that houses the famed Capitol Grill in Austin. No dispute Paul's World Class Property company had fallen behind on the loan payments. They owed less than $8 million on a property worth upwards of $25 million. But before you say too bad or it is what it is, look what Dolcefino Consulting has uncovered. On April 14th of 2020, Brian Hardiman got U.S. taxpayers to bail his car dealerships out during the COVID crisis. A lot of car dealers did that. More than $41 billion of your money was handed out in loans across Texas to save jobs during the pandemic. But there was a catch. You had to promise you were getting the money to support ongoing operations. Government records show Mr. Hardiman needed a lot of your tax money to keep his folks working. More than $10 million in PPP loans. $3.7 million to Austin Infinity, $2.6 million to Continental Cars, $3.9 million to Continental Imports. On the very same day that Hardiman's companies got that government bailout, records of the Texas Secretary of State show a company was created, Colorado 3rd Street LLC. On paper, the company is owned by this guy, Justin Bain. 2 weeks later, that same company, Colorado 3rd Street, it bought one of the big loans owed by Paul's companies, Capitol Grill. But where did Justin Bain get the money to pull the trigger? Records obtained by Dolcefino Consulting show the funding for Colorado 3rd Street LLC was provided by Austin Infinity and Continental Cars. Those are Brian Hardiman's companies. We now know from those court documents that Hardiman's entities don't just fund Colorado 3rd Street, they own 80% of it, kicking in $7.6 million. That's a lot of money for car dealerships that said they needed a government bailout just 2 weeks before. Good thing money is fungible, right, IRS? The Capitol Grill isn't the only Nate Ball property that Hardiman entities have foreclosed on. And in each and every one of those foreclosure sales, it's the same trustee, the guy you met earlier, Houston-based attorney Mark Riley, the guy you saw get into it with Nate Paul. I wonder if Paul's lawyers know what we do. Mark Riley has a history of alleged fraud. He was sued in 2004 for misusing trust funds of the family of a Houston multimillionaire Robert Alpert.
Sold that note to somebody called Alamo Lanark, right?
Yes.
Justin Bain entity, B-A-Y-N-E, true?
Yes.
Didn't lose a dime, yes?
I'm sorry, say again?
The bank didn't lose a dime, right?
Right.
Exhibit AG 1043, if you
I'm
would,
gonna
Mr.
put a link in
Arroyo.
the chat for you guys. Okay. This is a Facebook link, but still.
Sold this note to something called Cesar Rainey Street LLC, right?
Yes.
Bank didn't lose a dime, right?
Right.
Justin Bain entity,
All right, guys, check the
B-A-Y-N-E,
Rumble chat
right?
Yes.
for Justin Bain and Brian Hardiman.
Exhibit AG 1044, please,
Okay.
Mr. Royal.
Click that. All right, Pilled, Foxhole, y'all check your chats. All right. And
Sold this
anyone
note
watching
to
on
something called
YouTube,
Spring
check
Custer
this in the
LLC,
chat.
and the bank didn't lose a dime, right?
Yes.
Justin Bain entity, B-A-Y-N-E, right?
Yes.
Bain.
You've been in banking 44 years, did I hear that?
Yes.
That's a long time, right?
It is.
If somebody wanted to, I don't know,
Here,
foreclose on
I'm
a
doing another
piece
one.
of property themselves and wipe out the existing owner's equity, this is probably a good place to start, isn't
Putting
it?
another link in there, you guys.
Objection,
Check
Your
this out.
Honor. The default has to occur first. He's implying things that aren't relevant.
Sustained.
No further questions.
Here's another link for both Rumble
Redirect,
and
Ms.
Pilled and
Epley.
Foxhole. Here's another one. Y'all.
No, Mr. President.
Do both
Check
of
this
you
out.
excuse the witness?
Bain, B-A-Y-N-E.
Mr. Little, excuse the witness?
He is, Mr. President.
Okay. You're
Oh,
excused.
wait,
Thank you,
hang
sir.
on a second. Let me
And I
fix
believe
that.
this was the last.
Yesterday, at the end of the
Counselor,
day,
state your name for the record.
Of course, Allison Collins.
I always give you the time check. Members, House, you have 2 hours, 34 minutes and 49 seconds remaining. A respondent, 8 hours, 38 minutes and no seconds remaining.
now at the end of the day yesterday, good morning, everybody. Thank you all for being here. Those were recaps that I had been playing. I'm going to take this off now because we are live. They are just about to start for the day. Oh, let me fix that. We are on day 9 of the impeachment of Ken Paxton, political takedown of Texas's Attorney General, but really we like to refer to him as America's Attorney General. And I see in the comments some people said my mic was hot. That was a recap, so the audio might have been a little more harsh on the replay when I'm restreaming than when because I'm talking as low as I possibly can right now without actually whispering. But we'll just test that.
Senator Alvarado, I believe you are delivering the prayer this morning.
It's prayer time, everybody. Thank you so much. If my whisper is too loud for you, please let me know. And
Good morning.
thank you guys for being here. Please
Father,
like
Son,
and share
Holy
this out.
Spirit. Amen. Heavenly Father, in this sacred chamber, we come together as servants of the great state of Texas. united by the privilege of serving our fellow Texans and serving you, Lord. As we near the end of these proceedings, let us take a moment to reflect on the weight of our task and express our gratitude for the trust placed in us. We recognize the solemn responsibility that accompanies our positions, and we pray for the guidance and wisdom needed to make decisions that honor the best interests of the state of Texas. As we stand here today, representing different communities and backgrounds, we are thankful for the strength that comes from our differences. It is through unity and collaboration that we find common ground, work together harmoniously, and uphold the values that define this great state. We are grateful for the opportunity to serve, for the chance to make a difference, and for the trust that has been bestowed upon us. May your grace shine upon this chamber, lighting our path as we navigate the challenge before us with humility and dedication. With your presence, Lord, as our guiding light, we are confident that we will meet this challenge with unity, integrity, and a shared commitment to the people of Texas. In your name, we offer this prayer. Amen.
Amen. You may be seated.
Thank you, everybody, for being here. Please like and share this out. Just showing you a recap of day 6 cross-examination. That was before the House accidentally rested. So the House witnesses were actually being cross-examined. I believe that's what that was. Yeah, the House witnesses were being cross-examined. And Attorney Little did an amazing job pointing out that the Mitty Foundation, nobody involved was harmed by anything that was happening with the investigations Nate Paul asked for help with. Nobody was harmed other than Nate Paul and now the Attorney General of the great state of Texas. And for what? For simply looking into complaints that were referred to his office by the Travis County DA from a very concerned citizen who, I mean, guys, I think we'd all be concerned if during COVID, during a mandated lockdown, we had 9 properties foreclosed on because we couldn't make the payments for it when it was a mandated lockdown and money was stagnant globally. For the banks to just go around and seize property is wrong.
Good morning, everyone.
Thank you, guys.
In the gallery and those who are watching online. Before I begin, I have a few remarks to make. I first want to thank our clerk, Patsy Spa, and her entire team, and Austin, our bailiff, and all his team for their work during the trial. I've had questions, who are these people behind me? They've never been introduced. This is Darrell Davila, my chief of staff, former prosecutor, strong legal background. This is Chris Sterner, my legal counsel, strong legal background, working for governors before this, and Lola Fender, our deputy chief counsel. They've done tremendous work. And of course, Judge Lana Myers, who served as a prosecutor on a criminal court in Dallas and on the 5th Court of Appeals. I would not have been able to work through these last 2 weeks without them. As I said on day 1, I've never been to law school. I've never taken a course. But we prepared for the last 3 months to do the very best job that we could to present a fair trial, which I think we have done to both parties during this time. We've read thousands of pages of documents of history of legal proceedings, and I even took a little bit of a judge boot camp along the way. So we've done the very best we can. And in a very short period of time, the trial will be in the hands of 30 members of the Senate who will vote. This impeachment trial, for only the 3rd time of a statewide impeachment in the history of Texas, has been closely monitored, either through the media or through people watching online each day. I want to take a few minutes to go over a few of the key rules and to explain about what is to happen, because this is an unusual proceeding, not a normal trial. And I want to be sure the media reports it correctly, and that the public understands everything we do will be in total transparency throughout this process. First of all, we talked about the rules a lot in here. The rules were written and voted on by the members of the court. The final vote was 25-3, and these rules set out the framework for what has happened and what is about to happen. Let me highlight a few of the rules that we often get the most questions on. Pursuant to the rules written and adopted by the senators, Senator Angela Paxton cannot vote because of a spousal conflict. That's in Rule 31. However, the members kept the threshold to convict on any article at 2/3 of 31 members. That means it still requires 21 votes to convict, even though only 30 senators will cast a vote.
This is a point that
It only takes a conviction on one article of the 16 articles to remove the Attorney General from office. Like any jury, the senators will deliberate in private, but under Rule 28, the senators will cast their vote in open court on the Senate floor without debate, one article at a time after each member has finished their deliberations. All 16 articles will be voted on. I want to point out that under Rule 28, it provides that an article of impeachment is not divisible. What does that mean? That means the senators must consider each allegation in each article and determine whether the managers have proved each allegation in an article beyond a reasonable doubt before they can consider whether an article warrants removal from office. Then and only then may an article be sustained. For example, if an article has 3 allegations in it and only 2 are proven beyond a reasonable doubt in the mind of a senator, then a member shall not vote to sustain that article. Members, under the rules you adopted, I will read jury charges as written in Rule 27 after the conclusion of the final arguments. As I said in my remarks on opening day, your decision must be based only and only on the facts and evidence presented here in this chamber. You are the sole judges of the credibility of the witnesses. Evidence consists of the testimony of the witnesses and the materials admitted into evidence during this trial. Statements by attorneys in this trial are not evidence. Questions asked by attorneys are not evidence. I have no idea of how long the jury is going to deliberate. It could be hours, it could be days. Once they have notified me that all members are ready to vote, we will alert the media for a time certain when the members will come to the floor to cast their votes. And we will post that on the impeachment page of the state website. We will try to give the media and the public ample time to be ready for that time certain, at least 30 minutes notice. I know you are interested in the outcome of the trial, so check in on the website from time to time. No evidence whatsoever, members, outside this chamber shall be considered for any purpose. Nothing that I have said as presiding officer and judge, or that I have done, or how I have ruled, shall be considered as an opinion on facts or the case, and my words and actions should not influence your vote, one way or the other. I do not have the vote. You have the vote. The fact that the House of Representatives has preferred articles of impeachment to the Senate gives no inference of guilt. Like any defendant, the Attorney General is not required to prove his innocence or produce any evidence at all. The Attorney General is presumed to be innocent until proven otherwise. Even if a member believes the House managers have proven every element of an article beyond a reasonable doubt, the member may only sustain the article if they also believe Attorney General Paxton should be removed from office based on that article. The Senate jurors will begin deliberations today after final arguments, and they will continue as long as it takes. For the public, in some respects, understand this is like 16 trials in one. This is not a normal trial. They have to decide on 16 separate articles. Unlike a normal jury, the senators will not arrive at a group decision. When each member has come to their individual decision, they will come to the floor and vote one by one on each article. They will not have their phones with them during deliberations. They will not talk to staff during deliberations, legal counsel, or anyone else, members, only to each other during deliberations. They will be allowed, if necessary, depending on how long deliberations go, to sleep outside the Capitol. But under strict rules, members, you shall have no communications with anyone. You may not look at television. You may not look at your phone unless it's a call from a family member, and they should not discuss anything. It should only be for a family personal issue. You can tell your kids good night or your wife or your husband, but you shall not read any news, look at any news, go online, open up your computers. Before retiring to deliberate today, after closing arguments, each juror will be given a copy of the articles of impeachment. They will also be provided with all the exhibits that have been admitted into evidence. Both sides will have 1 hour for final arguments. The House Board of Managers, having the burden of proof, has the right to open and close final argument. They may divide their hour into any time segments as they wish for open and close. That means the House Board of Managers will argue first and last, but only for that total of 1 hour. The Attorney General's legal counsel will also have 1 hour for final arguments. Once again, after closing arguments by both sides, I will read the charge as you have written in your rules to the jury, and you will begin deliberation. I will now read the articles of impeachment. Article number 1, disregard of official duty, protection of charitable organization. While holding office as Attorney General, Warren Kenneth Paxton violated the duties of his office by failing to act as a public protector of charitable organizations as required by Chapter 123 Property Code. Specifically, Paxton caused employees of his office to intervene in a lawsuit brought by the Roy F. and Joanne Cole Mitty Foundation against several corporate entities controlled by Nate Paul. Paxton harmed the Mitty Foundation in an effort to benefit Paul. Article number 2, disregard of official duty, abuse of the opinion process. While holding office as Attorney General, Warren Kenneth Paxton misused his official power to issue written legal opinions under Subchapter C, Chapter 402 Government Code. Specifically, Paxton caused employees of his office to prepare an opinion in an attempt to avoid impending foreclosure sales of properties belonging to Nate Paul or business entities controlled by Paul. Paxton concealed his actions by soliciting the chair of a Senate committee to serve as a straw requester. Furthermore, Paxton directed employees of his office to reverse their legal conclusion for the benefit of Paul. Article number 3, disregard of official duty, abuse of the open records process. While holding office as Attorney General, Warren Kenneth Paxton misused his official power to administer the Public Information Law, Chapter 552 Government Code. Specifically, Paxton directed employees of his office to act contrary to law by refusing to render a proper decision relating to a public information request for records held by the Department of Public Safety, and by issuing a decision involving another public information request that was contrary to law and applicable legal precedent. Article number 4, and both parties had asked me to read these articles before their closing arguments. While holding office as Attorney General, Warren Kenneth Paxton misused his official power to administer the Public Information Law, Chapter 552 Government Code. Specifically, Paxton improperly obtained access to information held by his office that had not been publicly disclosed for the purpose of providing the information of benefit to Nate Paul. Article number 5, disregard of official duty, engagement of CAMIC. While holding office as Attorney General, Warren Kenneth Paxton misused his official power while violating the laws governing the appointment of prosecuting attorneys pro tem. Specifically, Paxton engaged Brandon Kamick, a licensed attorney, to conduct an investigation into a baseless complaint, during which Kamick issued more than 30 grand jury subpoenas in an effort to benefit Nate Paul or Paul's business entities. While holding office as Attorney General, Article 6, Disregard of official duty, termination of whistleblowers. Warren Kenneth Paxton violated the duty of his office by terminating and taking adverse personal action against employees of his office in violation of this state's whistleblower law, Chapter 554 Government Code. Specifically, Paxton terminated employees of his office who made good faith reports of his unlawful actions to law enforcement authorities. Paxton terminated the employees without good cause or due process and in retaliation for reporting his illegal acts and improper conduct. Furthermore, Paxton engaged in a public and private campaign to impugn the employees' professional reputations or prejudice in their future employment. Article 7, misapplication of public resources, whistleblower investigation and report. While holding office as Attorney General, Warren Kenneth Paxton misused public resources entrusted to him. Specifically, Paxton directed employees of his office to conduct a sham investigation into whistleblower complaints made by employees who Paxton had terminated and to create and publish a lengthy written report containing false or misleading information or statements in Paxton's defense. Article number 8, disregard of official duty, settlement agreement. While holding office as Attorney General, Warren Kenneth Paxton misused his official powers by concealing his wrongful acts in connection with whistleblower complaints made by employees whom Paxton had terminated. Specifically, Paxton entered into a settlement agreement with the whistleblowers that provides for payment of the settlement from public funds. The settlement agreement stayed the wrongful termination suit and conspicuously delayed the discovery of facts and testimony at trial to Paxton's advantage, which deprived the electorate of its opportunity to make an informed decision when voting for Attorney General. Article number 9, constitutional bribery, Paul's employment of mistress. While holding office as Attorney General, Warren Kenneth Paxton engaged in bribery in violation of Section 41, Article 16, Texas Constitution. Specifically, Paxton benefited from Nate Paul's employment of a woman with whom Paxton was having an extramarital affair. Paul received favorable legal assistance from or specialized access to the office of the Attorney General. Constitutional bribery, Paul's providing renovations to Paxton's home. While holding office as Attorney General, Warren Kenneth Paxton engaged in bribery in violation of Section 41, Article 16, Texas Constitution. Specifically, Paxton benefited from Nate Paul providing renovations to Paxton's home. Paul received favorable legal assistance from or specialized access to the office of the Attorney General. Article 15, false statements in official records, whistleblower response. While holding office as Attorney General, Warren Kenneth Paxton made false or misleading statements in official records to mislead both the public and public officials. Specifically, Paxton made or caused to be made multiple false or misleading statements in the lengthy written report issued by his office in the response of whistleblower allegations. Article 16, conspiracy and attempted conspiracy. While holding office as Attorney General, Warren Kenneth Paxton acted with others to conspire or attempt to conspire to commit acts described in one or more articles. Article 17, misappropriation of public resources. While holding office as Attorney General, Warren Kenneth Paxton misused his official powers by causing employees of his office to perform services to his benefit and the benefit of others. Article 18, dereliction of duty. While holding office as Attorney General, Warren Kenneth Paxton violated the Texas Constitution, his oaths of office, statutes, and public policy against public officials acting contrary to the public interest by engaging in acts described by one or more articles. Article 19, unfitness for office. While holding office as Attorney General, Warren Kenneth Paxton engaged in misconduct, private or public, of such character as to indicate his unfitness for office as shown by the acts described in one or more articles. Abuse of public trust, Article 20, while holding office as Attorney General, Warren Kenneth Paxton used, misused, or failed to use his official powers in a manner calculated to subvert the lawful operation of the government of the state of Texas and obstruct the fair and impartial administration of justice, thereby bringing the office of the Attorney General into scandal and disrepute to the prejudice of public confidence in the government of the state, as shown by the acts of described in one or more articles. Just one moment.
Thank you, everybody, for being here. Over on the Pilled chat, I want to say hello to everybody because I've been very busy this morning. Haven't been able to say hi. Always in Texas. Good morning. Sorry if my mic was a little bit hot. I am working on controlling the volume of my voice because I don't have great equipment right now. But thank you so much. And thank you for being here. I know you guys could, all of you guys watching on Pilled, Foxhole, Rumble, YouTube, all of you guys could be watching on other platforms, and I appreciate you being here and giving me positive feedback and constructive feedback, but mostly positive feedback for my commentary. Thank you so much for appreciating it. It took a lot of research, a lot of calls, and there are a lot of good people in Texas that know what's going on, luckily. So thank you guys for being here. Good morning, always.
Members, would both parties come forward for a moment?
Good morning, Victoria. Grain of salt, good morning. Let's see. High seas. Oh, wait, that's me. Good morning, me. Stacks, good morning. Crisco, how are you? Good morning. Truitt, good morning. Cisco Kid, good morning. Thank you for being here. Dondo, hello. Dondo, what are you doing? Get a profile picture. What are you doing? You absolute rebel, you have no profile picture. Good morning, Dondo. TGIF, yes, well, all the days blur together. For servers, all the days are the same. For servers, TGIF is okay. Time to get to work. For servers. Filter Dog says is the vote. Good morning, Filter Dog. No, the vote's not now. They have closing arguments from the prosecution and the defense. The House impeachment managers. Oh, who do you think they'll have to make their closing argument? They should go with Rusty Hardin because, to be quite honest, we respect him more. So that's why. And I'm going to share this is the chat over on Pilled, and I'll cut back over to them when they get back to work. Okay. Let's see. Good morning, High Seas. Good morning, Truitt. And Filter Dog. Isotope X. Good morning. Isotope X. I've only had 1 cup of coffee this morning, so I'm still running slowly. Welcome, Isotope X. Over on the Rumble chat, let's see. Oops. Hush me. Okay, now we've got our regulars over here on the Rumble chat. Big Bad Black Conservative, good morning. How are you? He says, Big Bad Black Conservative says, good morning, everyone. Hopefully today is the day our AG gets back to work. Yes, please. That's everybody just set that on your heart, that's what's going to happen. Everybody sees this for what it is. They see the House impeachment manager's case for what it is. Let's see if I can over here. Well, at least, you know what I can do? I can do this. This is our chat over on Rumble. Okay, so good morning, everybody. Good morning, Trump Rocker. JLox213, good morning, and amen. Trump Rocker, shared on Truth, Getter, and Clout Hub. Thank you so much. Thank you so much. Brian222. Nate Paul got scammed out of his properties by somebody who did not like him. Yeah. And with a little bit of help from the administrative deep state, they were successful. Paid for with your tax dollars. Yes, we see that. We see federal tax dollars were allocated to the Hardimans, who then apparently funneled it into a Justin Bain entity who purchased the properties that the Nate Paul properties that the banks foreclosed upon, or that the Mini Foundation attempted to seek legally.
15 minutes, and the House will come back for the remaining time. I will give each, as they get to near the end of their hour time, I will give each side a 10-minute warning, a 5-minute warning, and a 1-minute warning. And I've told them that I'm not going to cut them off in mid-sentence, but they'll have to wrap up when I say their time is up. Mr. Murr?
Oh no, they've got Wyatt Derp giving their closing arguments for the House impeachment managers.
Mr. President, members of the Senate sitting as
Representative Andrew Murr, we need
over
to
the last
primary
2 weeks, the Senate has faithfully carried out its constitutional duty to listen to the evidence. The framers of our Constitution placed a heavy and solemn responsibility on this chamber. The House did not come here lightly. We discovered unprecedented abuse in the Texas Attorney General's office by Mr. Paxton. As elected officials, we take an oath to protect, the citizens of this state, and the sacred public trust. The Constitution charges us with policing our own. If we don't keep public officials from abusing the capacity of their offices, then frankly, no one can. Mr. Paxton's attorneys like to remind everyone that he was elected by 4.2 million voters, but they have blindly ignored the fact that he has ultimately ended up serving one person, himself. Mr. Bangert explained Mr. Paxton's abuse of office in perhaps the most succinct way, and I'll direct you to your screen.
I was deeply concerned that the name and authority and power of our office had been, in my view, hijacked to serve the interests of an individual against the interest of the broader public.
With the help of Jeff Mateer, Ken Paxton was able to build an exceptional executive management team. Mr. Paxton's top advisors were thrilled to go work for him. They came to the office because they believed in him and what he stood for. They were unabashedly conservative, hardworking experts in their fields with rock-ribbed principles. He had hired the best and brightest to help run his office. Mr. Mateer explained at the beginning of trial that these advisors were committed to the rule of law and to conservative governance. In this trial, you have heard from 8 of Mr. Paxton's top and at one time most trusted advisors. There have been several discussions about what the evidence is, but of course their testimony is evidence. Mr. Paxton's advisors were excited about what the office was doing for Texas. They circled around Mr. Paxton and worked diligently to advance the promises that he had made to voters. The travesty is that Mr. Paxton's desire to deliver results for Nate Paul eventually tore the office apart. It metastasized and overwhelmed the office. When it came to Nate Paul, Ken Paxton abandoned and betrayed his trust in knowledgeable staff, his conservative principles, and his commitment to family values, the law, and his oath of office. He repeatedly demanded that his top deputies act as Nate Paul's personal lawyers and not the state's lawyers. He gave the keys to the office. His lawyers have come in here and tried to normalize his behavior. They're not denying that Ken Paxton did any of the acts alleged. Instead, they want you to believe there was nothing wrong with Mr. Paxton ignoring his senior staff's repeated warnings about Nate Paul. Hall of Fame Texas Ranger David Maxwell did not mince words. Your screen, please.
My evaluation of the allegations made by Nate Paul is that they were absolutely ludicrous, without merit, no probable cause, not even reasonable belief that a crime had been committed. The nature of the allegations that he was making were against the FBI, an investigator with the Texas State Security Board, 2 U.S. attorneys, the senior federal magistrate, Mark Lane, and others who were involved in the chain of the signing and execution of the search warrants on his business, his place of storage, and also his home.
Now, it is clear that Mr. Paxton's judgment was completely clouded by his distrust of law enforcement. But his failed judgment does not excuse his intentional abuse of office. Mr. Paxton wants you to find that even though Nate Paul's story was ludicrous, that it was completely fine for him to hire a 5-year practicing attorney as an outside attorney to do Mr. Paul's bidding. He wants you to find that it was completely okay for Mr. Paxton and Nate Paul's lawyer to direct Mr. Kamek to issue grand jury subpoenas against judges, court clerks, police officers, and the spouse of a lawyer involved in a civil lawsuit with Nate Paul. They even want you to believe that going and getting a grand jury subpoena isn't really a big deal. This suggestion is absurd. The ability to issue a grand jury subpoena is a substantial power wielded by our government, and allowing a private citizen to take that power to attack enemies is truly shocking. And Mr. Paxton has admitted that he does not know much about criminal law. When he asked for money from this chamber to settle the lawsuit filed by staff members he wrongfully terminated, he wouldn't even answer a senator's question about the hiring of Mr. Kamek, and instead deflected to a staff member that he said was better qualified to answer. But when it came to Nate Paul and his requests, all of a sudden Mr. Paxton knew best. He refused to reply on the expertise of his staff. He balked at their warnings. And then he hid his actions when he went around them in his attempts to move forward in helping Nate Paul. And he is continuing to claim he knows best. He is sitting here today saying that he was completely entitled to do what he did and that these witnesses were some part of some deep state conspiracy. But once again, Mr. Paxton's claims are divorced from reality. The fact that every action complained of would have benefited Nate Paul is not mere happenstance. As Mr. Paxton's counsel has said, there are no coincidences in Austin. Now let's be clear about what happened here. Mr. Paxton enjoyed the power of his office. He enjoyed his relationship with Nate Paul. It facilitated the life Mr. Paxton wanted. And Mr. Paxton willingly and blindly wielded the power he loved so as to maintain the relationship he needed. This is wrong. The power of the office of Attorney General cannot and should not be handed over to a private citizen to use to attack their perceived enemies. Mr. Paxton claims that he wants the truth, but he hasn't even bothered to be here for the whole trial. He came on the first day, he left at lunch, and now he's here for closing. Clearly, he thinks that he might just get away with this. Had he been here, he could have seen the hundreds of exhibits and the thousands of pages that have been presented to you with 13 witnesses over 7 days that the House have meticulously laid before you. Mr. Paxton put the risk of the citizens of Texas, of the businesses of Texas, and the lives of law enforcement at stake. As the state's top cop, this conduct is and was inexcusable. His actions are precisely the type of grave official wrongs that our Supreme Court has explained merit impeachment. He may claim to be one of us, but unlike the public servants here today, he has no regard for the principles of honor and integrity.
Please like and share this out.
He has betrayed us and the people of Texas, and if he's given the opportunity, he will continue to abuse the power given to him. Mr. President, I yield the rest of my time for my closing.
Mr. Busby?
Gotta get set up here, Your Honor.
Well, that was a terrible closing speech. Wyatt Dirk did not establish
We'll start the clock when he begins
anything
speaking.
other than he's a mudslinger. I love Busby's suit. This
House, you have 50 minutes and 35 seconds
definitely
remaining.
in the running for best suit.
May it please the court. Here we are in the Senate chamber in the most historic trial that's been had in this state in the last 100 years on this evidence. There is shame here, and the shame sits right there that they would bring this case in this chamber with no evidence. I am proud to represent Attorney General Ken Paxton. If this can happen to him, it can happen to anyone. Now, you heard when we started this case, you heard in the media that the evidence is 10 times worse than the public knows. But what a farce that was. What a farce that was. What we have seen instead is a bunch of supposition, mights, maybes, could have been. That's what we've seen in this trial. The very first witness they brought to you, the very first witness they brought to you, it's not working, crumbled under oath. Do you remember? Do you remember Jeff Mateer? Crumbled under oath. So what is this case about? It's about nothing. It's about nothing. Think about it. They failed to gather all the evidence. They failed to review their own evidence. They failed to talk to all the witnesses. Think about this. Brent Webster, the first assistant, did they bring him here? Did they even bother to ask him a question? They didn't even ask him a question. He is the man who reviewed and documented every single thing that occurred. They didn't even call him. You know why they didn't call him? Because he puts to bed all of their foolishness and silliness. They didn't take any sworn testimony. They let witnesses assume and speculate. They failed to even understand the law. And they couldn't even write the articles correctly. Look at the articles that the judge just read to you. They used words pro tem. Their own witnesses admit there was no attorney pro tem. They used words like the attorney general failed to protect charities. That is not the attorney general's job. And let me make sure we're clear about something here. When the House Board of Managers brought this case, they made an assumption. They assumed that this man would quit. They assumed that this man would run and hide. They assumed that Attorney General Ken Paxton would resign. Well, guess what? He did not resign. He is proud and is ready to go back to work. And after this is over, I expect he will go back to work. He has been a rock. He has been a rock, and that office, the Office of Attorney General, has accomplished more than any Attorney General's office in the country. You heard it from the witness stand. Biden's policies come to die in Texas because Attorney General Ken Paxton. Now let's talk about the burden of proof. We've heard about the burden of proof here and there. Is this working? Can I have 1 minute? Can we get this working?
Yes, I've been informed that the PowerPoint connection to your screens stopped as soon as he began his.
There are no coincidences in Austin.
We will.
Very interesting.
We will stop the clock here for a moment.
We're going to take just a moment. Can we get this going, please?
Thank everybody for being here. Truett says he needs to get rid of that GP mustache. That's what I'm going to say. But maybe I'm not going to read the rest of that comment. Duppy says, this guy looks like he should be on a baseball card from the 1880s. Oh, yes, you mean Andrew Murr? Mm-hmm. Well, you can't hide behind the mustache. That's all I'm going to say about that. Melindy says she loves Busby's accent. I do too. Brian Mark says, wow, sabotaging his closing? Well, I'm not quite sure, but Dan Patrick noted that. Melindy asks, who's going to play Busby in the movie? I'm not sure, but they'll need to go to the right costume designer because I believe that is a silk suit. It's beautiful. I love it. Big Bad Black Conservative says, Rumble seems to work way better in Edge than Chrome. Really? I didn't know about that. I use Brave browser. Try that one. Try Brave. Rob Maga says he has a sharp dresser. Yes, Busby looks very nice today in a gray silk suit. I very much like it. I like it very much. Trump Broker says, hope and pray the House doesn't get away with the sham impeachment. Whitney 1963, we have some excellent news, everybody. Whitney says that Medina County has passed a censure on Andrew Murr, who we at Taking Back Texas refer to as Wyatt Derp.
Okay, Your Honor.
Okay.
I think we're ready.
Do you want the screen to catch up to where you are?
Yes, sir.
Okay.
Thank you, everybody. Please like and share this out so people will understand what's been happening to our Attorney General. So people
They thought he would quit. They thought they could bring a bunch of people, 15 people, not put under oath, with a bunch of supposition and guesses and mights and maybes, and they thought he would quit. The Texas Tribune, the Dallas Morning News, the Houston Chronicle, they thought he would quit. He did not quit. He did not quit. And he will not quit. Let's talk about the burden of proof. That is super important here. And I want you, senators, please, to look at your screen and look at the burden of proof. Beyond a reasonable doubt. Beyond a reasonable doubt. That means that you have no doubts that are reasonable. No doubts. That is an incredibly high burden. Can you imagine if we were in any criminal court in the United States that this case would not have already been dismissed based on what we've heard from this witness stand? This case would not, we would not be in final argument. This case would be over, but this is not a criminal trial. This is a political trial. I would suggest to you this is a political witch hunt. I would suggest to you that this trial has displayed for the country to see a partisan fight within the Republican Party. Let's just call it for what it is. That's what we're seeing here. It's being played out on TVs across the country. There is a battle for power. Because there's no doubt that these folks did not prove a case. They didn't prove a preponderance. They didn't prove anything other than they don't like Ken Paxton. Remember this fella, Greg Cox. You remember that guy? Greg Cox. Maybe, potentially, possibly, might have, perhaps, conceivably, could be. He testified that the Attorney General's office was so corrupt, they're involved in organized crime, but you know what? I want to go work there. What a joke. What a joke. I had texts from my former Marine Corps buddies that said that guy is a joke. To come in here in the Senate of Texas and to get on the stand, and these people sponsored this guy. What a joke he was. And in my view, that's exactly what their entire case has been. A joke. Much ado about nothing. The burdens of proof. Look at the burdens of proof, senators. Beyond a reasonable doubt. Now, if you decided this case from the Houston Chronicle, the Texas Tribune, Texas Monthly, the Dallas Morning News, oh my goodness gracious, Ken Paxton's guilty. But there ain't no evidence to support it. The only evidence we have in this case is they don't like Ken Paxton. And there is no doubt There have been hundreds upon hundreds upon hundreds of articles about Ken Paxton and how bad Ken Paxton is. Everybody has heard it, and guess what? The voters heard it too, and guess what? Ken Paxton won hands down, resounding victory. He beat the latest in line for the Bushes. Let it be known, let it be clear now. The Bush era in Texas ends today. We thought it had ended in the primary when Ken Paxton beat George P. Bush 68-32. Well, we thought it was over. It wasn't. Well, now we have an impeachment. It ends today. They can go back to Maine. This is Texas. This case has been nothing more than assumptions. And you know what my dad used to tell me? Assumptions make an ass out of you and me. And that's been this entire case. It's all built on assumptions and jumping to conclusions. Think about it. House repairs were paid for by Nate Paul. You know how sad this is? I had to come here on behalf of the Attorney General of the state of Texas and disprove their case because he had already been convicted in the press. And now we know. I had to prove it to young Drew Wicker. That young man believed, I heard a stray comment. And I jumped to a conclusion that the house repairs were paid for by Nate Paul. We all know now that was wrong. We all know now that was wrong, but that was in more than 100 articles across our country, smearing this man's name, smearing his wife's name, smearing a member of this body's name. And we all saw it when we put this young man under oath and showed him the documents. Guess what? Didn't happen. Wasn't true. And that is indicative of their entire case. We should not be in a position to where we have to come in here and prove our innocence, but we did. We did. The referral from the DA's office had nothing to do with banks. All of his top lieutenants had no idea there was a second referral. You know why they didn't know? Because the referral went directly to Mr. Kamek. They didn't know about the direct referral from the DA's office. And you remember Margaret Moore? She came in here and tried to pretend like she didn't know anything about it because she wasn't supervising her staff. Her staff knew all about it. Her top lieutenant knew all about it. They assumed the Kamek contract was never executed, but now we all have seen that Ken Paxton, in fact, signed that contract. They assumed that Laura Olson's job was not legitimate, but now we have seen her employment contract. We've seen her application. We've seen that she's still working for world-class properties and still doing real work. They assumed that Wicker, young man Wicker, delivered a secret package in the middle of the night in a dark alley. Never happened. But if you were to watch the news and read the newspaper, oh my goodness, that happened. Even a Texas Ranger, think about this for a minute. You have a guy 6'6", wears a hat, cloaked with the authority of the state, comes in here and says to these folks, I heard from 5 or 6 people that Drew Wicker delivered a secret package in the dark of night in an alleyway on behalf of Nate Paul. Totally false. When he was asked, who told you that? Ranger. I can't even give you one name who told me that. Totally false. I asked the young man directly, did you ever deliver anything at night? Did you ever deliver anything that had anything to do with public records? No. Never. Didn't happen. Look at the position these people had put this man in and his wife. Prove your innocence, Attorney General. You've been convicted in the press. Prove your innocence now. If it can happen to him, it can happen to anyone. Foreclosures were stopped. There was a press statement that multiple foreclosures were stopped because of some informal guidance. Now we know that's false too. Presumed false. And these people got up here and used words like conspiracy, crimes, bribery, all kinds of really loaded words, and all were false. And this young man, Vassar, who cried on the stand in front of all of you because he had been called a rogue employee, at the very time he was called a rogue employee, he was joking and laughing and poking fun and calling his new boss, Brent Webster, a jerk. But when he came in here at the urging of these people, he cried. He cried because he had been called a rogue employee. What is a rogue employee? A rogue employee is somebody that doesn't do what the boss says. You don't do what the boss says? Let me tell you something. When I was a captain in the United States Marine Corps, and my staff sergeant didn't do what I told him to do, he can register his disagreement, but when the rubber meets the road and I tell him, this is what we're going to do, he does it or he resigns. What he doesn't do, what he should not do, what he should never do is go behind my back, cook up bar complaints, cook up a bunch of foolishness and go to the authorities. That's not how it's supposed to work. This guy, Mr. Vassar came here, cried on the stand about being a rogue employee, but really the truth is at the same time he was called a rogue employee, he was laughing and joking about it. What foolishness is this? It's been 3 years since these so-called whistleblowers. Now think about what a whistleblower means. That means that you have to have evidence of a crime, and they admitted they had no evidence of a crime. And what have we heard from the FBI with regard to Attorney General Ken Paxton? Crickets. Nothing. Nothing. If you don't think that the Biden administration and its FBI and Department of Justice would not love to indict Ken Paxton, then you're not paying attention. They've done nothing. You know why they've done nothing? Because there's nothing to do. This man did his job, and he should still be doing his job. Staffers were not only wrong on their assumptions, they were wrong on the law. Can you believe that they didn't realize that the only person in that office that can actually have the authority to sign an outside counsel contract was Ken Paxton himself, and anybody else was designated? He's the only one that can do that. They didn't like that. This is a situation where the tail is wagging the dog. Imagine if one of your staff members at some point decided that, you know what, I don't think my boss has authority. I know more than the boss, so I'm going to be in charge now. That is not how it works. 4.2 million people decided who the Attorney General would be. They didn't elect Jeff Mateer, Ryan Vassar, Banger, none of those people. Those are political appointees serving at the pleasure of the Attorney General, just as every one of your staffs are as well. They even had the nerve to come here in front of you and say, well, I believed that when Ken Paxton was in Ohio doing his job and trying to put together a group of attorney generals in a case against Google, well, he's out of the state, now we're in charge. That is not how it works. That is not how it works. Let's cook up a bar complaint against Ken Paxton. Let's Let's allocate $50,000 to hire an outside lawyer by the name of Johnny Sutton without any approval or telling the boss. They figured out real quickly, once they talked to Maxwell, that, you know what, we don't have anything. We need to beef this up. We don't have anything. And even though it's been 3 years, they still don't have anything. And 17 lawyers over there working since May, $500 an hour for each of them. Hundreds of thousands of dollars wasted, taxpayer money wasted, and they still don't have anything. Now, how did this happen? Well, they made some assumptions, and then they figured out they had no evidence, and it was too late to turn back. Recall that one of the witnesses, Mr. Mateer, Mr. Bangert, said, well, once we went to the FBI, we were signing our death warrant. Rightly so. You go to the authorities with no evidence and accuse your boss of a crime, and there has been no crime, and there's been no evidence of any crime, and it's all a bunch of supposition and guesswork. Rightly so. And so they took a long walk on a short pier. The House managers did the same. The House managers did the same. They, in a 4-hour hearing, decided to impeach the Attorney General of the state of Texas, and then they spent months and months trying to collect evidence to support it, and they did not. They failed. And then the lobbyists got involved. The text of support. TLR, yeah, we were against Ken. We spent $6 million against Ken Paxton. We couldn't beat him at the ballot box. Maybe we can beat him. Maybe we can beat him in an impeachment trial. George P. Bush decided, let me re-up my law license because maybe I can be the Attorney General now. I couldn't beat him in a fair fight. Maybe I can beat him here. And every one of these so-called whistleblowers, which are nothing but disgruntled ex-staffers, they all hired the same lawyer who just happens to be in the Ashcroft law firm, who just happens to be a protege of the Bush regime. The Bush era ends today in the state of Texas. Have you ever met a lawyer that works for 3 years for free, who's a former U.S. attorney, who's doing legitimate work? Legitimate work? I want to focus the allegations, as best as I can tell, of what Nate Paul provided to our Attorney General are in 3 buckets: campaign donation, house renovations, and Olson job. Let's focus on the first one. The allegation is there was some sort of quid pro quo. You have to have a quid pro quo for bribery. They're throwing this word bribery around. That has a lot of meaning. In this case, it has none. And let's focus on the person who supposedly bribed our Attorney General. This pain in the butt. This described pain in the butt, Nate Paul. Entitled, insistent, overbearing, manipulative, pushy, threatening, presumptuous, brash, assertive, forceful, militant, but he really believed that he had been abused by the federal authorities. And let me ask you a question. Do we really believe that the federal authorities do not sometimes abuse people? Do we believe that? Do we believe that the FBI is always on the up and up? Do we really believe that the Department of Justice is always out to do the right thing? Or can we all agree that sometimes they pick and they choose who they go after? And when the federal government comes after you, you better buckle down. This guy thought he had been targeted by the FBI. And the only thing that this man did was, let's find out the truth. Let's see if that's really true. That's all he did. Because he knows a little bit about people coming after you with no evidence. He can identify with that. Heck, we see it here. The very reason I'm standing here. He was come after by a group of misinformed, ill-advised people with no evidence. That's what, now, do I know whether that search warrant was altered? We will never know. We'll never know. Nate Paul thought it was. We'll never know. And to suggest that the keys of the Attorney General's office were turned over to Nate Paul, look at his correspondence. He was madder than a hornet's nest with the Attorney General's office. You're not doing your job. You have a conflict of interest. You guys are negligent. You're grossly negligent. He was mad. He was pissed because the Attorney General's office would not do what he wanted them to do. He wanted them to investigate. If you look at the correspondence from Nate Paul, senators, and you compare it to what you just heard from Mr. Murr here, you're going to see two different stories. Nate Paul was very unhappy with the Attorney General's office. That does not sound like somebody who had the keys to the office. He kept accusing the Attorney General's office of not being neutral. He accused the Attorney General's office of having bias. He accused the Attorney General's office of being in the bag for the Mitty Foundation. He accused the Attorney General's office of employing people that were against his interests. It does not sound like somebody who's running the Attorney General's office. There was one person running the Attorney General's office, and that man is sitting right there, and that is the man that should be running the Attorney General's office at the end of this day. But I urge you to look at the correspondence and compare it with what you've heard, not only from these people, but in the media. Nate Paul was very, very upset and very, very unhappy with the Attorney General's office. So much so that he threatened to sue, that he sent a letter and said, hold all of your correspondence because I am going to sue you guys for your negligence, for your bias. When you look at the documents and you compare it to the arguments, you see a much different picture. Now, the allegation, the first bucket is a campaign donation of $25,000 made in October of 2018. Everything that you have heard in this case was in 2020. So think about that for a minute. Their entire case, a campaign donation, a bribe, if you will, 2 years prior. Complete ridiculousness, especially when you look at all the other people that Nate Paul gave money to, and especially when you look at the percentage just in the year 2018 of the donations received by Attorney General Ken Paxton. This man is a fundraiser. There is a reason that he raises money politically, because the people like what he does. The people like Ken Paxton. We know that a campaign donation as a basis for bribery is complete hogwash. Imagine if a campaign donation were considered to be a bribe 2 years before the acts complained of. Line up. We're going to be doing a lot of impeachments in the city of Austin. That bucket has no validity. That bucket is empty. And let's look at the buckets of what Ken Paxton supposedly did for Nate Paul: foreclosure guidance, CAMIC retention, public records, and Mitty intervention. But what you heard from the young man who spent more time with Ken Paxton than anybody, sometimes 24/7, 365 days a year, is there was never an agreement at all. He never agreed to do anything for Nate Paul and never got a darn thing from Nate Paul, with the exception of a lunch. A lunch. A lunch that was public, on a patio, for everybody to see. Most of the time, you would think when people are doing something untoward, they want to hide it. These were public lunches for everybody to see. And if a lunch is a bribe, then boy howdy, we got a problem here, do we not? That holds no water. Let's look at Article 1. It fails just in its language. These people don't even know the role of the Attorney General's office. It is not a public protector of charities. It's a protector of the public's interest in charities. And we know that previously, Greg Abbott, as the Attorney General, had sued the Mitty Foundation, as a long and sordid history. But it's not just a history of problems. There is a recent history, starting in 2019, and I urge you to look at the evidence, at the memo that was submitted, at the memo that every one of Ken Paxton's subordinates reviewed before they all signed off on the intervention. This was not Ken Paxton causing anybody to do anything. This was subordinates who reviewed the evidence provided and decided we need to intervene. And it goes on and on. People punching their spouse, people being indicted for this and that, all kinds of problems. And the most important problem, the thing I think that the subordinates were really concerned about, is this charity that was only worth $15 million total is investing $3 million into a speculative land deal. The bottom line is, and what's so ironic and what's so egregious is that every single person who signed off on the intervention in the first article of impeachment came here and testified that that's somehow wrong, but they were involved in it. Utter hypocrisy. They not only signed off on the intervention, which only lasted 3 months, but they also signed off on an investigation of the Mitty Foundation. That article fails, period. Did they prove anything beyond a reasonable doubt with regard to that article? The only thing that we've seen beyond a reasonable doubt in that article is the Mitty Foundation has major problems and that the AG's office intervened, and now the Mitty Foundation stands to make millions upon millions upon millions of dollars on their speculative investment. Man, I wish I could get an investment like that. $3 million investment, they stand to make almost $20 million. That hurts really good, doesn't it? So we know the intervention is hogwash. Let's go to the written legal opinions under 402, Article 2. Well, it fails on its face because there was no written legal opinion, period. You heard our Lieutenant Governor charge you and explain to you that they have to prove what is in the article. They cannot prove this article because there was never a written legal opinion, period. That article is over. But, it's over. You can see it. This is informal guidance. This is not a legal opinion, period. But let's go a little further. They tried to drag Senator Hughes into this foolishness and put his name in this article. For what reason, I don't know, and act like having a straw requester was somehow wrong. And we all know, the people that work in the state's business in this city know that straw requesters are common. Every one of the House Board of Managers has been a, quote, straw requester at one point or another. We know that. And to put that in a public article, to somehow besmirch Senator Hughes is foolishness. But what was in Ken Paxton's mind when he was looking for this informal guidance? Well, if we want to know, we can look at his text. His text sent directly to Mr. Bangert, who was working on the informal opinion. Look what he says. I think that it will impact people's lives in a good way if we do this right. Hundreds of people will be protected from harm and maybe devastation. These are real-time texts. This is not 3 years later with a bunch of cooked-up foolishness. This is the real-time thoughts of our Attorney General as to what he was thinking with regard to the informal guidance. And did you hear Drew Wicker? When he was asked about that, he said he knew a little bit about it. General Paxton says, we may prevent a grandmother from being thrown out of her home. And now they've turned this upside down. They've cooked it up and made it look somehow bad. And you know what's most ironic is the president of the time, at the time, Donald Trump, a month later issued the same guidance. And we know, of course, Nate Paul put his entities in bankruptcy and there was never any foreclosures anyway. This is what we have to do. We have to get up here and prove our innocence. How wrong is that? And did you hear the financial guy from the bank get up here and talk about they didn't lose a penny? That they did not only didn't lose a penny, they made a fortune. That bucket's empty. Let's talk about the abuse of the open records process. Well, we've seen that is bull. We've seen that the abuse of misuse of official information, that was bull. Remember what you heard, that there was a secret delivery in the dark of night and a sealed package with top secret information. The problem with all that was all that information had already been released. It was already public. It was already public. And then when young Drew was asked, did you checked out for the general a packet that had a CD in it? Was that what you gave to Nate Paul? No, not at all. Total baloney. Never delivered any open records to Nate Paul, never delivered anything secret. That bucket's empty. Article 5, the retention of Kamek. They say he was a prosecutor pro tem. Well, that crumbled on the stand, did it not? You have to vote on the language of the articles. That should be 30-0. There was never a prosecutor pro tem. Game over. But we still have to prove our innocence. So ridiculous. The office of the district attorney made a referral. Mindy Monford, I want you to please pay particular attention to her affidavit. She was one of the subordinates of the elected DA, and she made it very clear that it was her idea to do the referral. And you know what she said? I didn't think it was appropriate to send it to the Texas Rangers. I didn't think it was appropriate to send it to the FBI, so I referred it to the Attorney General's office. But guess what? It went to a Texas Ranger and a former U.S. attorney, and they didn't want to fool with it. That's what you call a punt. We don't want to do it, let's punt it. And then they tried to pretend like they weren't involved, even though Kamek didn't know how to do a grand jury subpoena, so he had to rely upon the DA's office to do it. They were intimately involved. They were actively involved. They were helping him get the subpoenas, and they never said, this is wrong. In fact, they thought, I'm glad you're doing it because I don't want to be investigating the people that I have to work with. And then when it was over, they tried to wash their hands of it all. With all due respect, typical politician. And then lied about it. Margaret Moore sent a letter that she made sure was in the press that she didn't have anything to do with this at all. We all know that's not true. And she didn't even mention that there had been a second referral that was referred directly from the DA's office directly to this young man, Brandon Kamek. And that's the reason he sent the subpoenas that the DA's office helped him to issue. And they want to blame that on Ken Paxton, who had no idea about it. Kamek admitted, I never told him what I was my idea to issue subpoenas, and I never told him who they were going to be issued to. And Ken Paxton could not figure out why the devil will Maxwell and Penley not do their jobs. Ken Paxton had a chance to investigate the feds. He wanted to investigate the feds. He wanted to, because he had seen how they operate, picking and choosing who they convict or who they charge, weaponizing the FBI, abusing their authority. He had an opportunity. He could not understand why his subordinates would not do their jobs. Instead of fighting about it, he got outside counsel. And this young man, Mr. Kamek, who had a signed contract from the Attorney General of the state of Texas, was dealing with somebody the Texas Ranger had decided in his mind on a Google search. Think about this. Imagine, I hope Dave Maxwell never Googles me. He had decided before he even looked at it that Nate Paul was a criminal. My God. If that's how criminal work is done, that your top cop in the AG's office, based on a Google search, decides somebody's a criminal, therefore I'm not going to investigate his allegation of wrongdoing of the feds, we got a problem. We got a problem. He decided on a Google search that he wasn't going to do a darn thing. He was never going to investigate his old outfit, the Texas Rangers. He was never going to do that. He's in the Hall of Fame, for God's sake. And Penley's not going to investigate the feds because that's where he spent most of his career. And Ken Paxton said, look, there's an allegation. Let's look into it. And the only thing he ever said was, just find the truth. So look at the points of view. You look through the prism. Ken Paxton's prism is sometimes the feds screw up. Kamek's point of view as a criminal defense lawyer is sometimes those who are making allegations are wrong and screw up. Maxwell and Penley, the feds never do anything wrong. The Texas Rangers never do anything wrong. And anybody that says they do, they're a criminal. God, that's fear. That's terrifying. That should terrify every one of you. And so he issued subpoenas, and he thought he was a special prosecutor. He was outside counsel, special prosecutor, whatever he was, he had the authority of the AG's office only to investigate. To investigate. And that's what the young man was doing. And he made it very clear in his testimony. He was young, inexperienced, sincere, and energetic. And he was asked point blank, did you think this was baseless? He said, heck no. I thought it was persuasive. I thought it was convincing. And I was excited to be involved in it. Because if what was being alleged were true, that would be a, quote, big deal. The only thing that Ken Paxton ever told that young man is seek the truth. That's what I suggest to you. Seek the truth. Nate Paul got nothing. Nothing. It's a darn shame that we have to come and prove that, but we did. And these whistleblowers, so-called whistleblowers, in order to be a whistleblower, let this sink in order to be a whistleblower, you have to have a good faith belief that a crime has occurred. In order to have a good faith belief that a crime has occurred, you have to have evidence. And you heard Mr. Vassar admit when he went to the FBI, he had none. He had some guesses, he had some maybes, he had none. And if these folks would have done their job, you wouldn't have had to spend the last 2 weeks of your time doing their job. And you can tell from the text. You can tell from the text of these so-called whistleblowers, which what they really are is disgruntled ex-staffers. They were combative. They were insubordinate. They called their brand new boss a joke. How long would somebody on your staff last if they were texting their colleagues calling you a joke? You would fire them on the spot. He is a joke. We all know that when you bring in a new chief of staff, when you have a disagreement with your chief of staff and you bring in somebody else, that chief of staff is going to make sure that she or he brings in their own people. That's the way it works in politics, political appointees. And when you come in and you talk to your subordinates and they say, I won't work with you, what happens then? They leave. Nobody was ever mistreated. Nobody was ever talked down to. They were treated with respect. That's not what Brent Webster, the new first assistant, got in return. What he got in return is screams, shouts, hollers, and talking behind his back and calling him a joke. And then they joked about being fired. They were so torn up that they were joking amongst themselves, calling themselves the Cool Kids Club. The investigative report, I encourage you to read it. It's very lengthy. It's very lengthy. That's Article 7. It is documented and detailed. It explains everything that happened. It's a full investigation, and it's pretty darn good. And it lays out in great detail the events, and it's been unrebutted. They had a chance to bring Brent Webster, who was one of the authors of that report, who made sure that everything was documented. It's lengthy. It has exhibit after exhibit. It demonstrates that they did, in fact, take the Attorney General's name off of the letterhead. It's there in black and white, the emails back and forth when they did that. It's in that report. Now they say the report is false. And they throw around bribery. We know why they included this, don't we? Because it captures headlines. It captures headlines. And you know why they mention Laura Olson, because it captures headlines. And they want to shame people. They want to shame people. They want to be morally superior to us all. There's no reason to have done that to this family. There's no reason to have done that to this family. This woman got a job. She got it on her own merit, and she continues to work even today. She's getting checks from her job here in Austin even today. She has an apartment. She pays for her own apartment. That bucket is empty. I'm not going to spend too much time on this, but let me say, I'm certainly not perfect, and I'm going to assume that all of you feel the same. Because we all have sinned and fallen short. The only person that cannot be forgiven is somebody who's so cynical that they don't ask for forgiveness. If this impeachment is based on a marital impropriety, then line up. Line up. We're going to be doing a lot of impeaching in this city. You should be ashamed of yourselves. Ashamed of yourselves. Bribery. They convinced Drew Wicker, based on a stray comment, that Nate Paul was paying for the renovations. It took me about 20 minutes to disprove it. They never asked for any of those documents. They never even asked. They never even talked to Kevin Wood, the contractor. They didn't even bother. They assumed it was true, and I had to come here on behalf of my client and disprove it. How wrong is that? And that was the most serious allegation. It wasn't just against the Attorney General of our state, but it was against a senator in our state. Did you see young Wicker's face on the stand when I disproved it? I had to disprove it even to the general's body man. And let me tell you, the press reports that again, I'm going to be lining up a lot of lawsuits because that is absolute defamation. Because now we all know it's absolutely untrue. And that was the entire basis of this case. Supposition, and it can happen to you. Not even going to go through it. No burner phones, no secret email address, no promise to help Nate, no agreement with Nate. Nothing. Nothing. You should be ashamed of what you've done here. We showed you the transaction from front to back. Now, there was some suggestion that, well, he decided to pay because he knew they went to the FBI. Total baloney. The documents show something completely different. I urge you to look at Mateer's text and look at the text to Chip Loper on the payment. Look at the USAA docs that show that he was fighting with his insurance company trying to get paid for these very renovations and repairs that we have in evidence now. Every bucket of what General Paxton supposedly received, every bucket of what Nate Paul supposedly received, empty. Empty. So what do they do now? Well, you settle a lawsuit. A lawsuit was brought against the Attorney General office, and you went to the legislature, which is what you're required to do to get it funded. And the reason we decided to settle it, the reason they were begging to settle the case is because they didn't know what the Supreme Court was going to do. And Ken Paxton delegated that to one of his subordinates and said, hey, settle it if you think it's appropriate. And that was put before the legislature, and the legislature says, no, we're not going to pay it. And they were begging. The very people that came here to testify were the very people begging to get paid. It makes me mad.
You have 10 minutes remaining in your time.
So the Hail Mary, that's Roger Staubach. Remember him? The Hail Mary is, well, let's just throw in a bunch of malarkey at the end. Conspiracy, although there's no agreement and no furtherance of a conspiracy. Misappropriation, never happened. Dereliction of duty. Boy, when you're accused as a Marine officer of being derelict of duty, that's bad. Let's throw it unfit for office, abuse of the public. There's no evidence to support any of the articles. That means there's no evidence to support any of these articles. These are thrown in later because as you deliberate, there's going to be somebody say, okay, you're right. There's no proof of that, but we got this article. We'll use this to get him. We got to get him. We got to get him. Don't do that. That's not based on evidence. And that ain't the way it works. Just throw it at the wall and hope something sticks. That ain't the way it works in court, and that should not be the way it works in a historic impeachment proceeding. It holds no water. So why are we here? We're here because Dade Phelan got his feelings hurt. He was so drunk handling the House business, knowing full well that they had no evidence to support an impeachment and they hadn't done their homework. When Ken Paxton says, hey man, you embarrassed the devil out of yourself, you should resign, they sped up the process and impeached this man. You've seen the video. It's all over the internet. You know, my favorite author said, justice limps along, but gets there all the same. We should have never had to do any of this because this case is a case about nothing. It's a case about nothing. And people are watching. It's not just these people. There are thousands upon thousands of people watching at home who will sit in judgment who have watched the evidence, who have been shown what has been alleged and what has actually been proven, and have seen that they don't match up. For me, as a son of a butcher and the son of a woman who worked in our high school cafeteria, who had just the gift from God to go to Texas A&M and then go into our United States Marine Corps, and then be able to become a lawyer, a member of the bar of our state, to be called to defend the sitting Attorney General of the state of Texas is a great honor. And it's a great honor to stand here in front of you. I know in the fiber of my being that all of this foolishness that they've accused this man of is false. But the only question I have in my mind is whether there is courage in this room, to vote the way you know the evidence requires. I think there is. I hope there is. I pray there is. I'm asking you to agree with the 4.2 million Texans who put this man in office as Attorney General, to put this man back to work and vote not guilty.
Morning. I had planned on 30 minutes, but I have 5. So I guess there really are no coincidences in Austin. It may or may not surprise you that I'm going to go in a different way from my colleague, Mr. Busby, who's a fine lawyer. But I'm not going to yell at you. I'm not going to scream at you. I'm not going to point my finger and shake my fist. I just think, first off, no offense, but you're politicians. Y'all can probably get that faux rage quicker than most mammals. It's a skill set you got. I'm not going to attack my colleagues on the other side. I don't think they are good lawyers. I think they are great lawyers. They are living legends. But here's the point about that. Mr. DeGuerin, it is DeGuerin, Mr. Hardin, Miss Epley, Mr. Donnelly, some of the greatest lawyers in Texas literally could not put together a cogent case that could convince anyone that these things occurred beyond a reasonable doubt. These aren't second chair misdemeanor prosecutors. They were the best of the best. They did the best they could, but the evidence simply wasn't there. And my friends on the committee, here's a pro tip. If you're doing this investigation that will literally cost millions and millions of dollars and take weeks and weeks out of our senators' lives, you know, one person you might have talked to, me. I've been representing Ken Paxton for 8 years. Do you think they could have called me and said, hey, Dan, we got a problem with Paxton. What about this dark night? What about this kitchen cabinets? What about this Brandon Kamek? I was literally, sorry, I said I wasn't going to scream. I was literally having lunch with Mr. Donnelly when this was going on. Do you think? before we wrote that check. He could have said, hey, Cogdell, buddy, let's talk. They didn't do that. I'm not the world's greatest lawyer, but I'm pretty easy to find. The fact that they wouldn't literally pick up the phone and call me, that's a clue that they were more invested in the conclusion that they wanted than they were invested into the investigation. How much time, Your Honor? 1.5 minutes. I would make a joke about my personal life, but I won't. Can I see the picture of Brandon Kamick? One of the things that's really harder than it looks when you are a criminal defense lawyer is to argue to a jury. I need the picture, not the statement. There we go. Thank you. And thank you, Eric, for everything. One of the things that's harder than it looks is trying to explain to a jury what reasonable doubt looks like. That, ladies and gentlemen, is what reasonable doubt looks like in this case.
1 minute left.
Mr. Kamick told you this wasn't a baseless investigation. This was a legitimate investigation. Look, I respect David Maxwell. I've known him for a long time. But with respect to that legacy, his milk carton has expired. It's over. When he gets up there and looks you in a straight face and says it's a crime to investigate whether or not something is a crime, come on. We were born at night, but not last night. That is dumber than a bucket of hair for a Texas Ranger to say it's a crime to investigate the legality of the search. By the way, that's how my friends Mr. DeGuerin and Mr. Harden and I make a living. It's not a crime. It's not. But Kamick said, not a crime, legitimate. I believed in it. I thought that was something there. Paxton never asked me to lie, cheat, or steal. And I was doing the best that I could. That is game, set, match. I think that's the phrase. I don't play tennis. It's game over. The whole case was around this illegal relationship with Mr. Paul and Mr. Wynn, who they didn't call, and my friend Ken Paxton.
Mr. Cogdell, you're going to have to wrap up. I'm sorry.
Let me just say this. It was an honor to be here. Never thought I would. Thank you. But this is not about me. It's not about Ken Paxton. It's about whether or not you have a reasonable doubt. I suspect he did some things that you probably didn't like. I get that. I understand that. But that's not the issue. The issue is whether the proof is there that is so convincing that it convinces you beyond a reasonable doubt the same standard of proof that's in a death penalty case. It's not. It's not. It's not. 2 words. 2 words. Not guilty. Thank you.
Mr. Myers, he went over about a minute, so I'll give you an additional minute. You have 51 minutes. Yes, would you remove your easels? And we're not going to take a long break. They have a chance to come right back up, but I will give you 5 minutes while they're taking down the stretch. But do not leave the chamber.
And also, Stacks over on Pills says, I want to hear more about the FBI corruption and who put them up to it. I also want to hear more about FBI corruption. Over on Rumble, everybody says it wasn't there. They had no evidence whatsoever. Each attorney has an hour, confusing but exciting. Then the jury will vote. They still have a little bit more time. Let's see. Thank you guys for being here. I don't think they're actually taking a break. I think it's just they're just getting ready for another argument, another closing argument, I believe. Let's see. Big Bad Black Conservative says each team gets an additional hour for closing. Very good. Also, it goes prosecution, defense, prosecution. So there's another hour, I suppose, of them attempting to make a connection between Paxton and Nate Paul. And we've seen what appears to be happening to Nate Paul. It's not really passing the smell test, what's happening to Nate Paul. So over on Pilled says, Fact Finder says, we know Biden's DOJ put them up to it. Same stupid SHIT as all, I don't know why I say this. Same stupid shit as all Trump's indictments. Yep. Mutineers should be sued for defamation. I think that there's a case there because they were ridiculous. They even, in my opinion, they perjured themselves on the stand. A boneless chicken said, did he swear? And over on the Rumble chat, Rob Maga says, F-bomb drowned. So I get F-bomb dropped. I need more coffee. But yes, apparently he said the F word. I missed that. Hello, Dondo. Dondo says, red ticker tape says, AG Paxton exonerated. Well, it's pretty clear he's been exonerated. Thank you so much, Dondo. That's obviously my opinion. The Senate has not voted yet. That's just my opinion. I guess I should clarify that. It's not so obvious that that's just my opinion. But that is my opinion. I think it's pretty clear to most people that there's nothing there at all. That's my opinion and what I believe will happen. But no, the Senate has not voted yet. We have one more hour of closing arguments from the prosecution, I believe. Nate didn't benefit at all. They have no case. Nate Paul lost a lot. And it looks to me as though Paxton was just looking into the complaints that Nate Paul asked to be looked into. So, no case. Because that's what the whole thing was. Oh, Paxton did all this to benefit Nate Paul. No. There's no evidence that it benefited Nate Paul in any way. Because it didn't, because it wasn't about benefiting Nate Paul other than seeing what was happening if the FBI warrants were lawful that were being used to search and seize property of his. Of course, General Paxton, the House was harping on General Paxton's distrust of law enforcement. Well, of course. Well, why do you think we voted for it? Why do y'all think we voted for AG Paxton? Right? If he wasn't talking to the people about exactly the things that we have concerns about when he was campaigning. And he went up against a Bush. You think Texans don't know about the Bushes? I mean, we know. Hello, we know. That was excellent. Did y'all hear when Busby said the Bush legacy ends today? That was excellent. I love Tony Busby for, I don't want to say for governor because Abbott's been doing good things. Every time Abbott starts doing good things, we want to defend him. But Tony Busby is really great. What do y'all think? Delmar Dance says, I'm late here. Love from North Carolina. Can't stand bullies. We are Americans. Where we go, on we go on. So you missed a very nice and powerful testimony from Tony Busby. It was a closing argument. Tony Busby, one of Paxton's defense attorneys. And I need a team with me because I keep forgetting to take these tickers down or to modify these tickers. Let me fix this too. I'm going to say TBTX predicts. Okay, that way y'all understand that's my prediction because I suppose I wasn't very clear about that. Predicts AG Paxton is exonerated. Yeah, I mean, it's not as if there's any evidence. So that's why I just put that he's exonerated. In my opinion, he's been exonerated. So you missed a great testimony from Tony Busby. He had a kind of like a superstar moment when he declared the Bush dynasty over today. And that was really cool. Everybody was like, yeah, everybody was like cheering and, pumping their arms and fists in the air. And everybody was like, MAGA. It's very MAGA. So he had a MAGA moment. That's what I should have said. in his slate gray silk suit that I love. Trump Rocker says, Texans know about the Bushes. I thought George P. Bush got the message when we voted for Ken Paxton overwhelmingly. Yeah. I think he did get the message, but this is still the administrative deep state lashing out to protect itself. Stax says, it's all about the land grabs now, from Ohio to Hawaii and back to Texas. You might be right, Stax. You really, COVID land grabs. Yeah. Yeah. I know, right? Nate lost out. How did he benefit, Stax? I don't know. I don't see any way that Nate benefited at all. It looks like he lost everything. It looks like the people they alleged Paxton harmed, the Mitty Foundation and the banks, it looks like none of them were harmed. They all benefited greatly. So that's crazy. Truitt said, he said bucket of hair. I also thought he dropped the F-bomb at first. Oh. It wasn't the F-bomb, guys. He just said very aggressively, bucket of hair. And that's something that we say, I don't know if that's just like a Texas thing. That's probably why I didn't register a curse word at all in my mind. But bucket of hair, yeah. I usually don't say bucket of hair. I usually will say that's dumb as a box of hair. I don't know why. A bucket of hair. I don't know why we're putting hair in boxes or buckets, but anyways. He said bucket of hair very aggressively, so that's probably why y'all thought you heard the F-bomb. Where's my coffee? All right. Absolutely, Donda says, hi, Sis, thank you for airing this for us. Absolutely. Trying to do a few things at once. Hope I'm doing all right. Trump Rocker says,
Waiting, we have one juror missing.
I agree.
Wait a moment.
Okay, we're about to come right back. We have one more hour of closing arguments from the House impeachment manager side, which is the prosecution. I believe that's who's up next. Big Bad Black Conservative will correct me in the Rumble chat if I'm incorrect. And if he has other context, he'll throw that out there. So if you're watching, please like and share this out. Feel free to comment, join the chat over on Rumble, or if you're watching on Foxhole or Pilled. If you're on YouTube, I don't mean to neglect you there, but I'm shadow banned heavily on YouTube. Let's see, do I have anything on YouTube? Yeah, I've got one person watching on YouTube. Thank you, Patriot. Thank you. Okay. Please like and share this out. And
Mr. Murr, we did add a minute to your time because they went a minute over. So you have 51 minutes and a few seconds.
Wyatt Dirt back at the mic.
Thank you, Mr. President. When I gave the opening statement on behalf of the House managers, we told you that we wanted you to hear from the witnesses and see the documents. And so we're going to continue to do this. On your screen, we're going to start with Article 1. Now, we don't have enough time to go through every piece of paper that was introduced at trial and every word that was uttered under oath. But we suggest that you look at these key exhibits related to Article 1. To summarize, the Texas Attorney General wields astonishing power and is required to use that power to protect charities. In fact, the Fifth Circuit Court of Appeals has called it the public protector of charities. But instead of protecting the Mitty Foundation, Paxton forced his office into the Mitty lawsuit over the objections of the Charitable Trust Division solely to help Nate Paul and his companies. Mr. Paxton's obsession with helping Nate Paul manifested itself in the Mitty litigation when he demanded his deputies try to halt the lawsuit and force the charity to accept Mr. Paul's lowball settlement offer. Mr. Paxton claimed that the office needed to intervene to save the Mitty Foundation from excessive attorney's fees. But in reality, his actions harmed the charity by causing it to respond to frivolous motions and demands. Instead of protecting charities, Mr. Paxton harmed the Mitty Foundation only because he wanted to help Nate Paul. Now, in addition to exhibits, you heard testimony proving
Committee foundation.
evidence in Article 1. Here's just one of the highlights from Mr. Bangert.
He directed us to intervene. It was clear to me the intervention would benefit world-class holdings in Nepal.
Article 2. Same thing.
It was
Trying to be compressed on time, but I want to give you a highlight of some of the exhibits that we want to direct you to. You can write these down and look at them later during deliberations. To summarize, Mr. Paxton abused his office, forcing his employees to draft the midnight opinion to help Nate Paul avoid impending foreclosure sales. He became involved in the drafting of an opinion for the first time ever. He covered up his misdeeds by creating a straw requester, a Senate chairman, to hide the fact that he had no valid requester as required by Chapter 402 of the Government Code. The letter was clearly a 402 opinion, and the Office of Attorney General knew that. Why else go to all the trouble to find an authorized requester? It doesn't make sense. Even though the Attorney General's office had been promoted as Texas is open for business during COVID, and Governor Abbott's emergency COVID order had expressly permitted real estate transactions to continue without limitation, Mr. Paxton forced his employees to stop foreclosure sales based on the phony claim that COVID made these outdoor sales on the courthouse steps dangerous. To accomplish this purpose, he forced his employees to reverse their legal conclusions, and they told you that, so that Nate Paul could benefit from a legal opinion published at 1 o'clock on a Sunday morning. The very next day, Nate Paul attempted to use the opinion letter to halt foreclosures in his properties. On your screen is Exhibit 657. Articles 3 and 4. Same thing. We have listed some of the top exhibits that we suggest you look at when you deliberate. To summarize, Mr. Paxton does not dispute that the law enforcement exception is designed to protect victims, law enforcement, informants, and practices. It is also undisputed that Mr. Paxton directed his employees to act contrary to the law enforcement exception and release confidential information related to an ongoing investigation.
No, that was thoroughly debunked.
It is not a coincidence that Nate Paul had pending lawsuits concerning the open records request and the AG's no opinion, no position opinion endorsed disclosing sealed documents.
We shouldn't be surprised that they're going to continue to make these arguments.
It is not a coincidence that even though there are over 40,000 open records rulings each year, the Nate's request is the first and the only time that Mr. Paxton ever cared about anything in the open records division. Now, after his advisors warned him repeatedly not to release law enforcement records relating to an ongoing investigation, Mr. Paxton insisted that the office issued the no position letter. The House has also established that Mr. Paxton provided Nate Paul with confidential information.
To the public.
It would be impossible for Nate Paul to know the specific details of who signed the sealed probable cause affidavit in connection with the application for the search warrant without being improperly provided that information by Paxton. In May, Mr. Paxton obtained a copy of the DPS file. That information was in there. He had the file for 7 to 10 days. The DPS file was in a manila envelope. It was testified it was 1/4 inch or less in thickness. According to Mr. Wicker, in May or June of 2020, he handed off a manila envelope to Nate Paul at Nate Paul's office. In a meeting on August 5th, 2020, with Penley and Maxwell, Nate Paul and his lawyer presented a presentation titled Operation Longhorn, revealing that he knew the identity of the affiant and the probable cause affidavit that still remains sealed. There was also witness testimony explaining that Mr. Paxton asked that the information related to the ongoing law enforcement investigation be released. Listen to Mr.
All
Vassar.
of this was totally debunked. He knew the name
Was
of
there a
the
clear clash
investigator
here
because it was the guy who raided
between
his
what the
house.
judicial system had decided somebody that should be sealed versus a man under investigation seeking the sealed information?
Yes, that was my opinion.
And was the information he was seeking particularly harmful and dangerous to other people? If disclosed.
I believe so, to the extent it revealed the law enforcement information within the probable cause affidavit, the investigators that were involved, and other government officials that participated in the decision.
And still more.
What did the Attorney General say in this meeting?
He asked us to review the file. He asked us what our interpretation of the file was. He told us that he had spoken personally with Mr. Paul. He said that he believed that something bad had happened to Mr. Paul. He felt that Mr. Paul was being railroaded by the FBI and by DPS. And General Paxton said that he didn't trust law enforcement.
And it's obvious
He
now
asked
to us
us
that he
to
was
find a
being
way
railroaded.
to release the information that had been requested to be withheld.
So despite his staff telling him you can't release this type of information, despite Mr. Paxton's claim that the decision did not release any documents, the no position letter, that opinion, still created precedent that could help Nate Paul and could help others obtain confidential information. Listen to Mr. Banger about precedent.
If our office refuses to take a position on an issue like that and the court sees that, that is a strong signal, I believe, to the court. And I've been a lawyer for over a decade, probably close to two. That's a strong signal to the court about the Attorney General's view of that file, that we would have gone out of our way to render a vastly uncharacteristic decision.
Let's talk about Article 5. Here's a summary of some of the key exhibits that we direct you to in your deliberations. Highlights: Mr. Paxton secretly signed a contract to hire Brandon Kamak, a 5-year lawyer with no prosecutorial experience, to commence a criminal investigation into Nate Paul's enemies. Mr. Paxton hired Kamak September 4th, 2020, and unbeknownst to his deputies, fully executed the contract 3 weeks later on September 28th. Paxton alone supervised Kamak's work, in which Nate Paul and his attorney, Michael Wynn, directed. Paxton thought it would be a good idea for Kamak to obtain grand jury subpoenas that would have allowed Nate Paul to get the private email and telephone records of law enforcement agents who investigated Nate Paul, lenders, and opposing counsel. Now, pursuant to the Texas Code of Criminal Procedure, Article 20A, I ask you to write that down. Texas Code of Criminal Procedure, Article 20, big capital A. The ability to obtain grand jury subpoenas is a prosecutorial act. It is not a tool available to outside counsel hired by the Office of Attorney General who has not been appointed an attorney pro tem. Now, let's talk about what that is. An attorney pro tem is appointed when a DA recuses herself, and it is a formal process in which that district attorney goes to the court and asks for permission to be recused. Kamak was not an attorney pro tem, but Paxton still permitted Kamak to obtain grand jury subpoenas
for
just like he
investigating the
was.
deep state.
Thus, Paxton was illegally attempting to use Kamak as an attorney pro tem when under the law, which this legislature writes, says that cannot be. Paxton communicated with Kamak using only private encrypted communications like Signal and Proton Mail and extra phones. The two talked several times a week, and Kamak updated him about his work as a special prosecutor. Let's talk about that real quick. Even though Mr. Paxton called Kamak a special prosecutor, a term, special prosecutor, didn't exist. He clearly wasn't one. A special prosecutor is when a DA appoints someone to assist with their cases. And that person is not on the payroll of the district
kind of
attorney's
what happened,
office,
though. They asked
but
the
is
attorney general to
sworn
take
in
this one.
by the district attorney and becomes an assistant DA and a special prosecutor. The DA continues to supervise the handling of their case. Kamak was not sworn in and was not supervised by the Travis County District Attorney's Office. Let's listen to the testimony of former DA Margaret Moore.
The Travis County DA is kind of the problem, too, though.
Untruthful. There is no way that anyone could interpret the facts as my appointing Mr. Kamak as a special prosecutor. I couldn't pick him out of a lineup today. I don't know him.
But nobody's really alleging that.
Well, he wasn't a special prosecutor.
They're
and he
arguing
wasn't an
against
attorney
points
pro
that
tem.
nobody's taken.
Let's hear from
By
Mr.
that
Mattia.
time, the 29th, because the next day is when we go to the FBI and DOJ. By that time, I concluded that Mr. Paxton was engaged in conduct that was immoral, unethical, and I had a good faith belief that it was illegal.
This entire investigation by Mr. Kamak was illegal. Let's listen to Ranger Maxwell.
It was absolutely not illegal.
Now,
It was fully within the
would you
Attorney
agree
General's
with me,
power.
Ranger, that despite your concern or belief or hope that Mr. Wynn or Mr. Paul would say something incriminating or say something that would cause them exposure criminally, neither Mr. Wynn nor Mr. Paul ever asked you to do anything illegal?
Yes, they asked me to interfere with a federal investigation, which is absolutely illegal. It's also obstruction of justice.
Show me, Ranger, in the first hour or the second 2 hours on the investigation or the interview of July 21st or August 5th. You've got the transcript there for both of those.
Counselor, you are showing me the evidence right here. This is a map of how he wanted the investigation to be done and to have the AG's office follow how this was to be investigated, along with targeting 6 individuals.
Where they say you reviewed the transcripts of the July 12th interview and you have reviewed the transcripts of the August 5th interview. Show me the language where in either one of those interviews, Ranger, that they ask you to commit a crime.
They're not in the interviews, Counselor. They are in the document you're looking at right now. He lists 6 people as a person of interest to be targeted in this investigation.
Where does it ask?
It's an Operation Longhorn.
What crime is Mr. Wynn or Mr. Paul asking you to commit by tendering this PowerPoint to you?
They entered the PowerPoint and gave it to us to map out how they felt our investigation that they wanted to be created should go.
What crime is committed, Ranger, by them asking you to investigate the legality of a search warrant? What crime is that?
In my professional opinion, to create this investigation and follow through it would be obstruction of justice and interfering with a federal investigation.
And finally, I ask you also to recall testimony
And that
of
was
Mr.
a
McCarty.
ridiculous answer, but they're definitely trying to make a mockery of our
And,
entire state right now.
Did you learn or see subpoenas, the grand jury subpoenas that had been issued to players in the Mitty Foundation case?
I saw a criminal grand jury subpoena that had been issued to a bank.
What was your reaction to that?
I was stunned.
What do you mean? Explain it.
I saw a criminal grand jury subpoena directed to a bank that was clearly seeking information that would have aided world-class Nate Paul's efforts against the Mitty Foundation.
Why is that bad?
Well, it's one thing is it's lawyer ethics 101. So that was the first thing that came to my mind. We are weaponizing the criminal process to aid a civil litigant, and that is a big no-no.
Ethics 101. And Mr. Paxton has not disputed the testimony of Mr. McCarty. Now, Brent Webster, on behalf of Mr. Paxton, misled the Senate Finance Committee by stating that he had proof that Mr. Kamek was an attorney pro tem because he was allegedly being supervised by the Travis County DA's office. I remind you of this testimony. This is...
I want to talk about the appointment of special prosecutors, and I don't know if you or the general need to answer that. Is it rare for your office to appoint a special prosecutor?
So is this a general question about special prosecutors? Is that
just for the AG's office in general?
Okay.
Yeah,
I'm happy to address that. So
I would actually rather if General Paxton would address it, but if
he knows this like backwards and forwards. He was a prosecutor, so he knows this issue very well.
Well, I'm wondering who hired Brandon Kamak. Was that you?
So if I can address that.
Sure.
So our office entered into a contract for Brandon Kamak to be outside counsel. And so he was serving as outside counsel for the AG's office. Now, I have, through the process of, I started, as you know, in October after this happened, I have interviewed ADAs from Travis County, and I've seen documents from Travis County that prove the fact that the Travis County DA's office made Brandon Kamek a special prosecutor. We did not make Brandon Kamek a special prosecutor. That was within the purview of the Travis County DA's office. So the special prosecutor word gets confusing at times because there's two types. One type of special prosecutor is a pro tem prosecutor, and a pro tem prosecutor can only be put in place when a DA's office recuses themselves from a case. And that's not what happened with the Brandon Kamek situation. We hired him to be outside counsel. That contract was signed by the general. And then he went to go work because he was hired on to assist the Travis County DA's office. And the news glosses this over. No one ever goes and looks at the Travis County DA's office's files. They don't give really deep interviews on these things. But the fact is, he went and said, I'm the guy that's going to be the outside counsel for the AG's office, and I'm here to assist on your investigation. And then through that process, he worked with them to get grand jury subpoenas, and that's how he became a special prosecutor.
And I'm aware of the difference. I actually wrote the legislation that determined on pro tem who could actually be appointed. So yes, I'm familiar with it.
This body knows the law. On September 29th of 2020, Jeff Mateer was leading a Zoom meeting about opioid litigation when he received an urgent message that there was an emergency. Mateer knew that it was something important. He learned that an individual representing himself as a special prosecutor for the Office of the Attorney General and Nate Paul's personal attorney had served a grand jury subpoena on a bank seeking information relating to Nate Paul and his activities. This was a crisis moment. Mateer called Bangert, Brickman, and other deputies who were in meetings at the Capitol. They assembled, shared the grand jury subpoena from the bank, and they were stunned and outraged. They realized that Mr. Paxton was using criminal grand jury subpoenas to aid Nate Paul's civil lawsuit against the Mitty Foundation. In that room, Bangert, Mays, McCarty, Penley, Vassar, and Brickman for the first time started to share from their puzzle pieces what their office was doing to benefit Nate Paul, not realizing how it all connected. The puzzle pieces came together that day, and they realized they had a massive problem. Concerns of bribery were raised. Mr. Paxton had allowed Nate Paul to infect the office at the highest level. Despite all their efforts, Mr. Paxton's senior staff realized they could not stop him. They believed that he had committed crimes and abused his office, and that he had attempted to involve them. They knew they had no choice but to report them. Mr. Paxton's counsel has argued with each witness, save one, claiming that they should have spoken to Ken Paxton before they went to the FBI. However, this line of questioning ignored the months and months of warnings, conversations, and pleas from senior staff, imploring that Mr. Paxton stop asking his office to do work for Nate Paul. Here's a video.
We were protecting the interest of the state, and ultimately, I believe, protecting the interest of the Attorney General, and in my view, signing our professional death warrant at the same time.
Let's hear what Ranger Maxwell had to say.
I told him that Nate Paul was a criminal. He was running a Ponzi scheme that would rival Billy Saul Estes, and that if he didn't get away from this individual and stop doing what he was doing, he was going to get himself indicted.
And Mr. Mateer?
I felt like we had been trying to protect Mr. Paxton. On several occasions, I'd gone to him and really he had become, he was my boss. He'd become a friend. I cared for him. I cared for Senator Paxton. And I wanted him, I think in one of the memos I say, come clean. I wanted to help him.
And Mr. Penley?
I told him that I was trying to be a loyal subordinate and a friend, and I still considered myself a friend even up to that very day. And I was trying to walk him back from what I thought was a dangerous line he was trying to cross. And I told him all my reasons, that he could face criminal charges, bribery, other things. It could be a media scandal. He could get himself in a lot of trouble. He needed to leave this alone, to back away from it. I explained all the practical investigation difficulties, that we shouldn't be trying to investigate the feds. And there were many things we couldn't investigate. We didn't have the power. We didn't have a way to get at those sealed search warrants.
That's the testimony that you've heard during this trial. Now, Mr. Paxton's response was swift, vicious, and wrongful. He followed the classic playbook of guilty: deflect, deceive, and demonize. Articles 6, 7, 8, and 15 detail Mr. Paxton's attempts to misuse state resources to conceal his bad conduct by lying and smearing the otherwise stellar reputations of his loyal staff. Again, we list out some of the exhibits that we would direct you to during your deliberations. Please write them down if you can. He used state resources to issue an internal OAG report before this last election that contained blatantly false statements and personal smears against the whistleblowers. Let me remind you of what Mr. Brickman said.
In this report, if I asked you just to take three or four examples of things that you disagree with, have I asked you to do that?
Yes.
All right. What I wanted to ask you is, in this report, how would you describe your reaction to it as accuracy in terms of what happened in these matters involving Nate Paul?
I would call this report a whitewash full of lies.
Now, if I may, let's just go over to page 5 and do this real quickly. If I ask you to pick 4 or 5 samples, can you just do that for me? And would you look on page 5 and see as to the first claim? What is untrue about that claim?
It says, on 2 prior occasions involving Nate Paul's interests, the Open Records Division sided with the government agency against disclosing to Nate Paul. That is not true. There was an Open Records decision that took no opinion as to the release of the documents.
Oh, this number 2 here, where it says A.G. Paxton's involvement is consistent with his predecessors and in line with his required duties and legal obligations as Attorney General of Texas. Most relevant here, The position taken by the AG in this litigation was adverse to Nate Paul and in support of a higher settlement amount to be paid by Nate Paul to the Mitty Foundation, as opposed to the prospect of continued and costly litigation that would disproportionately benefit the charity's court-appointed receiver and his lawyer. All right, the third claim. This informal guidance letter regarding foreclosure sales written by Bangert was made in response to requests for disaster counsel advice from Texas Senator Brian Hughes during the height of the pandemic and not for the benefit of Nate Paul. Is that a true or untrue statement? Is that a true or untrue statement?
It is an untrue statement. The foreclosure opinion was for Nate Paul's benefit.
Can we go to page 6, please? Look at the top.
Wrong. That was the opinion of the governor and the president.
Legally and properly exercised authority delegated to him by both AG Paxton and the TCDAO. Kamek was designated as outside counsel for OAG by AG Paxton, and he was also knowingly appointed as a special prosecutor by the Travis County DA's office. Is that a true or untrue statement?
It is false.
Mr. Paxton did not examine or cross-examine a single thing said by Blake Brickman. Every word he said is unrefuted. Let's look at a quick timeline. I want to remind you that the whistleblowers were all constructively terminated within 45 days of making their report to the Trump FBI.
No, most
Mr.
of them
Paxton
resigned.
last attempted to silence those whistleblowers with his request to the taxpayers that the taxpayers pay $3.3 million in hush money. Even when he was specifically asked to justify the use of the money, he declined and refused. And that is why we are here. Mr. Paxton refuses to take any responsibility for abusing the esteemed office that he holds. Let's look at Articles 9 and 10. In exchange for abusing his office to help Nate Paul, Mr. Paxton reaped tangible benefits. What we know is that Nate Paul gave Mr. Paxton's mistress a job so that she could move from San Antonio to Austin to be closer.
That is
provided
not a
free
tangible
Uber
benefit.
rides to her apartment. And Nate Paul provided renovations, free renovations to Mr. Paxton's Austin home until he was caught. And I'll show you that in just a minute.
They never established
Look at this
that.
next chart.
What?
It has a lot of data on it, but just look at the colors for me. This chart is a demonstrative based on Exhibit 700. Exhibit 700. Marked in orange are trips to and from Ms. Olson's residence, which is shown as Exhibit 699. Marked in blue are trips to Nate Paul's residence. Exhibit 700 shows that Nate Paul set up an Uber account for Dave P. The account facilitated a covert means for Paxton to maintain his affair. The ride chart in this exhibit contains the latitude and longitude for each pickup and drop-off for Dave P. Focus on the rides between July 30th,
I don't think they ever
2020
established any of this.
and October 2nd, 2020, when the ride suddenly stopped. October 2nd. Next, I show you this Uber exhibit also shows that the rides are paid for with a credit card linked to Nate Paul's billing address in Austin and not Ken Paxton's in Collin County. Not Ken Paxton's in Collin County. Next, I show you Exhibit 699, which shows that Laura Olson was hired by World Class Property Company July 6th, 2020, and reports to Nate Paul. Let's talk about a timeline that's really important. You've seen a lot of documents, but let's take a moment. I want to show you this timeline. It's important. This shows when Paxton found out about the whistleblower report to the FBI and the actions that he took immediately after that. Now, Penley emails Kamek to tell him to cease and desist at 9:18 on September 30th, 9:18 in the morning. At 10:35 that morning, Kamek forwards the email to Paxton's Proton mail address. Kamek relentlessly calls Paxton that morning as well. Only 4 hours later, Paxton decides to pay the Cupertino builders for renovation work completed in July. Completed in July, but we're paying them now, September 30th. He returns to Austin and arrives at the airport at 10 p.m. At 10:57 p.m., Dave P. takes an Uber to Nate Paul's house. Dave P. was picked up 1 block from Paxton's residence. The next day, October 1st, that was the 30th. The next day, October 1st, Cupertino Builders creates an invoice for Paxton at 7:50 p.m. The records show that this invoice was never sent to Mr. Paxton. That night, October 1st, Dave P. takes his last ride to the Pearl Lantana Apartments, where Laura Olson lives.
Whoa, are they doxing her?
We tried to call her as a witness.
I
The
don't
court
even think
announced
that
that she was
any
present
of
but
this was
unavailable
entered
to
in as
testify.
evidence. Was this entered in as evidence, guys?
Next,
I must have
this is
missed
an invoice
this.
from Nate Paul's guy, Raj.
I don't know how any of this has been confirmed.
Never sent to Paxton. He created it after it was due, and the metadata tells us so. The metadata tells us it was created on October 1, yet Mr. Paxton decided to make payment on
That
September
is so
30th
rich
for work
because
that had
that's
been
what
completed
Paxton
in
was
July.
investigating the FBI for doing, was creating the warrants after they conducted the raids or modifying them after. That is so rich that they're going to accuse Paxton
This is
of
Exhibit
that.
703.
Total projection. I don't know how any
These
of
are
this stuff has been
emails.
confirmed.
Why does Nate Paul need to know the schedule for the renovations at the Paxton's home in Austin? Why does Nate Paul need 20 photos of the new flooring in the Paxton's home in Austin?
They never talked about the Uber
Mr.
rides in the
Wicker
trial. What is he even
testified that he
talking
heard
about?
Kevin Wood tell Mr. Paxton, "I will have to check with Nate," at least 3 times. Kevin Wood, who avoided being served multiple times with subpoenas in this matter. There are no coincidences in Austin. Nate Paul was paying for these home renovations until it all got found out.
There's no evidence of
Articles
that at
16 through 20.
all. That he was paying for his home renovation.
They charged that Mr. Paxton and Nate Paul's scheme to use the powers of the Office of Attorney General constituted dereliction of duty, made him unfit for office, and abused the public trust. These articles ask the Senate to do exactly what Mr. Paxton's counsel is begging you not to do, to look at the entirety of Mr. Paxton's conduct. And when the Senate does so, there is no reasonable doubt that Mr. Paxton committed the acts set forth in these articles, and that these acts were an abuse of office and a breach of public trust. The witnesses have explained to you that Mr. Paxton conspired with Nate Paul and others to harass and intimidate their perceived enemies. While Mr. Paxton's attorney suggests that there must be some type of overtly stated agreement if people are going to conspire, he also knows there are no coincidences in Austin. Mr. Paxton was using an inordinate amount of the OAG's resources for Nate Paul. Listen in.
Well, when the Attorney General kept raising Nate Paul issues of the ones that we've gone through so far and later in the future, do you have any idea how much time or resources that were devoted to dealing with Nate Paul instead of real concerns?
We were devoting far more resources to Nate Paul than we ever should have, given the importance of those issues.
The burden of proof in this case is beyond a reasonable doubt. What does that mean? It means exactly what the words say. Is there doubt? And is it reasonable? Even though this isn't a criminal trial, every day in this country, criminal defendants are convicted of crimes beyond a reasonable doubt with much less evidence than you have seen in this trial. We admitted over 3,000 pages of documents and 7 days worth of testimony, and that will all be accessible to you in your deliberations. When we first started our case, it might have been unclear what all the evidence was. And that doubt was reasonable since Mr. Paxton was presumed innocent. But as more evidence came in, the picture became clearer and the doubt faded. The puzzle pieces came together. The law does not require that we exclude all doubt. When we have shown you enough evidence that you can see what the puzzle is showing, that you know what the picture is, then we have met our burden. Now, Mr. Paxton's counsel would urge you that we have to put every piece in the puzzle there for it to be a picture, but that is not what our burden is. The burden is satisfied.
Because you don't have any pieces at all.
Is it a
Just playing
coincidence
charades.
that Paxton ordered his people to intervene in the Mitty lawsuit when they had already waived intervention? Is it a coincidence that Nate Paul used the midnight opinion to stop a foreclosure sale one day after the opinion was issued? Is it a coincidence that while discussing the Paxton home renovations, Mr. Paxton's contractor told him at least 3 times, "I will have to check with Nate"? Is it a coincidence that Nate Paul gave Ken Paxton's mistress, Laura Olson, a job while Mr. Paxton was doing Nate's bidding? Is it a coincidence that within 45 days of reporting to the Trump FBI, every whistleblower was terminated or constructively discharged? My counsel talked about $25,000 campaign contribution from Nate Paul in 2018. And he told you that Mr. Paxton is a fundraising machine. Well, in our world, that is a good campaign donor. That is a donor that you have a race. The next year you pick up the phone and you call. There should be a campaign donation in 2019. Where is that? There should be a campaign donation in 2020. That is a good donor.
Oh my gosh, look at him.
Is it a coincidence that there is
Maybe
no
the
longer
same reason
campaign
Nate Paul couldn't
contributions?
afford all of his mortgages because COVID lockdowns?
There are no
froze everybody's funds.
coincidences in Austin. Members of the jury, this is the most important choice you have ever faced. In 100 years, it's probably the only vote that anyone will ever talk about in your careers. It will also decide
That
what
is
Texas politics
so
look like.
condescending and
Not
demeaning
just
of
to the
him to
way
say.
cynical people
So
outside this
disrespectful
chamber
to say.
think, but this is about what does public service mean? Public service. To Mr. Paxton, it meant serving himself and his friend Nate Paul. Mr. Paul brought incredible wealth and a lavish lifestyle to the partnership. And Mr. Paxton brought the incredible power of the state. And the defense here isn't that he didn't do it. It's that it doesn't matter because he won the election. You know, Mr. Kinghorn summed it up in his testimony yesterday. The office of the Attorney General of the state of Texas is Mr. Paxton's law firm, and he is the firm's only client. He directs it to serve himself, not the people of Texas. If you vote to condone that, then high office will simply be the most profitable choice for any self-serving crook, and it won't even have to be hidden. You're here despite political pressure because you believe that public service is a calling that you put people first. You have everything in common with the whistleblowers, each a faithful servant who has spent years fighting for their values with great integrity. Look at what Mr. Paxton did to them. Think of Ranger Maxwell. In September of 2020, he was a Hall of Fame hero with 40 years of experience, a man of honor above reproach. 1 month later, that lifetime of service meant nothing.
Above reproach?
When he was an obstacle to Mr. Paxton, he was suddenly a liar, a rogue, a liability that had to be fired.
No, he's just become part of the ship.
We say we back the blue in this building, but Mr. Paxton tossed him out with the others like the garbage. If you don't hold Mr. Paxton accountable, that could happen to any of us. Your entire legacy could be erased and rewritten on the whim of whoever wins the next election. That is a godless, rudderless morality, and it cannot be the new normal for Texas. We must have a shared standard of integrity, honesty, and service that transcends any election. Your vote will set that standard.
Mr. Mayor, you have 10 minutes left.
At the beginning of trial, we watched all of you place your hand on Sam Houston's Bible and take your oath. Sam Houston's Bible. At that time, I reminded you that Sam Houston told Texans, do right and risk the consequences. Now is your time to do right. Mr. President.
Mr. Leach, you have about 9 minutes.
That was amazing how they tried to enter in evidence that was never established in the actual prosecution.
Thank you, Lieutenant Governor,
They didn't
distinguished
talk about
members
the
of the
override
Senate,
bill.
my fellow House members, General Paxton, and to the people of Texas. Let's be very clear. None of us want to be here today. I don't, and I'm confident that you don't either. But here we are with a heavy and historic moment in front of us. I stand before you today humbly on behalf of the House Board of Managers to offer a few brief closing remarks. These remarks have not been reviewed by anyone. I didn't go to dinner with TLR last night. George P. Bush didn't have his speechwriter draft this for me. Karl Rove's not sitting in my office right now. This is me, and me alone. 10 days ago, as these proceedings commenced, I watched each of you, I sat right over here, and I watched each of you, senators, place your hand one by one on Sam Houston's Bible, swearing to impartially render a verdict based on the law and the evidence. And as Chairman Murr has just articulately outlined for you, the House Board of Managers believe that that evidence meets the high standard of beyond a reasonable doubt. And as strong as we believe the evidence to be, make no mistake, this is not an easy vote for you. It's not. It shouldn't be, and I trust that it's not. It wasn't for me. This will, if you're like me, be the hardest vote, the most difficult vote, the heaviest vote that you will ever cast in your time in the legislature. This proceeding, we've had a lot of discussion about whether this proceeding is civil or criminal in nature, and as we've learned, it's been a unique mix of both. But it's also very personal. The vote that each of you will cast, I should say the 16 votes that each of you will cast, will be very personal, and they should be. We should treat the heaviness and the historic nature of this moment with the weight that it deserves. Members, senators, I certainly have done so. In voting to impeach General Ken Paxton, my dear friend, a political mentor, a brother in Christ, and a once trusted advisor, this has not just been a hard vote, this has been one of the most difficult things I've ever had to do in my life. Mr. Busby, you said in your closing that we're here because we hate Ken Paxton, and you could not be more wrong. I have loved Ken Paxton for a long time. I've done life with Ken Paxton. We've traveled together, attend church together, attended countless Cowboys and Baylor football games together. Heck, we're both former Baylor student body presidents.
You have 5 minutes.
I've block walked for Ken. I've donated to Ken, supported Ken. I've asked others to do the same. The first bill that I ever passed in the legislature in 2013, the only bill I passed that session, was sponsored by then Senator Ken Paxton.
which is one of the reasons that this is so difficult for me and many of our House members, and I know for many of you, it will be as well. Over the years, Ken and I have spent hours on the phone together. We've texted, we've called. For the first years after he was elected Attorney General and when he took office, I had an open door to the Attorney General's office. I could go up to the 8th floor anytime and visit with my friend. We talked politics and policy. We talked life. Members, I know as I look across this floor, many of you had the same. But a few years ago, those calls stopped and that open door was closed. And I became increasingly concerned and alarmed at what I saw.
Your Honor, he's testifying, and this is not proper. This is not based on any evidence in this case. It's improper.
Mr. Busby, this is closing argument.
I understand what it is, but I'm just saying he's talking about personal things that were not put into evidence.
Mr. Busby and Mr. Leach, the jury will decide what is evidence. Okay.
Thank you, Lieutenant Governor. Members, senators.
It's disgusting.
This has been, the point is, I know it's not lost on you, senators. This is difficult for me. It's been difficult for many of us, and I know it will be difficult for you, and it should be. While the law and the evidence is clear, this is a personal vote for you, and it should be. But make no mistake, we shouldn't have to be here. I, like many of you, in response to those concerns, attempted to get answers, to have conversations, to schedule meetings. I called General Paxton in front of our committee 12 times this session, and not once did he appear in front of our committee for answers. And with all due respect to my friend, Mr. Cogdell, we do not, as legislators, have to go through private counsel to have access to a statewide official. Senator Huffman, if you wanted to meet and have Comptroller Hager come in front of your committee, you don't have to go to his private counsel. Senator Creighton, you don't have to contact Mike Marath's private lawyer for him to come in front of your committee. Not once did he come answer questions in public or in private, which is largely one of the reasons that we're here today, because the people of Texas deserve answers, and the legislature, the Senate and the House expected to get those answers. Members, in closing, I see some of the whistleblowers are here in the gallery this morning. These are men and women of high esteem, character, conservative to the core. And you courageously spoke out, knowing the consequences and taking the risk, much like all of us have had to do and will have to do with this vote. I want you to know that the House has seen you and heard you. Mr. Maxwell, I see you. You deserve more than to be ridiculed and mocked on the floor of the Texas Senate. We hear you and we see you. The House has, and I'm confident that the Senate will as well. In closing, one of my favorite quotes is a quote of Martin Luther King. He says that, quote, cowardice asks the question, is it safe? Expedience asks the question, is it politic? And vanity asks the question, is it popular? But conscience
black
asks the
conservative
question,
over on Rumble.
is it
I
right?
believe now you
And there
are
comes
right.
a time for each of us. There will come a time for you. I believe this is it. Not to ask yourself what is safe or popular or politic, but what
nobody
is
would have a
right.
chance to refute. Totally.
And I believe that it is right,
on the House
as
impeachment
painful as it might be, for us and for you to vote to sustain the articles of impeachment commended to you by the Texas House of Representatives. It's an honor to serve with each of you. I pray God's grace and favor and his wisdom and discernment over you as you deliberate and vote on this historic matter. May God bless you, senators, and may God bless the people of Texas. Thank you.
Thank you, Mr. Leach. Thank you, councilors from both sides. Under the rules passed by the Senate, written and passed by the Senate 25-3, Rule 27 says that I shall give you the following instruction to the Senate jurors before deliberations begin.
Now they will deliberate, and then after that,
And
they
as
will
a
vote on the
reminder
floor.
to everyone who may have tuned in late, we have no idea how long deliberations will take, but we will try to notify you once every member has decided they are ready to come to the floor and vote. And we will alert the media, and we will put it up on the website 30 minutes or a little bit more so that you can be aware of when the senators will be back on the floor to vote individually on all 16 articles. These are the instructions as you have written. Sustaining an article of impeachment means that the impeached officer is removed from office for the term the officer was last elected. You are instructed that the rules adopted by the Court of Impeachment establish that the burden of proof rests on the House Board of Managers to prove an article of impeachment beyond a reasonable doubt. You are to determine if the allegation in each article presented to you has been proven beyond a reasonable doubt. And if so, shall the article of impeachment be sustained, which would result in removal from office? The final question to be put to you after each article is, shall this article of impeachment be sustained? Members, we will adjourn for this day very shortly. You will go to deliberate. I want to repeat that if the deliberations last until the night, when you leave here, you're not to talk to anyone about this trial. You're not to talk or watch anything on television about this trial. Go online and surf any news. You have serious work to do. And I believe that you will do it in a serious and responsible fashion. I'm going to order you to work to at least 8 tonight in deliberations. You can work longer if you wish. To be back here, if you have not come to a decision today on all 16 articles, to come back tomorrow morning at 9 a.m. and work until 8 tomorrow night. If a decision is still not reached, to be here at noon on Sunday. And if a decision is not reached by late Sunday night, I may take the option of sequestering you in the building. We all have slept overnight in our office once or twice. I know I have. Take as much time as you need to come to the decision that you believe is the right decision. God bless all of you. Thank you for your service to Texas. We stand adjourned until the members notify my office that they are ready to return and vote on all 16 articles.
Okay, everybody. Well, we saw Tony Busby gave a great closing argument, and House impeachment managers attempted to, because they quote unquote accidentally rested.
Members.
No.
Members. The clerk will pass out all the articles of impeachment to you as required, so you can take with you.
The House impeachment managers
Members retire to the deliberation room. No mingling on the floor with anyone except each other. It's time to retire from the Senate floor once you receive the articles, or they can be delivered back there as well.
Yeah, they're not allowed to talk to literally anyone but other senators right now. But it was totally disgusting how the House impeachment managers attempted to get evidence. They were testifying in their closing arguments, and they were giving evidence that was never discussed in the hearing. That was totally insane. Let's go. What's everybody on Rumble saying? Everyone on Rumble's saying, let's see. TXPC guy says that the House is abusing the justice system. Trump Broker said, that's not a closing argument. Nope. Trump Broker said, Leach's toast. Uniparty. People are saying, yep.
To the media and council, as appropriate, it will be time to clear this chamber, as this chamber will be closed until the jury returns.
Okay, so Dan Patrick's just told everybody to clear out. So let's see, over on Rumble, you guys are talking about, well, I'll just leave it here. I won't pop it out. Rhino, Trump Rocker says one of the PCs this week said Collin County reps were encouraging the senators to vote guilty. What? Collin County reps need to be primaried if that's the truth. Let's see if we can find any evidence of that or confirm that in any way. So conservative, they signed off on Hart. If Trump Rocker says they have no intention of restoring election integrity. Melindy says hypocritical scum. Excuse me. Yeah, they want on purpose everyone to hear prosecution evidence again. Well, that would be fine if they were just reviewing their evidence, but then they began to enter in evidence that nobody had heard before. All this Uber stuff, what was that? So Big Bad Black Conservative says it's now time to call your senators, blow up the phones. Yep, they're not allowed to talk to anybody right now except other senators. They're not allowed to talk to any of their staff, anybody at all, except other senators. Yeah, I mean, you guys can call, but they're not allowed to talk to anybody. Over on the pilled chat, it says, let's see. Thank you so much for the can. Thank you very much. Give me one moment. Thank you so much for the can. 123 SKG. Diddy, what's up? Sorry, but don't vote to impeach a friend. Straight snakes. Exactly. Like he says, oh, I love the Attorney General. I'm a friend. I consider him a friend. Yeah. I mean, with friends like that, who needs enemies, right? Fact Finder said they're all trannies. Why is this rep here on the Senate floor for this? Because he was part of the House impeachment team. Just one says, if it's so clear, why are you begging for an impeachment vote? Yeah, he was begging, right? It was a please just believe what I'm telling you type of thing. It wasn't a here's the evidence. That's why he said, our argument is not based on evidence. It's based on how you feel. They need 2/3 to convict, right? They need 21 yays to convict, and a conviction on just one article will have him impeached and removed from office. I hate that in court the prosecutor always gets to have the last word. I think that defense should get the last word. It's never have like that. Yeah, but in this case, the way that it played, I agree. Fact Finder says CNN will be in the deliberation room. No, they're not allowed to be in there. I don't think any media is allowed to be in there. But in this case, the prosecutor getting the last word, it really showed how dirty they are and how they were trying to enter in evidence that had never even been brought up in the hearing. The Uber stuff, we have no idea if any of that is real. We literally have no idea if any of that is real. Mark Steed says, how is the local media covering this? Well, I guess that depends on what you mean by local, because I'm based out of Tarrant County, Texas, and I consider myself local. But if by local you mean, let's see, this is over here on StreamYard. If by local you mean, the local CBS affiliates, they're not doing a great job covering it at all. They're leaning towards the impeachment narrative. That's what they're leaning towards, the impeachment narrative. But they're not going into any detail really on either side. They're just sort of leaning towards that. Very light coverage is how I would describe it. Oops. I accidentally opened a portal. Temporary portal. All right. Mark C just wondering, I'm in Washington State. Yeah, our local, I've accidentally opened a prayer portal, guys. Feel free to send your prayers. Let's see. Mimi Mitch said I contacted Springer yesterday also. That's good. That's good. At this point, they're not allowed to talk to anybody, actually, so. So what we can do you guys want to watch? Let's do this. I'm going to share this. And this is a recap from yesterday. Let's see. This is a recap of day 8. Okay, I'm going to put this up and then I'm going to press play and hope y'all enjoy this. Okay. The House impeachment managers were doing their prosecution, right?
Some
and
of
they
this is me from
accidentally
yesterday.
rested, and Busby immediately jumped on it. And it was definitely an accident. Tony Hardin accidentally rested his prosecution case. Now the defense is calling their witnesses. Both chances will have so here's the issue. When the House impeachment managers rested, it was a pretty big deal, and Busby motioned to force a vote on the basically the sufficiency of the evidence, saying that this is not anything. These are not impeachable offenses, and there's no evidence for anything that they're even alleging. That accidental rest and Busby filing that motion literally threw everything into chaos. Both of them reversed the motions that they made. So at this point, we'll see how this goes.
Could you please turn on your microphone and go ahead and adjust it pretty close? The acoustics in here can be a little difficult.
Is that okay?
Yes,
Thank
that's
you guys
much
for
better.
being here.
Could you please state your name for the court?
My name is Justin Gordon.
And where are you currently employed?
I'm employed in the Open Records Division of the Texas Attorney General's office.
And what is your position there?
I'm the Open Records Division Chief.
How long have you been the chief of the Open Records Division?
I began in 2015 at the beginning of General Paxton's term.
Good morning, Ms. Firecracker.
Excuse me. I think you're going to have to speak louder and a little closer. Okay.
I began in 2015, in January of 2015.
Says, good morning from North Carolina.
What does the Open Records Division do?
Our division handles a number of responsibilities regarding the Texas Public Information Act. That includes enforcement and review of public information decision requests. We also provide training for governmental bodies on the Public Information Act.
Okay, I'm going to ask you just to slow down a little bit while you're talking, okay, to help the court reporter out. Can you tell us how many public information ruling requests your division handles a year?
Last year we did over 40,000. In the previous fiscal year, we did just under 40,000.
And does your division maintain a record for each ruling request?
Yes, we maintain both an internal record of our ruling requests. We also post all of our letter rulings on our website after they are issued.
Do you recall a request for ruling from the Texas State Securities Board in the fall of 2019 for some records related to Nate Paul?
Yes.
Do you recall if any records were released as a result of that ruling request?
I do not believe any records were released in response to that ruling request.
Do you recall if there was a request for reconsideration of that ruling?
Yes, there was.
How frequently does the Open Records Division receive requests for reconsideration or complaints about a ruling?
That's very common. I don't have an exact number to provide you, but that's something that we see certainly on a monthly basis, if not weekly.
Were you also involved in deciding a request for ruling from DPS, the Department of Public Safety, in the spring of 2020, which we're going to call the big request for ease of reference? Do you recall that one?
Yes, I do.
This is the big request that Nate
was that
Paul put
also
in
related
for
to Nate Paul,
information.
if you recall?
It was.
At some point, as one of your duties, as part of your employment, did you make a summary of that file?
I did.
Your Honor, if I may approach the witness.
Yes, you may.
I'm going to approach with what is marked as AG.
Hold on one second. Yes, Senator Whitmire. Okay. Allison, you're going to have to speak louder as well.
Even louder. Okay.
That'll do it. That'll do it.
I'm going to approach with what has been marked as AG 205, and it has been pre-admitted.
Okay. Members, do you need for us to review with the court reporter what has already been said? You're okay? Everyone's okay? You do? Okay. Okay, so let's go back to where you began the question on DPS, Senator West. Securities. Okay. Let's start
No
over.
problem. Do you recall receiving a request for ruling from the Texas State Securities Board in fall of 2019 for some records related to Nate Paul?
Yes.
Do you recall if any records were released as a result of ORD's ruling?
No, I do not believe any records were released in that ruling.
Do you recall if there was a request for reconsideration of that ruling?
Yes, there was a request for reconsideration.
How frequently does ORD receive requests for reconsideration or complaints about a ruling?
That's very frequent. I don't have an exact number to provide to you, but it's something that we see, if not on a weekly basis, then certainly monthly, several times a month, we receive reconsiderations.
Do you also recall being involved with a request from DPS in the spring of 2020 related to Nate Paul?
Yes.
Now, we've been calling that the big request to help distinguish them. Will you understand what I'm saying if I call it the big request?
Yes.
Thank you. And at one point, as part of your employment, did you create a summary of this file?
Yes.
Your Honor, I'm going to approach the witness with what has already been admitted as AG 205. Mr. Gordon, do you recognize this document?
I do.
Is it a fair and accurate depiction of the summary that you created for this file?
Yes, it is the summary I provided for the file.
Well, let's talk about it. Let's walk through it together, okay?
Okay.
First, how would you describe this particular request, the big request?
It started off as what I would have characterized as a relatively routine request from the Department of Public Safety. Department of Public Safety routinely briefs our office on law enforcement matters. They, again, very commonly submit rulings to our office. However, as the ruling was being reviewed, it took a turn procedurally, and then there was a number of procedural irregularities that occurred with the file that made it unique.
And Eric, if you could please pull up AG Exhibit 205 and highlight the first paragraph, please. And Mr. Gordon, I think it's consistent with what you just said that there were procedural issues that made this file unique. Is that correct?
That's correct.
Okay, and when was the request received by your office?
On March 13th.
Okay, and at this point, this is when you're talking about it was very routine?
Correct.
Do you recall what exception DPS was asserting?
They sought to withhold the information under the law enforcement exception. That's Government Code Section 552.108.
Is that, there are generally two types of exceptions under the PIA, is that right?
That's correct. There are two, we characterize them as two separate types of exceptions. There's an exception for confidentiality provisions that we would also call mandatory exceptions. And there's a type of exception that is just a normal exception to disclosure that we would call a permissive exception to disclosure.
And which type is the law enforcement exception?
Section 552.108 is a permissive exception. The government body has the option to raise it or not to raise it.
What happens if they do not raise it?
Nothing happens if they do not raise it. We won't address it if they do not raise it.
So if they don't raise it and you don't address it, what's the end result as it relates to the request? Are those records released or are they withheld under the law enforcement exception?
Oh, they would be released. They would not be withheld under the law enforcement exception.
So let's talk about some of the procedural irregularities in this file. I'm now in the second paragraph, Eric, if you could blow that up for the senators. Where did this file first start to take a turn towards the unique?
Where you have it highlighted, I described that.
Excuse me one second. I'm very sorry. I'm very understanding with 8 grandchildren and a lot of little ones, but we really can't have a distraction. I'm sorry. Might have to step out. I really apologize, but I don't want to distract the jurors. Very sorry for that.
May we continue? Thank you. I believe you were about to point out to us where the procedural issues started to rise in this file.
Sure. So we have a statutory 45-day deadline by which we have to issue all of our rulings. That's from the government code. And as we were approaching that deadline, the DPS submitted a follow-up correspondence to our office explaining that the requested information may implicate the interest of the FBI. And at that time, they also submitted additional records. So in the initial submission, they only submitted a representative sample, which they are permitted to do. In
To
fact,
answer your question,
DPI requires them
we
to
are
do that
live
if the
again. We
records
were
are
recapping
voluminous,
this morning, but this
and they had
is
done that in the initial
current
submission.
day's impeachment proceedings.
However, when they submitted the subsequent submission, they submitted additional documents, not the same representative sample that they had submitted earlier. And the new documents were substantially different than the documents that had been originally submitted and were of a different character. So they
and I'm
had.
going to stop you. I think that's a great spot. And just to summarize, so essentially, the original representative sample that DPS sent in did not match with the sample that they later sent to your office in May of 2020. Is that right?
That's correct.
And they sent that second sample at the time that they were notifying the FBI that they might have an interest in the file, in the information being sought by the request?
That's correct.
Is that considered a procedural violation under the Public Information Act?
Yes, government bodies are required to submit all of the records that they want a ruling on or a proper representative sample by the 15th business day after receiving the request, which had been substantially before this time period.
Well.
So this sample was also late. Yes. Is that correct?
That's right. That's correct.
What
now is when
the
we get to see
for a procedural violation of this nature?
Perspective.
Under the Public Information Act, failure to comply with the procedural requirements in requesting decision from our office results in a presumption that the information is released unless the exception that they're raising constitutes a compelling exception. And our office has concluded that Section 552.108 does not constitute a compelling reason. That's a fancy way of saying that they waive that exception, and they would waive it for the information that they had the procedural violation on.
And that would be all the information that they provided as the second sample in May of 2020?
Correct. Anything in that representative sample, the second set of documents that was not in the first set.
And is it your understanding that that second set of documents had also been provided to the FBI?
Oh, I'm not sure if they provided that second set of documents to the FBI. I don't remember that.
Okay, so over on Rumble,
late,
we've got some
notice
questions.
To the FBI also late?
They both reversed the
government bodies.
The positions that they took yesterday,
and there are
the House
also
did
due
rest.
process requirements in the Public Information
But
Act.
the two motions
and because
that
of those
Busby
deadlines,
had, which was the directive verdict,
there are certain notice requirements.
that's been
so
rescinded.
The only notice
And the
requirements in the
House's
Act that applies to third parties
has
is in
also
Section
been rescinded.
552.305.
But the House did rest.
That section
That was an
requires
accident on their
government
part.
bodies to notify third parties if their privacy
So,
or proprietary interests are
directive
at issue,
verdict was
and that notice is
rescinded.
supposed to come within 10
And
days
that's why,
of receiving
they're
the
basically
request.
acting like yesterday did not happen,
Otherwise,
except for
there's also the
last
due
part,
process
except
element
for the
of
House did
that notice
rest.
needs to be made in time for those comments to be received by our office before, in time for us to be aware of them, and also in time for the requester to receive notice.
And in this instance, was the notice given close in time to your statutory deadline to issue a ruling?
Yes, we received it just a couple of weeks before our 10-day deadline or our 45-day
So to
deadline.
answer your questions over on Rumble, Trump Rocker,
The
did the vote even take
sample
place
of
by the senators, or are they just not saying what happened? The vote did not take place because the motion
how
for
were those
directed
provided
verdict
to
was
you?
rescinded by BuzzFeed. And the House
Hard
rescinded
copies
their
on a
motion as
CD,
well.
do you recall?
But the House did
I don't
rest.
recall.
So this is now the
If they were a
defense's team
CD or if they
to
were
make their
if they were a
case.
hard copy.
I hope that makes sense. But please, if you have
so
more
you sent
questions,
this,
go ahead
the
and leave them in
notice
the
went out to the FBI and you received a copy of it. What happens next?
So at that point, we were kind of up against it with respect to the timelines. You've got the highlights here with respect to the to kind of what was going on in this file. We had also been notified by the requester in this file that he had filed a lawsuit against DPS in this case, which added a whole nother layer of complexity to it. Because the late notice, because the notice was received so close up against our 45-day deadline, we didn't feel like the third party who was notified, FBI, would have had time to submit comments to our office in time. And so while we were waiting for those comments so that we could receive them and review them from the FBI, we took a 10-day extension on it, and again gave ourselves a 10-day extension, which is permitted under the PIA.
All right, I'm going to ask you just to slow down a little bit, okay? You're doing great. So you extend it for 10 more days. Does the FBI eventually provide your office with comments?
Yes.
And do you know if the FBI also provided the requester with a copy of those comments?
At the time, when we identified the documents, we actually only found the comments because the requester let us know that he had received comments, and so then we went and tracked them down. This is at the beginning of COVID, so our mail intake was kind of thrown off. So when the requester notified that we had received comments, we went and tracked those down. To add another procedural complication to it, at that time, the requester notified us that his copy of the comments had been completely redacted. Our copy did not have any redactions on it. It just had a reference that at the end that the version that had been provided to the requester was redacted.
In your honor, if I may approach with what's been marked as House Managers 46, but has not been admitted into evidence yet.
You may approach the witness.
Yes, guys. So I totally understand the confusion about what happened yesterday. So the House did rest. They were unable to take that back, but both parties did take back their other motions. So now it's just the defense's turn.
Mr. Gordon, do you recognize the document that I placed in front of you?
I do.
What is it?
This appears to be a copy of our internal ruling file pertaining to the DPS file that we've been discussing.
And does it appear to be a complete and accurate copy of the file?
Over on Pilled, we've got a question. Grain of salt. Would you please explain the time left Patrick announced when it started today? Yes, each side was given 24 hours to make their case, and it's up to them how they use that time.
Take your time.
Paxton was letting, not Paxton. We're all doing this. We keep implicating Lieutenant Governor Dan Patrick when we mean to say Paxton and vice versa. Patrick was just letting them know how much time they have left for both sides, because each side was given equal amount of time. I believe 24 hours was I think 24 hours plus a couple hours each for a few different items. They were given identical amounts of time, though it's up to them how they want to use it. So it looks as though, one side has used a little more time than the other, and that's totally fine and understandable and strategic. Any time left over, I mean, they'll be able to use their time whether or not one side uses all of it or not. So that's why they keep track of that every day, how much time is left. I hope that makes sense.
Yes, it does.
I appreciate your thoroughness.
To the
At
question
this
of how
time,
does
we've moved
somebody
to admit
accidentally
House
rest their case?
Managers 46.
Very simple, very quick.
Any objection?
It happens
Mr.
so
President,
fast.
no objection to the admission. However, in this document, it contains a copy of the unredacted FBI brief, which not only contains personal identifying information, but a number of sensitive information of the types of operations plans and other sensitive law enforcement information, which Nate Paul has been trying to get for a while. If it comes in, we just ask that it be redacted because that information has not been publicly made available.
And Your Honor, we'll get to that on the next request,
We actually
but I will
established
represent
that
to
that
this
was
court that that
your
is not the
agreement.
case. As has been discussed by other witnesses, this brief was in fact released publicly.
Okay, so they did not object, and I'll let her go along with her line of questioning, and we'll get back to that issue, but thank you for bringing it up. Go ahead.
Thank you. Eric, if you could pull up towards the back of that exhibit 46, the Bates number at the bottom is 8803.
Mr.
And
President, I do have to, I'm sorry, before this is shown to the jury, there is personal identifying information
and
that has
sir,
not, may I finish?
Stop not talking over each other.
That has not been released publicly. It may have been released to Nate Paul at General Paxton's direction. However, it has not been made public to the world at large.
Okay.
There's very sensitive law enforcement operation plans, details about search warrants, how investigations are done, and also specific names of individuals that are identified and involved.
Come on up to the bench. Please come up to the bench.
And a hat tip for his fashion. Remember that cornflower blue tie?
Proceed slowly, carefully. You may proceed.
thank you. Mr. Gordon, as a preliminary matter, if a document is released after a ruling request or a ruling decision, would that be released to a subsequent requester for that same information?
Objection calls for speculation.
Overruled.
Yes, there's a specific section that directly addresses that. Section 552.007 of the government code prohibits the governmental bodies from selectively releasing information and provides that if information has been released to one requester, that it would be released to a subsequent requester unless there's a special right of access that applied to the initial requester.
Absolutely. Which is exactly why we said that the argument that producing CVRs took too
Mr.
long
Gordon,
was a
repeat
silly
your
argument.
answer. Slow down.
Yes, sir. Yes, there is a specific section of the Public Information Act that addresses that. It is section 552.007. It provides that if information is released to one requester, then it would be released to a subsequent requester. It prohibits the selective release of information to one requester and not to another. So if information has been released by a governmental body, then it would be released to subsequent requesters unless there is a special right of access that only applied to the initial requester. For example, if I ask for my driver's license number and receive it, you wouldn't release my driver's license number to the next person because I have a right of access to that.
Thank you for that explanation.
Very interesting. So I have a right of access to my ballot.
Within House Managers 46.
Let's all request our ballots. We can only do that if we're aware of our ballot number.
Which is
So
page
make a note of your ballot
77
number,
within that
the
PDF.
entire number.
Mr. Gordon, can you see that on your screen?
Yes, I can.
Does this appear to be a fair and accurate picture of the redacted brief the FBI provided to Mr. Larson?
That's correct.
And Eric, if you could scroll to the next page, so to 78, go down. Is this showing an entirely redacted page?
Yes.
And does that continue through the majority of this brief?
Yes.
Is this unusual?
Yes.
Can you explain why?
Under the government code, if a third party submits comments to our office objecting to the release of information, they're required to notify the requester and provide the requester with a copy of those comments. They are permitted to redact the comments, but only to the extent that it reveals the information that is requested. In this case, they've redacted the entirety of the brief, including all of the substantive arguments.
And why does that matter?
That matters because the requester was not put on notice about what arguments the governmental body was making and would have been unable to respond to them to our office in order to refute any statements that were made or directly address the statements that were provided by the briefing third party.
Paxton's team
is
is
this
going to
another
destroy these
procedural
articles.
violation of the PIA?
Yes.
Guys,
so far
the PIA
we've
is
talked about
binding.
at least 3 procedural violations or irregularities with this file.
Objection
Yes.
leading.
Restate your question, sustain.
Can you estimate for us how many procedural irregularities we have discussed related to this
The
file
Public
so far?
Information Act, guys, is binding by 6 months
There
in
was
jail and a
the
$10,000 fine
failure to
if found
submit
to be in
the
violation of it.
representative sample, or they submitted the documents late. The representative sample that they submitted the second time was not indicated that the first representative sample was not actually representative. They did not notify the third party in a timely fashion. And then when the third party briefed us, they substantially redacted their briefing to us. Or I'm sorry, they substantially redacted the copy of the briefing that was provided to the requester.
Are you able to tell us how frequently you work on a file that has 4 different procedural irregularities?
We see a lot of procedural irregularities. These are pretty unique, though, in the way that they came in. Ordinarily, what we see are missed deadlines. So it would be pretty rare that we see 4 completely different procedural violations like this.
And again, what can be the consequence of a procedural irregularity of the nature you've been discussing?
If a governmental body fails to comply with the procedural requirements of the Act, then they would waive their discretionary exceptions.
Meaning that any documents that fell within a discretionary exception would be released.
Objection leading.
Sustain,
That's not
rephrase your
leading.
question.
She just had a question.
So what's the consequence of that, of the permissive exceptions being waived?
If a permissive exception is waived, then we would not apply it or review it in the context of those documents. And if that's the only exception that's addressed, then those documents would be released.
And in this particular file, the DPS file in front of you, was the only exception raised the law enforcement exception?
That's correct.
And it is a permissive exception?
That's correct. They did not raise any confidentiality provisions. They only raised the law enforcement exception.
Do you recall meeting with the Attorney General about this file?
Yes.
And I don't want you to go into what anyone said at that meeting, okay? But could you please tell us what topics were discussed?
We discussed this topic, this DPS file.
Did you discuss options for how to proceed?
Yes.
And what were those options?
The primary options were to release the information, to conclude that there had been a procedural violation and a failure to establish that the information was accepted from disclosure. And then the second exception, which was the primary option, was the closed letter that we ended up issuing.
Did you agree with issuing the closed letter?
Yes.
Why?
It was correct. The procedural background of the request put the requester at a significant disadvantage, and allowing the procedural actions that were taken would have really been a detriment to that requester. There was already a pending lawsuit, and courts will give our letter rulings great weight, and rubber stamping the actions in this procedural context would have, or could have, I don't know what the court would have done with our ruling, but it could have tilted the scale in favor of a governmental body who had failed to comply with the procedural requirements.
And I want to make sure I understood your testimony a moment
This
ago.
means that Paxton's
You
office was
considered
fighting
releasing all
for
of the
us,
information. What do you
good
call
guys,
that
not the
within
mutineers,
ORD?
not the
Pouring
whistleblowers.
out.
And would that have been supportable under the law, in your opinion?
It would have been pushing it. I agree with the closed letter. I feel like releasing it all would have been pushing it.
To your knowledge, had ORD issued closed letters of this nature in the past?
Yes.
Eric, I'm going to ask you to pull up the closed letter, which is within House Managers 46 at page 2, and please take it off the screen before finding the new page and placing it there.
Council, what was the page number that you directed him to, please?
It's page 2 of the PDF, which is in front of you.
That OAG 8728?
I don't have it in front of me, but it's the closed letter. Mr. Gordon, does this appear to be a complete and accurate copy of the closed letter?
Yes, it does.
And in that letter, you reference a prior ORD decision, right?
That's correct.
Why? Why did you reference that prior ORD decision?
Well, there were a lot of reasons. The primary reason is that what this open records decision specifies is that if a lawsuit is filed after a ruling request is made, I'm sorry, let me take it back and maybe simplify it. Under the Public Information Act, a requester can sue a governmental body if they believe they're improperly withholding documents. What this open records decision provides is that if a requester files a lawsuit after a governmental body has issued or has requested a decision from our office, then our office should still go on and issue a ruling. Prior to this decision, we routinely closed files and did not issue determinations where the issue that come before us in the decision was in court. So we would demur and close that letter and let the court decide.
And in your opinion, how did this DPS file differ from the closed letter that you issued in this case? How did that differ or was distinguished from that ORD decision?
It was all of the procedural irregularities, especially the redacted FBI brief. That was the primary issue that prevented us from ruling in accordance with due process. It was the heavily redacted FBI brief.
And why did that cause you so much heartburn?
Again, our rulings are given weight or great weight, quote unquote, by the courts. And in the face of those procedural irregularities, giving a rubber stamp of approval to them could have tilted the scales in that court, even despite the procedures being handled incorrectly.
Could it also set bad precedent?
Objection leading.
I'm asking his opinion, Your Honor. It's a yes or no. He can say what he'd like.
Overruled.
I'm sorry, I didn't understand. I didn't hear the question.
Sure. Could it also set bad precedent in PIA requests coming into your office?
Objection, Your Honor. The relevance of this personal witness's opinion is not relevant to any issue in this proceeding. And what he considers a good or bad precedent is purely subjective.
I think that we all agree that it is relevant.
Overruled.
Thank you, Dan Patrick.
I wouldn't characterize it as a precedent. So many of our rulings are fact specific. What I do think it could have resulted in, because DPS and FBI routinely brief our office, it could have again been seen as condoning that type of heavy redaction, which then could have led to that type of action being taken in future requests and for future requesters. Wouldn't have characterized it as a precedent, but it could have indicated that we thought that was okay, and then they would, because they do it routinely. I mean, they request decisions from us routinely. They could have seen that as oh well, now we've got the stamp of approval to do this, and now we'll keep doing it.
And now, while all of this is going on, Were you made aware of a request from Mr. Larson for a copy of the FBI brief?
Yes.
How were you made aware of that?
That came in as a Public Information Act request. The Public Information Act request was forwarded to my division for handling. And when I say handling, I mean we collected the documents. So we collected the unredacted brief in processing that Public Information Act request, and we provided it to our Public Information Office.
As to the DPS ruling itself, did that closed letter result in the release of any documents?
It did not.
Okay, so this request from Mr. Larson comes in for a copy of the brief. Do you know what happened after that was received?
I know what happened after the fact. Because it involved open records decision documents, our division does not rule on decision requests for our own documents, so it was handled by another division. But through the process of this whole circumstance, I did become aware of what issued or what happened with that public information request.
And your division maintains those files even if it doesn't necessarily make the decision on the request, correct?
That's correct. Because the FBI submitted the brief to our office, we were the ones who maintained that as part of our work file.
Have you reviewed the ORD file for the FBI brief request before?
So just to clarify, our office or my division does not have a file on that public information request. We have the file that's here before me as this PDF, and yes, I have reviewed that, but I have not seen the opinions file or the public information office file involving that ruling request for that brief.
Now, in the file in front of you, there is a copy of the unredacted FBI brief, correct?
That's correct.
Would you take a look at it, please?
Okay, I'm looking at page.
And what I want you to look for, you're the chief of ORD. I want you to set aside law enforcement exception for a moment. I want you to look at that brief and let me know if you think there are any mandatory exceptions to public disclosure that are flagged within that brief.
I want to say thanks to everybody on the Pilled and Foxhole chats for being here. Hello, Uncensored Abe. Hello, Stacks. Thank you for the shades. Thank you, Stacks, for the cookie. Welcome, Uncensored Abe. Diddy and I need to come on to your show and give a short rundown. Yep, give them an inch, they'll take a mile. I agree, Carrie Lake. Over on the Rumble chat, hello, Pappy Frost. Welcome. The Johnny Sutton issue, Pappy Frost, I agree with you. He said the Johnny Sutton issue is a big deal as there's no way he's doing this for free. Yes, guys, all of the whistleblowers, or as I refer to them, mutineers, are represented by the same attorney, Johnny Sutton, who has apparently agreed to work for them all for free and represent them for free and do a significant amount of work for them for free. I agree with you, Pappy Frost and PC Amani. That's a very big deal. We've got another comment saying the Bush family is paying Johnny Sutton, in my opinion. That could very well be. Texas is, and Batty Mom of 3, absolutely right. Texas is an at-will state and can fire with or without cause.
Not to nitpick, but there is a Mr. Larson's email address is at the end of the brief, but he was the requester. So no, but other than that, I don't see any confidential information on the face of the document.
Thank you. And just one more thing on, forgive me, Your Honor, if I may approach with what's been marked as AG 34.
You may.
I also find it extremely rich that Karen Epley, the DOJ and CIA's own, would object to questions about his opinion on a legal process when she was asking people about their opinion on granite countertops in Ken Paxton's home.
Mr. Gordon, do you recognize the document I placed in front of you?
I do.
And what is it?
This would appear to be the internal file for the opinions ruling request that we've been discussing. That was Mr. Larson's request for the unredacted FBI brief.
Thank you for the donation. Thank you for the can. Sly
Does
Park.
OAG receive
Welcome,
requests
Sly Park.
for copies of PIA briefing on other occasions?
Yes.
Does that occur with, can you tell us with any sort of frequency how often you receive that type of request for briefing?
If I had to guess, I'd say it would be once a month, probably less than once a month. It's not very common. It's not a weekly occurrence.
And were you familiar with Joe Larson?
Yes.
How?
I've worked with Joe Larson for a long time. He is a well-known open government lawyer. He's also involved with the Freedom of Information Foundation, which our office has partnered with in the past to perform trainings. He's routinely sought after to provide input on Public Information Act requests. I've also observed a number of cases that he's handled because he ends up often handling important Public Information Act cases. So I've known Mr. Larson for a long time.
Was, based on your knowledge of Mr. Larson and working with him, was it surprising or unusual for him to submit a request for a copy of that redacted brief?
No, I wasn't surprised at all that Mr. Larson would ask for that.
And you started to walk us through what OAG does when it receives a request for documents that OAG itself holds. I just want to make sure that's clear for the jurors, okay? So let's walk through it. So what's the first step OAG would do when it receives a request for records that it itself holds?
That would be received and handled by the Attorney General's Public Information Office.
Objection, Your Honor. I apologize to the witness, but at this point, it's clear from the witness's own testimony that once this request that's about to be discussed was made, it went to a different division, not his, that he does not oversee, and he's previously testified that he was not involved. So any information that he has about specifically how it was handled or by whom would be hearsay or speculation.
Your Honor, right now I'm asking him to walk through the general process of how this is handled, which is something that as the chief of ORD, he is intimately familiar with.
The witness can answer. Overruled.
When a request comes into our Public Information Office, the Public Information Officer will identify the divisions that they believe maintain documents, and they will notify those divisions. Those divisions then collect the information. Generally, we collect the information unless there's some issue with the request, like we don't understand it or it would require a cost estimate. Those divisions, my division in that case, will respond back that we maintain documents, and then we'll follow that up by providing those documents. If a decision is required, then the Public Information Officer will prepare that decision, and they will send it to our division. As soon as we see that we've received a request from the Attorney General's office, it gets segregated out, and at this time, it would have been forwarded to the Opinions Division.
So ORD is not deciding decisions on documents held by ORD, is that right?
That's correct.
Leading.
Sustained. You can re-ask the question.
I think the point's been made, Your Honor. I'm going to move to admit AG 34. It is an internal business record of OAG. It was actually given to us pursuant to a business affidavit that has been on record for more than 14 days. And Your
Any
Honor,
objection?
As we discussed at the bench, The issue is not the business records affidavit. It is protecting the sensitive information of law enforcement, how they conduct their investigations, and specifically the individuals involved. An exact identical copy of the same brief we just talked to you about at the bench is also contained in this document. And so I have no objections as long as she's willing to protect law enforcement and the integrity of their investigations and redact that sensitive information. With those redactions, no objection.
And Your Honor, the chief of ORD has now looked at this brief and told you that there were no mandatory exceptions and no confidential information within that brief. He's also testified that once a brief is given to once documents are given to one requester, they are given to any subsequent requester. They are considered public. And so I do believe that he is one more than very highly qualified to speak to this file, and that there are no confidentiality concerns raised within it based on this witness's testimony.
Brief response, Your Honor.
Yes.
This is hitting a nerve.
Everything my colleague said misses the point. All I'm trying to do is make sure that the sensitive law enforcement information, which is in front of you, the identities of the individuals involved in the investigation, how they conducted the investigation,
This is the
their
CIA
sensitive
and
operations
DOJ's
plans,
own Aaron
their
Epley
sealed search warrant
pretending
affidavits,
to care
and the
about
details
the
contained
integrity
within,
of
how they
investigations
communicate with
and
each other,
protecting law
who was
enforcement.
on those communications, and when they were
And we
sent.
actually
All of that
corrected
information, I just
because
would
that's
ask,
actually
would
Leah
be redacted.
Graham.
And Your
Otherwise,
Honor,
we have
very
no
quickly.
issue.
Absolutely not.
Don't talk over each
Absolutely
other.
not.
Court reporters have a tough job, as it is. Come up for a moment again.
Okay, now Dan Patrick has done this. I think that we need to have this debate because here is some the woman in the Pepto-Bismol pink is actually a woman named Leah Graham. She works for Rusty Hardin, but we showed, and I'm about to skip back to where the attorney is because I want you to see her destroy Articles 3 and 4. But we had someone point out that that's Leah Graham. She looks remarkably like Aaron Epley, but that's Leah Graham, one of Rusty Hardin's impeachment managers on the House impeachment team. Okay. Are frustrated. I wonder if that means that one of the Grim Reapers hovering behind Dan Patrick has determined that the redactions should be made. Paxton's attorney said they don't need to be made. Excellent. Raging Smirk says Ken Paxton will be interviewed by Tucker Carlson in the next 2 weeks. Excellent. High quality television. Finally, we have something good to do. Not the way she's asking the questions. She was told to rephrase, and maybe she was just so, she has a hard job. Telling the truth, it's easier because you don't have to keep up with so many lies, right? But when you have a job like Aaron Epley, when you work with the CIA and the DOJ to facilitate the takedown of constitutional representatives elected by their people, by their own constituents, Aaron Epley, it's difficult to keep up with the sheer volume of lies. So big bad black conservative, I think it just slipped her mind to do her hair yesterday and the day before. I think it totally slipped her mind. Oh, we're back.
Members, we will take a break in a little bit, just a little bit.
Are you sure you don't want to just go ahead and count that last one as a break?
Everybody be seated, please.
And I'd like to ask for
So as we have been going through
back
this
to the next
testimony, slowly continue.
Mr. Gordon, the file placed in front of you marked as AG 34. Is there any search warrant inside this file?
Wait a moment. Has it been redacted or not? The way she's asking the questions, she was told to rephrase, and I believe, let's see. She's asked him to locate in this file that Aaron Epley did not want entered in, whether or not there is a search warrant contained in the file.
There is no search warrant inside this file.
Are there any emails between the FBI and DPS inside this file?
There are no emails between the FBI and DPS in this file.
Did you notice any victim information inside this file?
I did not.
And if the redacted FBI brief had been released to one requester, it would be released to other requesters.
That's correct.
And you've had a chance to look at this file now, correct?
Yes.
And at the back of it, you'll see that, well, let's walk through it. So I think you've testified that based on this file before you, does it appear that OAG sent a notice to the FBI about this request for their redacted version of a brief?
Yes, it does.
Did the FBI respond?
Yes, they did.
And I want you to take a close look at their response brief, and specifically the last page under the signature line. It's the last page of the file. Are you there?
Yes, that's page 6 of the draft.
Witness needs
We've
to stay
got
close to the mic
some
and speak up.
commenters saying that
Does
that's
it
actually
indicate
someone
that
named Leah
the version
and not
sent to
Aaron,
Mr. Larson
and that
was redacted?
explains the
Objection, Your
significant
Honor.
improvement in the hair.
Counsel is mischaracterizing the evidence and honestly misleading the witness. The document that she
Overruled.
is.
You may answer the question.
They look
On this
similar enough
brief,
to me.
it does not say redacted after
Thank you, Truitt, for
the
this. Let's
CC
see.
list to Mr. Larson.
And this brief was filed by Mr.
give me 1
McPhillips
second.
from the FBI, is that right?
Pulling this up
That's
right
correct.
now, Truitt, to confirm.
And from the front of this brief, was it filed, and it's actually marked as received by Open Records on or about June 18th, 2020? Do you see that?
Yes.
And then I want you to look immediately in front of this brief is a copy of the redacted brief at issue. Do you see that?
I'm sorry, would you repeat the question?
Yeah, if you keep flipping forward in the file, the next thing you see is a copy of the blacked out brief that the FBI
Okay,
had filed
guys,
first.
I'm going to show you this. That is apparently not
I
Aaron
believe
Epley, but someone named Leah Graham. So I'm going to show you. This is Leah Graham, who works for Rusty Hardin, the House impeachment manager. She is the one that's been gumming up the process today. I did think that was Aaron Epley because this is what Aaron Epley looks like. They look like just alike. And they're both absolute CNX Tuesdays, okay? But apparently the woman in the Pepto-Bismol pink is Leah Graham and works for Rusty Hardin. Okay, so just a clarification about that, okay?
No redacted version here.
However, this
and when you
is
look under the
Paxton's
signature
attorney right
first,
here. This is
who
Paxton's
signed this brief from May 2020 for the FBI?
Matthew Phillips.
So the same
And I'd
Mr.
like to
McPhillips.
know
Yes.
if we can see Aaron
And
Epley and Leah
underneath his
Graham in the
signature
same
line,
room.
what does it
I'm not
indicate
convinced
next to
that they're
Mr.
different
Larson's
people.
signature? I mean, next to Mr. Larson's name on the copy list.
Next to Mr. Larson's name on the copy list, it says it was redacted.
So the first brief was sent to Mr. Larson, redacted.
We
Is
got to
that
give
what
it to
that represents
Leah
to
Graham
you?
for the hair. She has better
Yes.
hair.
And so the second brief, the June 2021, based on the documents before you, was that
Correction.
redacted when it was sent to Mr. Larson?
It does not indicate that it was redacted.
Does that indicate
you
to
so
you
much,
that the
Pruitt. Thank
FBI
you so much,
provided a
everybody
copy
over
of
on
this
Phil for
brief
that.
directly
Terry
to
Lake.
Mr. Larson?
Thank
Objection,
you,
lady.
Victoria, thank you. Grain of salt.
Sustained, rephrase your question.
What does that indicate to you?
That indicates that they provided the same copy of this brief that they provided to DPS, not unredacted.
And I want you to take a look at this June 2020 brief and tell me how it compares to the May 2020 brief.
Yeah, if we can get Leah Graham and Aaron Epley in the same room to confirm they're different people, that would be great. But thank you so much to everybody on Pilled that caught that. One of you guys said, yeah, thank you, Truitt. One of you guys said, there's no way that's Aaron Epley. That hair is way too nice. That surely is a different woman because those are different genes that produce better hair. And we say, wait, what? So we go and look. Yeah. So that's one thing. If they're the same person, she got a better wig. Because Erin Epley's hair, maybe it's like just her hair just can't be styled, you know? Some people have hair that's just unruly, you know? Whether it's long and straight, but like won't do anything at all. That's my hair. Well, now my hair curls when it gets humid outside. But when I try to curl it, it looks a total mess. It's totally unruly.
They look very similar. There are some different language certainly at the beginning, but they look very similar.
Other than the first paragraph, they are very similar.
Yes, that's correct.
So based on the documents in this file, does it appear that Mr. Larson that the FBI provided this information itself to Mr. Larson?
Yes.
And the very front of this file is the decision issued in this case. It starts with Bates 49954.
She just debunked another article.
I do.
Excellent.
And you just looked at the FBI's June 2020 brief addressing whether or not
very well done. She just
that
debunked
blacked out
another
brief should be released to the public, right? You just looked at it?
I did.
Did it anywhere in there argue that their redacted brief should be withheld from public disclosure?
No, it looked like the arguments applied to the documents that were issued in the underlying DPS file.
And so when that happens, when the comments don't address the information being sought, what, in your experience in ORD, happens in a file like that?
In that case, we would not apply the exception to the documents that are submitted. We ordinarily, because this opinion was done by opinions, they use slightly different language than us, but we've got boilerplate for that type of circumstance. Either that the entity that submitted the arguments is arguing against the release of information that was not submitted to our office, or that the arguments that they've submitted don't apply to the information that is at issue. Because we have a presumption of openness, there has to be an exception to disclosure in order to withhold the information. And if it's a discretionary exception, it wouldn't be applied to information that they don't seek to withhold. If it's a discretionary exception, they have to seek to withhold it in order for the exception to be applied to it.
And the FBI, so the FBI just didn't address their redacted brief at all, based on this file, is that right?
That's right.
Which would result in what, ultimately, for the requester?
That would result in the information, that would result in the arguments that are raised not being addressed to the information for which there are no arguments. And if there are no other arguments, then the information would be released.
Okay, so I want to make sure we all understand what your testimony has been here today. So we had the first request to TSSB in the fall of 2019. Was any information disclosed to Nate Paul as a result of OAG's ruling?
No.
Then we move on to the big request to DPS in the spring of 2020. Was any information released to Nate Paul as a result of that ruling?
No.
And then we get to this third request. And what we see is that the FBI provided a copy of the brief directly to the requester itself. Is that right?
That's
Objection,
right.
leading.
Overruled. Repeat the question and answer.
We get to this FBI request for their blacked out brief. And what we see is that the FBI directly gives a copy of the brief to the requester, to Nate Paul. Is that correct?
Objection, Your Honor. It should be made clear for the record that we are talking about two different briefs, one in May and one in June. And the one in June, yes, there's no dispute. The FBI provided that to Nate Paul's counsel. That is not the one that contains the sensitive information that we have been discussing.
Clarify.
Of course.
I sustain the objection. Clarify.
What we're seeing from this file is that the FBI provided a copy of its June 2020 brief directly to Mr. Larson. Is that right?
Yes, that's correct.
And you've also testified that that June 2020 brief is very similar to the May 2020 redacted brief, right?
Yes, that is correct.
And that ultimately, because the FBI did not address why their redacted brief should not be released to the public, it was released.
Objection, leading.
Sustain. Rephrase your question.
What was the ultimate outcome of the opinion on this FBI request related to its redacted brief?
The opinion concluded that the unredacted brief could be released to the requester.
And you reviewed that brief?
Yes.
And you did not see any mandatory exceptions within that brief that would require OAG to apply its own redactions before release?
That's correct.
Leading.
Overruled.
That's correct.
And after this ruling in August of 2020 on the FBI brief, do you recall one way or another if Joe Larson, on behalf of Nate Paul, continued to seek information from public safety agencies through public information requests?
Yes, he did.
And how do you know that?
He continued to pursue complaints against the Texas State Securities Board all the way through September of that year, seeking to obtain documents that TSSB was withholding from him in the context of Public Information Act requests. And then that continued, throughout the summer and into the fall.
And after ORD rules on a request, what does ORD do with the documents that the governmental agency provided to you to make your ruling?
We send the documents back to the governmental body.
You don't keep a copy?
No.
Those are all my questions for this time. Thank you.
Thank you, Ms. Collins.
She did very well. She demolished Articles 3 and 4. That was very good. She sounded sweet, and sorry, let me talk quieter.
So sorry, one thing, we are moving for admission of HM 46 and AG 34 based on this witness's testimony.
Your Honor, same objection. All we're trying to do is protect the sensitive law enforcement operations, who was involved, when emails were sent, what the subject of those emails were, what the
They
FBI's
established there were no
operations plans were,
emails.
how they work with the State Securities Board, the FBI, the DPS. If that information can be redacted, no objection.
Hold on. We've discussed this at length. He testified there was nothing confidential. The FBI could be here. They could be called.
Yes.
I love how he
Your Honor,
gestures
or
to her.
Mr. President, yes, that's correct.
Either one, doesn't matter.
Okay. Yes, sir.
But they're not here.
They're not. However, I would like to, for the record, remind the court that it was Mr. Banyard's testimony opposite to Mr. Gordon's.
Your Honor, I'm going to insist that she not say testimony of another witness in front of this witness.
Okay.
Wow.
Both of you,
Okay, I'm sorry,
just
Leah.
stop for a moment, okay?
Leah's the Karen. Again, this is she's apparently not Aaron Epley. This is here, let me show you. This is Aaron Epley right here. Okay, this is the DOJ and CIA's own Aaron Epley, but her hair does not actually look like that in real life. This is Leah Graham, apparently. They look just alike, but this woman works for the House impeachment manager Hardin. Okay, but she has a very similar, just say, bouquet as Aaron, the DOJ's own Aaron Epley. But that is Leah, what? Graham. I don't know why I cannot keep her name in my head. Leah Graham, who continues to object to this, even though the witness established that there is none of the information that she's objecting to as and insinuating is in the document. This witness already testified. None of that stuff's in this document. Dan Patrick was absolutely right. Dan Patrick's really looking pretty good here because he was like, look, how are you going to object on behalf of the FBI? First of all, it was the DOJ who sent you, right? No, I'm just kidding. But how's she going to object on behalf of the FBI when they could have been here to testify on the evidence that they released this evidence. The FBI did. And so the OAG is going off of the Public Information Act, which is binding. You cannot just violate the Public Information Act because, I mean, it is binding. If somebody sues, so say I want my records. And
Your Honor, if I could, I just want to make sure that there's no misunderstanding or misstatement here.
Jurors, please take your seats again.
I just want to make sure that there's no misunderstanding here, that you have a complete copy of those files in front of you, and you can see for yourself that there are no copies of search warrants. There are no copies of the actual emails within those files, which appear to be the documents that counsel is concerned about. And I just want to make sure that's clear for the record, that those documents are not in those files.
And the witness testified to
We have
that
reviewed
as
them
well.
while up here, going through this testimony. Is it your representation as an officer of the court that this document has already been released to the public?
Yes.
Both documents?
Yes,
And that was the testimony?
it was.
I have to overrule your objection.
Dan Patrick,
Get
excellent.
into evidence.
They just demolished Articles 3 and 4. Absolutely.
AG
Demolished.
34
She did a good job. It was
and OAG Exhibit 46.
That should be HM 46 and AG 34,
I'm sorry.
Your Honor.
HM 46, yes.
Thank you, Your Honor. Those are my questions for now.
she was very good. She totally destroyed, and I can show you this right here. Why not? Because I have it right here. This is Article 3, abuse of the open records process. Yes, she just introduced herself as
This decision
Leah.
being fact
Excellent.
specific.
Excellent
You recall the
catch,
testimony?
Leah. Thank you.
Yes. So let's talk facts. The requester in this
Oh.
case was Nate Paul's lawyer, correct?
Objection, speculation.
I believe that same testimony was elicited on direct that Joseph
Overruled, go
Larson.
ahead.
Correct.
We did not know that at the time. It's become apparent that that is the case now, but we did not know that at the time.
In your original opinion, as it relates to the request for the full release of the DPS file, was that it should not be released and that the law enforcement exception applied. True?
That's the big DPS file that we're referring to.
Yes, sir.
The original draft on that, I believe, did just address it under the law enforcement exception.
And that was your opinion that it should not be disclosed under the law enforcement exception, correct?
No, that was not my
Excellent
opinion. That
catch,
was just
grain
the
of
first
salt.
draft that was on
Excellent
on the
catch.
ruling.
Who drafted the first draft?
I'm not sure if that was the drafter on the ruling or if that was me. I don't remember.
You had direct conversations with Ken Paxton about this specific request for a full copy of the DPS file, true?
Yes.
He made it clear to you
Obviously.
that he wanted to find a way to release the documents that Nate Paul's attorney was requesting, true?
Objection, Your Honor. That's improper testimony through this counsel. I'm assuming facts that have not been addressed with this witness.
Your Honor, this testimony has already been elicited.
Overruled.
True?
No.
Mr. Paxton did not summon you to his office to talk about this file?
Yes, he did.
He did not put pressure on you to either not rule against the requester or to release the information?
No, I would not classify it as pressure. The decision that we made was not.
Sir, I appreciate that. I'm not asking you what the decision was made. I was asking about your conversation with Mr. Paxton. He had one of two things that he wanted to occur: either release the information or at a minimum, figure out a way not to rule against the requester. True?
Same objection, Your Honor. Assuming facts not before this witness.
I'm trying not to laugh because this is very funny.
In your conversation with Ken Paxton about this particular DPS file, can you recall any other time when Mr. Paxton directly came to you and got involved on a DPS open records request?
No.
Ultimately, you did exactly what Mr. Paxton wanted, correct? You did not rule against the requester, Nate Paul's attorney. True?
Again, objection, Your Honor. Assuming facts not before this witness.
Overruled.
True?
I'm sorry, could you repeat the question?
Yes, sir. Ultimately, the opinion was not to rule against the requester, which was exactly what Ken Paxton was pressuring you to do, correct?
Again, Your Honor, I'm going to object. She's now mischaracterizing this witness's testimony. He said he was not pressured.
Sustained.
By not ruling, you were not ruling against the requester. By making a no decision, that's not ruling against the requester. True?
That's correct. We didn't rule against either party, the requester or the governmental bodies at issue.
Now, earlier you said that the OAG decision not ruling against Nate Paul's attorney, quote, tilted the scale in terms of how a court would ultimately decide whether or not to rule on the disclosure of that information. True?
No, if I said that, I may have misspoken. We did not want to tilt the scale. We didn't want to tip the scale either way. We wanted to maintain the status quo and allow the court to review it completely de novo without our opinion, which is due great weight, tilting the scale based on the procedural requirements.
Withholding the information would have been detrimental to the requester. That's what you said on direct. Do you remember that?
I'm sorry, could you repeat the question?
You said withholding the requested information would have been detrimental to the requester. Do you recall that testimony?
I'm going to object, Your Honor. I don't recall that testimony either, so mischaracterization of his testimony.
And I'm happy to put her on the stand. I'm asking the witness if he recalls his testimony.
We can check with the court reporter.
I have a quote, it would have been detrimental to the requester.
I'm going to overrule. You can answer yes or no.
Yes, it would have concluded that the information could be withheld.
Now, on June 8th, after the opinion came out, Joanna Ward, do you know who that is?
John Award?
Yes, sir.
Yes.
Okay. On June 8th, she was asking if you still had the file in your possession. Do you recall that?
Yes.
In the file she was referring to was the entire DPS file, correct?
Yes.
And within that file is one part of it would have been the probable cause affidavit that Nate Paul was looking for, correct?
No, I believe that, if I'm not mistaken, I think that was after the ruling had been issued.
It is, sir, but that's not my question. Included within the DPS file would have been the probable cause affidavit that Nate Paul was looking for, true?
No.
The probable cause affidavit would not have been within the DPS file.
Not after we issued the ruling, we would have sent the documents back to DPS.
But by June 8th, after the decision was released, do you recall Joanna Ward emailing you and specifically asking you if you still had it, it was still checked out to you, and asking when you were going to return it? Do you recall that?
Yes.
We talked a lot about precedent and what should be publicly disclosed. You would agree with me that a search warrant is treated substantially differently than a probable cause affidavit or search warrant affidavit in terms of whether or not that should be released to the public, correct?
There are different exceptions that can apply to those, but I would not characterize anything as what can or should be released to the public. It needs to have an exception that applies to it. But both can be released to the public. A search warrant affidavit is more likely to have an exception that applies. They're not automatically confidential.
Correct. No further questions, Your Honor.
Redirect.
That was dismal.
Very briefly, in any of these requests, could either party have filed a lawsuit challenging the outcome?
Yes.
Did anyone file a lawsuit for the outcome of the FBI brief ruling request?
No.
That's all I have, Your Honor.
And just so the court knows, because it has been unusual, either side can ask questions from the podium or their tables in case anyone's asking. Can the witness?
Requires no redirect, Your Honor.
Pardon?
Witness requires no redirect. Recross.
Can the witness be excused?
Yes, Your Honor. Thank you, Mr. Gordon.
Am I released, Mr. President?
I'm checking with the House. Yes, you can be released. Thank you. Hence, we'll call their next. No, we're going to take a break. Sorry. We'll call your next witness after a break. How about 5 minutes after 10? 20-minute break? 11. Sorry. We passed the 10 hour. 5 minutes after 11.
Last noticed witness of the day, if I'm not mistaken. Sure. I am
inaccurate.
mistaken. I am mistaken.
Okay, you guys.
Ms. Epley, who are you calling? Or Mr. DeGuerin? I'm not sure who's calling the witness.
There's a lot of information
Yes,
on
Your
that
Honor.
last link that I sent out, so please search
The
on
House
that page.
Board of Managers calls Darren McCarty.
Bailiff will bring in Darren McCarty.
All right, search in the page for the link that I just posted in both the Foxhole, the YouTube Pilled, and the Rumble chat. I posted 2 of them. One's a video, and it's like a YouTube link, and I
Bailiff,
don't have YouTube, but it
just
still
hold the
let me
witness outside for a
pull the
moment.
video up. The second one is an
Mr.
index
Busby,
sort of thing.
Mr. DeGuerin,
Just found.
I understand that both sides have
Search in
agreed
there for
to
Bing.
exhibits. I
See
guess that was
what
earlier
info you
today,
can
this
find from
morning.
that. That's just very.
That is correct, Your Honor.
There you
And
go.
we're going to
Yeah,
read those exhibits into the record
just
now.
to prove his point,
correct?
we can Google them and find information.
Mr. DeGuerin?
So
Turn on the
and
microphone.
now they're
It's right
trying to
behind the
accuse and
laptop
Frank.
there.
They're
There you go.
projecting, trying to accuse Paxton of conspiracy. Paxton.
I'm going to
this
start with the
Brian
House Board of
Campbell.
Managers exhibits first, Judge.
And read through them relatively slowly. Don't race through them.
Yes, Judge. House Board of Managers 55, 62, 77, 85, 86, 91, 92, 94, 324, 346, 657, 677, 678, 680, 681, 682, 683, 684, 685, 693, and 694. And Judge Attorney
You may continue.
And Judge Attorney General exhibit numbers 17, 33, 42, 47, 48, 84, 85, 141, 151, 155, 161, 165, 219, 223, 305, 307, 332 through 354, 371, 398 through 422, 428, and 429.
Thank you, sir. Mr. DeGuerin, hold on one moment.
Okay, everybody, give me just one moment. My restream is frozen, and I think this is when. Let me see. Was this when Rumble was down yesterday? An excellent report by Dolcefino. Give me just one moment.
Attacks from without.
Here we go. Then we can
Absolutely.
And does it sometimes include protecting a charity from itself or from mismanagement?
Yeah, from breaches of fiduciary duties, some sort of mismanagement, yes.
Is there a requirement under Texas law that when a lawsuit involving a charity occurs that the Attorney General
And since you're
is
not
to get
selling like
notice
finished
of
products, you
that
have to like
lawsuit?
customize them.
Yes.
What does the Attorney General do then what does your charitable trust division do
Yeah,
then
it's easier
when
to
given
just send them.
notice?
So that's that with
They
the
look at the
custom built
lawsuit
orders,
and,
unless they can order like stuff online,
do some investigation to
basically a
determine
custom order
whether
every time.
the charity
So there's not
is
there's let me see,
qualified
two pages.
to protect itself and is protecting itself. In other words, if there's some sort of mismanagement issue at the charity, or there's some inability to legally represent itself, the charity in the litigation, that might be a place where the Attorney General's office steps in to protect the charity.
Give us a rough estimate of how many charitable trusts exist in the state of Texas, if you know.
I do not. Quite a number.
Is it in the hundreds
Yeah,
of thousands?
That would
that's how
not
it is
surprise
now.
me.
It's to
Okay.
where
And give
they
us
can upload their
a
art
rough
if they have
estimate,
any,
if
or
you
they
will,
can
of
just give a description of what they want and
how
sort of get a quote
many
from you.
times the Attorney General's office, in
Yeah, and
let's
then
say in
because
a
it'll
year,
save you money if we try to connect all
involves
of this stuff. If
itself
it
in
sees
some
that you're doing all
way in
these
a
little
charitable
deals,
trust
it's just going to
litigation?
spam all of this.
It's
Like if you take a little
handful.
off the top
A
of it,
handful.
it's going to add up to a lot of money. That would be
Okay.
that you would
So
save
it
if
may
you
be,
send them the link directly
again,
after
it may be a
the
management problem. Sometimes
so it'd be
charitable
easier to do it
trusts,
like that. Now, before
are
we're
falling
going,
into a
how
state
do you
where they
use
sort of can't be
QuickBooks for your
self-sustaining
type
anymore, et cetera. And so, the AG's office will get involved, but it's not a common occurrence.
How, what procedure does the Attorney General's office go through to determine whether to involve itself in litigation involving a charitable trust?
Well, first, the Financial Litigation and Charitable Trust Division, as it was organized then.
Well, for
they
him, it's
have
a little different because
group,
he can have
obviously,
like he
within
can just
that
send
looks
them.
at charitable
Well,
trusts.
it'll be a little bit. It'll still
They
be
analyze the situation. They make the staff attorney will make a
so if you have all of your
recommendation.
products uploaded in
Initially to the head of
QuickBooks,
the
we can add all of
charitable
those to
trust
the website.
group within the
And then if
division,
you want, you could say you could have like
as
a
to
flat
whether to
rate. Like say
intervene
you
or
have like a
not, and then
special.
that's sort
Like
of
say, oh,
if
all of
it's
these
non-intervention,
shirts, I can get this one type of
typically it
shirt
sort
for
of
like
stops
really, really cheap.
at
So
the
I can
division
do
level. It won't
this type. I
necessarily
can do
come
like
up
a
to me
one
unless
color,
they think it's a close call and they
t-shirt
would
print
need
design for like
someone in my
$5,
role's
just an
advice.
example. We
If
can
that's not the case and
teach
they
you that
believe that they should
say, hey,
intervene in
order
the
here.
case,
How much do you
then
want it? How many do you
there would
want
be
it?
an
And then upload
executive
your
approval
one color
memorandum,
design that you want
and
us to put on there, and
that
then
would
we'll
be
get them ready
signed
for you,
off
and so people
on,
can just say, okay, here's my art. I
be
want
signed
30
off
of
by the
them,
division
and
chief.
go ahead
It
and
would
pay
be
the
signed
set
off
rate. Like if you
by
want to do it,
me.
stuff like that.
I believe it would have been signed off by the deputy first assistant attorney
We could
general and
set
also
that type
by the first
of
assistant.
storefront up,
I want to
but then
ask you
you can
some
do a lot
questions
of
about the MIDI
stuff that's a little more
Foundation
custom. But like
and some
you might
litigation
want to have
involving the MIDI
a
Foundation
couple of items, like maybe stickers and
and
magnets,
Nate
maybe a
Paul
special
are
on shirts.
world-class holdings.
And
You're
we can
familiar
advertise that on
now
like
with
the
that
homepage and
litigation,
say,
aren't you?
hey, flat rate,
Of course,
$12
yes.
a shirt,
We do not
or
have
two
an
colors,
agreement on
and
Exhibit
whatever
54, but I'm going
works for
to
you guys,
hand you
and then
Exhibit
we can advertise that
54
right on the homepage,
and
so
ask that
people
it be
will
introduced
go
once
right
he
away, and then we can have a
identifies
button,
it, Your Honor.
and basically it'll be the same thing where they upload their artwork, and then there's the button underneath it will be like a submit and order, or like add this to the shopping cart type of thing.
Any objections from the?
No, Your Honor. We'll allow this.
We'll admit Exhibit 054 into evidence.
Will you pull that up, please? I want to direct your attention to the first paragraph of this memo. First, what is the memo?
This looks like a memorandum
but
that
it's not showing me. Let me see. Business, PayPal business.
recommends, I shouldn't say it looks like, it is a recommendation by.
Keep your voice up and get close to the microphone.
I'm sorry, I was busy trying to read this.
I'm trying to log into mine.
This appears to be the memorandum that
I'm sorry, it is on the screen if that's easier for you.
Okay, that is easier, thank you. This is the memorandum that declined to involve for the AG's office to become involved with the MIDI Foundation. So this would have been prepared at the division level.
Yeah,
and,
they're going to charge you like
highly
a certain
unlikely
amount
that
to
it would have come to me initially.
to do that, and then
All right. I want to draw your
they tell us
attention
you're
to
the
the first
sixth
paragraph,
thing.
and I'll just read it as you look at it. If you'll highlight that first paragraph, I recommend waiving the Attorney General's interest in this matter regarding a private real estate company's breach of fiduciary duties to its investors, one of which is a charitable trust, the MIDI Foundation.
Yeah, and
Did I read that
yeah,
correctly?
you can set
And that's a memoranda recommending to waive the Attorney General's interest.
That's correct.
But
On the second side of that letter,
yeah, if you
go to the
PayPal's
second
doing
page,
really well, but
I want to highlight
that's why they're so popular. The on your PayPal
paragraph
account,
in the middle, in my opinion, starting there.
PayPal business account. Okay, and because mine's showing me.
This office does not have a role in this matter. The trust is zealously represented by counsel. Counsel stated that once the receiver sells the First and Trinity LP and WC Third and Congress LP, the trust will likely make a massive return on its investment. Did I read that correctly?
You did.
And finally, at the bottom, I recommend the Attorney General file a waiver for the following reasons.
On your
the trust is represented by counsel, the trust's assets are diversified, and the litigation will not critically impact the trust's 2020 distributions. Is that right?
Yes, that's how it reads.
Following this, did the Attorney General waive filing any, waive interfering in this lawsuit?
Yes, we did not intervene in January or around that time frame of 2020.
Pull up Exhibit 55, please. I believe this is agreed. Entered by agreement. This is the Attorney General's waiver, isn't it? Filed in the lawsuit, styled the MIDI Foundation.
Yeah, that's good. That's good.
Against WC and Trinity, so forth, the world class or Nate Paul's
okay, so
organizations.
I don't remember my Twitter username.
I want to highlight at the bottom of that first page of the waiver.
An option there that says look like a pro.
If any pleading is filed herein that adds additional parties or causes of action, then that would constitute new or additional proceeding, and then the Attorney General might intervene, correct?
That's correct.
Did any new parties, additional parties, or additional causes of actions ever get filed in that case?
I certainly don't recall any new parties, and I was not aware of any additional causes of action.
Did General Paxton order that an intervention be made?
It doesn't say anything about.
Well, yes.
Let me ask you this way. Did you have a conversation with General Paxton in which he expressed his request or order that the intervention be made?
Yes, I did. So General Paxton eventually came to me, and this was my first involvement with this case, substantive involvement, right? There are 34,000 matters.
Okay.
Okay.
So let me get it this way. Was this on your radar screen at first?
No.
How did it get on your radar screen?
It got on my radar screen because General Paxton particularly wanted to intervene in this matter. I don't think my first discussion about this matter was with General Paxton. I think it was probably with Jeff Mateer. But at some point soon thereafter, I had a meeting with General Paxton.
Oh yeah,
and
to
he
connect. But is there a
expressed,
way for you to connect your website?
a high level of interest and some insistence that we should intervene in this matter.
In your experience,
Oh, you did? Okay.
had
Does it
General
have? It does.
Paxton
Okay,
ever
so actually, on your invoice, that it's saying
expressed interest in
does it say to have your website on the invoice?
any litigation involving charitable trusts that the Attorney General was involved in? Attorney General's
Objection, Your
office.
Honor. That's speculation.
Sustained.
Had there been any other litigation involving charitable trusts that you'd had any conversations with
design@yahoo.com email? Like, does it have
Paxton,
your
the
business
General
email
Paxton
on the
about?
I did not.
I'm sorry, I didn't hear you.
There were not. No, I had no other conversations about any other charitable.
So what was your thought about General Paxton getting involved in this litigation?
I did think it was unusual at the time.
I'm sorry?
I did believe that was unusual at the time.
That way we can make sure to.
And that's probably all I thought about it at the time. We had so much going on in my divisions at that time with COVID and the Google lawsuit, et cetera. I did not spend a great
going to the store over here.
deal of time thinking about it other than
His
sort of the mental
username
note
and
that was
email
a
weren't
little
working, and I wasn't sure if it was
out of the ordinary.
All right.
computer just
So
being weird.
at any rate, did
But I can't get it to pull up, and I've tried a few.
the Attorney General's office file an intervention
Pull up for your.
in that lawsuit?
We did.
At the time it was filed, do you rely on advice from your staff of attorneys that generally have hands-on handling of the litigation for advice?
Of course, I always.
We could have the
advice for them.
Organization chart again, please.
Online pay links. There's also a way, in GoDaddy people. He's no.
Down the list of people under you, there is a Joshua Godby.
Okay, good. You have that. That's in your PayPal.
Our screen shows the previous document.
Good. So PayPal should not have a reason at all to shut you down at this point.
You've got a glitch over there.
The main reason with Stripe is they're going around asking everyone to validate their URLs. They got mad at me.
I can tell the court reporter does, but for some reason our table has something completely different.
They shut me off for that.
And I'm not trying to take away your time.
I don't know what you're doing, and
I'm not trying to take the man's time.
And validate your URL. So it's like, okay, so I just updated that, and then they're like,
it's just our
table
that's
fine.
keeps
And so
doing
then
this.
they release.
I'm not suggesting a conspiracy, or I'm just saying it's happening.
Are the rest of the tables of your attorneys?
But I think that this way, when we
Damien
make sure,
will come to the rescue.
and until we put a link from GoDaddy,
It looks like the senators have the right one.
To your PayPal, which I'm not sure if that's
I'd request an extra 15 minutes for this
market
delay.
like a special product with a flat rate.
I bet you could negotiate down to one.
Nice try. Like a simple thing that you could execute really quickly and still make money on. But
plus, we saved you 5, so you're 11 minutes to the good.
Like even if it's cheap, you don't make a lot of money on it, but it gets their attention. Or it's something that they could continuously reorder, and you'll still make a little bit of money and keep their attention. That way, you can offer them more stuff later and say, "Hey, we have these new mugs, we have these new whatever," and they might be more willing to keep shopping with you. But
y'all please like and share this out. Some people don't like my commentary; they just want just the plain stuff. Well, that's what Taking Back Texas does. We have Inside Baseball. Our website is down right now, unfortunately.
So any business,
see all of our reports, but it'll be back.
They're not going to be looking at you super weird. But I think it would be great if we could get something like that.
So thank you to everyone for being here. Please like, share, and subscribe. We do commentary. We have a lot of Inside Baseball and Texas.
Members, we're going to take this is the last witness of the day, but there's still more questions and cross. So let's take just a quick 10-minute break here, not our normal longer break, and then we may be finished by a little earlier this evening. So 10 minutes, come back at 20 minutes before the hour of 6.
Okay, quick 10-minute break. All right, guys. So y'all have any questions at all? What do you think?
Mr. President? Oh. Okay.
No, for her the answer is no. Your mic is off. Go away. Go. Now go away. All right, 10-minute break, y'all. Okay, guys, I apologize. I also apologize if you heard me on the phone with one of my clients. I'm so sorry. I'm building out her website for a couple websites for people. Thank you, guys. This is how I know that she is CIA. Over on the Rumble chat, Mrs. Lopez asked, "How do you know Erin Epley is CIA?" So this is how I know. So she DOJ, okay, and I haven't joined LinkedIn just to get onto Erin Epley's LinkedIn, but she is, let me see, Erin Epley lawyer. Here's Ava. Let's see if we can, I don't know if it'll show everything there. That's her. Not yet reviewed. Really? So such an experienced attorney has no reviews? Let's check out her resume. Let's see. Harris County DA. This doesn't have everything here. It doesn't have everything here. If LinkedIn weren't such Nazis, I would try to go back and look in. This has no information, and that's kind of crazy because Erin Michelle Epley is like, a relatively experienced attorney, so that's kind of weird that she's had her state license for her license for 14 years. She doesn't have a single review, not yet reviewed. How do you even get a hold of her? Criminal defense, then why was she part of the prosecution? Very interesting. I don't know. But so I guess I might as well make an account for LinkedIn. Lawyer.com. Here's this. Oh, I zoom in and it does not help. Anyways, Department of Justice. She's in good standing. 14 years licensed in Texas, but no reviews. No one's had any experience with her until now. Let's see. Yeah, she's got a bit of a CIA background. Diddy, do you have the link? Are you able to, let me see. Diddy had pulled up her LinkedIn, and we saw her very impressive resume. Let me see if I can get it. I don't think so, but did you mean this? Yeah, whatever. It's not gonna let me look. But this is her. Join to view profile. Should I join, guys? Should I just join? Let's see. The senators have not returned. There's still no live broadcast to display. And we have no idea how long the deliberations will take. We don't know if they'll be... If it'll take... Oh, so Crisco, the senators are in deliberations right now, are deciding how they're going to vote. What they're having their little arguments. They're not allowed to talk to anybody other than other senators right now. Senators can only talk to other senators right now. So we have no idea how long the deliberations are going to go, and that's going to make it very difficult for people like myself and other streamers to actually be able to catch it, you know. But we'll find out. We'll catch it and we'll bring it back up. So hopefully it's today, but it might not be. It might be next week, and we have to prepare ourselves for that. That's okay. Anyway, if you guys have a LinkedIn account, if you want to know why I say she's CIA and DOJ, this Erin Epley, go ahead and log in and check out her LinkedIn account. She has a very impressive resume. Very impressive. Okay. So here she is, guys. All right. And you'll see if you just scroll down to where it won't let me view her education, her experience. Yes, she's definitely somebody that I would want to watch out for if I was working down in Travis County, but she's over in Harris County though. So anyways, they brought her in special from Harris County, from the DOJ, to facilitate the takedown of Attorney General Paxton. And I want to thank everybody for being here. I'm going to leave this live stream up and running for just a little while. Okay. And I might do some replays of some of the initial days worth of hearings. Let's see if this one. Could probably share this one.
Can you just clarify for the record? We have.
You know what? You know what we should do? We should show actually the testimony of that ranger. Do you guys want to see the testimony of that ranger? Let's go ahead and show that. Let's see. He was on, I would say he was on what, day 6? Is that when the ranger was? I'll look it up right now and see. Let's see. From the first week, so that would have been, it was in the first week, so that would have been, let's see. Will that have been on day 4 that the ranger testified? We'll find out. You guys remember? You're right, Miss Lopez. She says, I've communicated with all and my rep for 2 weeks, but once they convene as jurors, I do not believe they can communicate with the office, social media, anyone at all other than family and fellow jurors. Yep. Okay, guys, I have found the testimony of the ranger, and I think that we should go ahead and play it. You know, regardless of how the senators vote, I think that we all need to be aware of what this ranger has testified to. So please enjoy this recap. This is a recap of day 4.
If you'll move that microphone pretty close, we have a little problem with acoustics in here. Please tell the senators your name. Yep. Yeah.
There we go. My name is David Maxwell.
Mr. Maxwell,
excuse me.
Your last position with the Attorney General was as Director of Law Enforcement. Is that correct?
That is correct.
I want to ask you some questions about your law enforcement career. Can you tell us where you started and when?
I started in 1972 with the Texas Department of Public Safety. I went to the patrol school, graduated April 6th of 1973. Spent 8 years working highway patrol in Harris County. I promoted to narcotics in 1981.
So help me God.
Excuse me while I try to figure out why my sound was not working anymore. For some reason, my sound is not working anymore. Very interesting. Well, guys, my sound seems to have
If you'll
cut
move
out
that microphone pretty close.
for a little while. 5 hours.
Nonetheless,
5 hours, 45 minutes.
did you form an applause as Director of Law Enforcement? Is that correct?
That is correct.
In the other day, you did not.
Okay, guys. Well, I've got some sort of mystery happening here. Let me get out of this one. Some sort of mystery.
Okay. Repeat after me. I do solemnly swear and affirm.
Explain it. For some reason, my sound is not working, and I can't get my video to play with any sound, and I need for it to play with sound, so it's very strange. All right, so this is. I apologize, guys. I'm going to. I'm going to try once again to pull that up. I'm sorry if you hear a ghetto chick outside of my apartment window running her mouth on her phone as if she's the only person in this entire world. But she should be gone soon, and I'm just going to pull up day 4. Okay. It's working. Okay, guys, for some reason it wasn't working, but I got it working now, so I'm going to share this. This is the testimony of the Texas Rangers that the House was banking on. And honestly, this testimony is very important for us to hear, not because what he's saying is truthful, but because what he's saying is damning. He basically testifies that it's illegal to investigate the FBI. It's incredible, so check this out, okay?
And affirm as a witness in the impeachment proceeding.
Please like and share this out, everybody. Thank you very much for being here.
Shall be admitted. I'm sorry. I read the wrong line. Let me start from the beginning. I do solemnly swear and affirm, you've read that, that the evidence I give upon this hearing,
given while our senators are in deliberation,
upon this hearing,
cast their vote. We will be back to stream their vote.
The Senate of Texas impeachment, charges against Warren Kenneth Paxton Jr., shall be the truth, the whole truth, and nothing but the truth. So help me God. Please be seated. You may begin.
Thank you, guys. I apologize. Not sure what was going on, but I think we got it all worked out now on both ends. Thank you so much for being here. I appreciate all of you. Thank you, Spotzel.
If you'll move that microphone pretty close, we have a little problem with acoustics in here. Please tell the senators your name. Yep, got it.
There we go. My name is David Maxwell.
Mr. Maxwell, your last position with the Attorney General was as Director of Law Enforcement. Is that correct?
That is correct.
I want to ask you some questions about your law enforcement career. Can you tell us where you started and when?
I started in 1972 with the Texas Department of Public Safety. I went through the patrol school, graduated April 6th of 1973. Spent 8 years working highway patrol in Harris County. I promoted to narcotics in 1981 and worked narcotics in Harris County for 5 years. Then promoted to Texas Rangers in 1986.
Let me stop you there just for a second. Those of us who were raised in Texas know a lot about, or think we know a lot about the Texas Rangers. What does it take to become a Texas Ranger?
First of all, you have to have 8 years of experience with DPS to be able to apply for the position. When I applied in 1986, it was a little different than it is now, but we had to take a written examination to qualify to go before the oral interview board. And then they would score the oral interview board and combine the two, and then they took the top 5 people and put them on a list for 1 year. If you didn't get promoted in that 1 year, you went back to the first step and started over.
How long did you serve the state of Texas as a Texas Ranger?
25 years as Texas Ranger.
And when you left the Ranger service, where did you go?
I went to the Texas Attorney General's office.
What was your first position there?
My first position was Deputy Director of Law Enforcement.
And did you promote to the Director of Law Enforcement?
I did.
I want to pull up for, please, the organizational chart. It'll be in front of you. I'll ask you a couple of questions about that.
Okay.
Your name and, yes, your name has been highlighted, and it appears to be on a level with other deputies. So what was your rank in the Attorney General's office as it relates to the Deputy Attorney Generals?
I was the Executive Deputy over Law Enforcement Division.
Is that an equal rank with the deputies that were deputies over the other divisions of the Attorney General's office?
Yes, and I was the most senior deputy.
Most senior, how?
I had more time as an executive deputy than the others who were working with me at that time.
How many employees, law enforcement officers and support staff, as well as attorneys, did you supervise?
I had about 350 employees. 205 were commissioned officers and 19 of them were attorneys.
Were those employees spread out across the state, or were they only in Austin?
We had a majority of them in Austin, but we also had offices around the state.
What is and was, when you were director, the authority of the law enforcement division of the Attorney General's office?
The authority was that of other peace officers in the state. We had jurisdiction over any type of crime that would be committed against the state of Texas.
Did you have a criteria for opening a case as an investigator to be investigated by the Attorney General's office criminal division?
I did.
What was that criteria?
This is the criteria that I set up for investigating public officials. So I had certain requirements. And first of all, I reviewed all the requests that came in for investigations on public officials. And we had a lot of requests, and I didn't approve but just a few every year. We already worked as many cases on public corruption as the Texas Rangers have statutory authority. So we worked.
Excuse me, Your Honor. Excuse me. Non-responsive. The question was, what was your criteria?
What was your criteria for opening an investigation?
The criteria was, at first, I had to have a sworn signed statement from the person who was making the allegation. The second thing was that I had to have a letter from the district attorney who had jurisdiction over the possible cases, saying that they would prosecute those cases if we were able to prove that a case was viable.
Why did you have a criteria such as that, particularly when it comes to investigating public officials?
I set up the criteria in order not to be pulled into situations that are strictly political in nature. I did not want us to be in a position of investigating public officials when there was really no crime being committed.
And did this criteria particularly apply to investigations of public integrity?
Yes.
Do you know who was the district attorney in Travis County in the year 2020?
Margaret Moore.
Did you have a good relationship with Margaret Moore?
I did.
I want to get right to the matters here. Were you asked in some way to meet with a person named Nate Paul?
Yes.
Who asked you to do that?
Jeff Mateer.
Where did Jeff Mateer tell you who had told him to have you meet with Nate Paul?
Objection, hearsay.
That's not hearsay under 803 and 801E2D, Your Honor, with respect.
Mr. Mateer is not alleged to have been a co-conspirator. Objection, hearsay.
It's not.
Hold on one moment. Hold on. And we've been doing a really good job of not using a lot of numbers. I have my whole chart here. It's better for just to say what the answer objection is, but this is why I have legal counsel here.
Yes, it's 801
yes.
E2D.
Overruled.
All right, you may state your answer. And the question is, did Mr. Mateer tell you who ordered him to order you to meet with Nate Paul?
Yes.
What did he say?
He said General Paxton ordered me to meet with this individual, that he had a story to tell.
At about the same time, did you hear from an employee of the Travis County District Attorney's Office about Nate Paul?
I did.
I'm going to ask you about that in a minute, but when you first were asked to meet with Nate Paul, did you do some research of your own?
I did.
And what did you find?
I found on the internet that...
Excuse me, with all due respect to Ranger Maxwell, if he's going to recite information that he obtained doing his research, that would be hearsay.
It goes to his state of mind in conducting the investigation, Your Honor, and thus is not hearsay.
It is hearsay.
Well,
overruled. Continue.
Okay. So what did you find when you made your initial investigation of Nate Paul?
I found that Nate Paul was being investigated by the FBI, that they had run search warrants in August of 2019 on his business and his home and a storage facility. I found articles in business journals that talked about lawsuits.
Excuse me. Objection, hearsay. Articles in business journals, that's definitionally hearsay.
Again, it goes to his state of mind, and it's the same. He's answering the same question that the court allowed.
With all due respect, he can testify to what's in his mind under this exception. He can't testify as what the article said.
Sustained.
Nonetheless, did you form an opinion of your state of mind?
I did.
And what was that?
My opinion that Nate Paul was a criminal and that we should not be associated with Nate Paul.
At about the same time, did you receive a communication from the Travis County District Attorney's Office?
I did.
Your Honor, we have an agreement on House Exhibit 615, which we moved to introduce.
Could I see it, Dick, real quick? I'm sure you're right. Yes. No objection.
It's been admitted. Both sides have agreed.
If we could bring up closer, yeah. I'm being told to tell you to get closer to the mic.
Mr. Maxwell, they just asked you to get closer to the mic when you speak.
Closer to the mic? Yeah. Is that better?
You can pull that towards you a little bit if you'd like.
Okay.
You can pull the whole outfit closer to you.
Okay.
This is the first page. This is the email, and it references a letter. Let's go to the second page, please.
Yes, it was from Don Clemmer.
All right, here's a letter from Don Clemmer. It's dated June 10th, 2020. It's to you. And let's just read it into the record. I am forwarding to you the attached complaint, which was recently received by my office regarding allegations of misconduct by employees of the State Securities Board, the Federal Bureau of Investigations, the Department of Public Safety, the United States Attorney's Office for the Western District of Texas, and a federal magistrate. My office would typically forward such a complaint to the Public Integrity Unit of the Texas Rangers for review. However, since an employee of the Department of Public Safety is one of the subjects of the complaint, referral to the Rangers would appear inappropriate. I am therefore requesting that your agency conduct the review. My first question, is the word review significant?
Yes.
What is its significance?
In the protocols that we had set forth, we first review the request before we ever make a determination on whether we'd actually open up an investigation.
Now, you're familiar with a district attorney's office excusing or recusing itself from an investigation, aren't you?
Yes.
Is that what this was?
Yes, they were forwarding it to us. They didn't feel like that it was up to them to do this investigation.
Now, we saw the email that Mr. Clemmer sent about the same time, and it mentions that you should call him if you'd like. Did you call him?
Yes, I did.
And did you talk to him?
Yes, I did.
What did he tell you?
Excuse me, objection.
It comes in, I know he's going to object to hearsay. Under Rule 803.3, it's an expression by Mr. Clemmer of his then existing motive, intent, and plan.
Not only do I have to object, I want to object. Hearsay.
Yeah. Sustained.
Maybe I didn't clearly state my citation of the code or of the evidence rules, Your Honor, 803.3.
I've ruled. Continue.
All right. Whatever, and don't go into the words that Mr. Clemmer said, was it consistent with what you had already found or the suspicions that you already had?
Yes.
And what were your suspicions?
That the referral was being requested by General Paxton.
And what about the validity of the referral and the complaint?
Excuse me, objection, conjecture, and speculation.
Oh, this would be his evaluation, which was his job to do.
He hasn't done anything yet. Objection, conjecture, and speculation. You're asking him to testify as to the validity of a complaint which he hasn't investigated yet. That would be conjecture and speculation.
Let me lay a letter.
Overruled.
Okay, go ahead.
I can answer the question.
Yes.
My evaluation of the allegations made by Nate Paul is that they were absolutely ludicrous, without merit, no probable cause, not even reasonable belief that a crime had been committed.
And he's basing
Now,
that
let
on
me step aside for just a moment and say, or ask you, what were the nature of the allegations that Mr. Nate Paul was making?
The nature of the allegations that he was making were against the FBI, a investigator with the Texas State Security Board, 2 U.S. attorneys, the senior federal magistrate, Mark Lane, and others who were involved in the chain of the signing and execution of the search warrants on his business, his place of storage, and also his home.
Now, one of your areas to investigate, one of your duties was to investigate public integrity, correct?
Yes.
If there had been credible allegations against the State Securities Board, the DPS, the FBI, federal magistrate, U.S. attorney, would you have any hesitation of going forward?
Objection, excuse me, objection, bolstering, and self-serving.
Overruled, continue.
You may answer.
No, I would not.
Did you have any hesitation even to meet with Nate Paul?
I did not want to meet with Nate Paul, and I expressed my concerns to Jeff Mateer about that.
And what was the reply?
He said that he was getting a lot of pressure from General Paxton for me to do this.
All right. Let's go to July the 21st of 2020. Did you have a meeting with Nate Paul and his lawyer?
I did.
What was the reason you had that meeting?
I told Jeff Mateer that I would consent to let him tell his story, and that if he made any statements against his interest, I would report it to the FBI.
So on July the 21st, did you have the meeting?
I did.
Where?
It was on the first floor of the Clements building. It was in the office of our security office, where we have a conference room that has the capability of recording video and sound.
Who wanted that to be done? That is, record by video and sound the meeting, but with Nate Paul and his lawyer and yourself?
Me.
Are you familiar with a report that was later put out by the Attorney General's office claiming that General Paxton wanted that meeting recorded?
That is false.
So, have you reviewed the transcript of that meeting?
I have.
Are you aware that the lawyers for General Paxton have been supplied with both the audio and video and transcript of that meeting? What took place?
Okay. Yes, I'm aware of that.
Okay. What took place at that meeting?
Say it again.
What took place at that meeting?
Nate Paul laid out his conspiracy theory about what happened the day of the search warrants were executed. He had complaints about the procedural part that the FBI took when they were securing the scene and conducting the searches. And then he laid out his conspiracy theory that they had originally come to search for not records, but for drugs and guns. And that in the middle of the search, when they didn't find any drugs and guns, they then altered the search warrant to be the search warrant that was executed, where it was for records. And he further stated that The people involved in that was the FBI agent, the agent from the Texas Securities Board, Alan Bowie, who was at AUSA, and Mark Lane, the senior magistrate.
So according to his complaint, a United States federal magistrate was involved in this conspiracy?
That's correct.
As a law enforcement officer of many years, what did you think of that?
It was ludicrous.
Did you ask for any documentation?
Yes, I did.
Are you familiar with the crime of obstruction of justice?
I am.
Are you familiar with the crime of interference of a law enforcement investigation?
Of a federal investigation, yes, I am.
What concerns did you have if you had started an investigation based on these claims by Mr. Paul?
My concerns that we would be interfering with a federal investigation. We could be charged with obstruction of justice, and based on a complaint that has absolutely no merit.
And at this time, even at this meeting, had your criteria for opening an investigation been satisfied?
No.
How so?
It doesn't meet any of my requirements.
After that meeting with Mr. Paul, and his lawyer, by the way, was Michael Wynn?
Michael Wynn was there.
Okay. After that meeting with Mr. Paul, did you have a meeting with the Attorney General, General Paxton?
I did not after that meeting immediately, no.
But no, I don't mean that same day. But did you personally talk to Ken Paxton, the Attorney General, about what had happened in that meeting?
No, I did not.
What did you tell him about the meeting?
I'm sorry. I thought he said he did not meet with Mr. Paxton. And you just asked him what he told Paxton. One of us is confused.
Can we clarify that?
Yeah, could you clarify that? Did you tell him what you thought about that meeting?
I told him before the meeting ever occurred what I thought about us being involved with Nate Paul. That happened before the first meeting.
And what did you tell him?
I told him that he was a criminal.
Sorry. Excuse me, Ranger. Objection asked and answered. He just got through telling us what he told Paxton.
I don't believe it was asked. I don't believe he answered fully what I'm driving at. What did he tell General Paxton?
I'll sustain the objection and you can try one more time again.
Maybe I'm not clear on it. Did you at some time tell General Paxton what you thought about this idea of Mr. Paul, that there was a vast conspiracy against him?
Yes.
What did you tell him?
I told him that Nate Paul was a criminal. He was running a Ponzi scheme that would rival Billy Saul Estes, and that if he didn't get away from this individual and stop doing what he was doing, he was going to get himself indicted.
Nonetheless, was there a second meeting between you and Nate Paul and Nate Paul's lawyer and Mark Penley?
There was.
Why was there a second meeting if you felt like you did after that first meeting?
Because he had talked to he had talked to Mark Penley and told him he wanted him to conduct another meeting with Nate Paul.
When you say he, are you referring to General Paxton?
General Paxton, that's correct.
So General Paxton had told Mr. Penley to get involved in this?
That is correct.
Excuse me. Objection. I'm sorry, Dick. Objection asked and answered. Ranger Maxwell will give his testimony and Dick will ask him to repeat the same thing. Ask and answer.
I'm going to overrule that. Continue.
Yeah, I wanted to clarify and make sure that we understand. Mark Penley told you that General Paxton had ordered him to now get involved?
This is the third time. Objection, ask, and answer. He literally just got through testifying to that.
I believe that you allowed me to ask that.
Sustain.
All right. So did you have a second meeting?
We did.
And was Mr. Penley involved in this one?
He was.
And what was Mr. Penley's role in the Attorney General's office? If we could have that organizational chart again.
Mr. Penley was the executive deputy over criminal prosecution.
So in this chart, he's just next to you, and it's now been highlighted for them for the jurors.
That's correct.
Was he your superior or was he an equal of yours?
He was an equal.
And what was Mr. Penley's background, briefly?
He came to us from the U.S. Attorney's Office out of Dallas, where he'd been an assistant U.S. attorney.
So at this second meeting, where did it happen?
In the same place as before, in the Clements Building, ground floor, the security office, conference room.
Was it audio, video recorded?
It was.
And is there a transcript of that?
There is.
Have you reviewed that?
I have.
Are you aware that that has been provided to Attorney General Paxton's lawyers?
Yes.
All right. Who wanted that meeting recorded?
I did.
If there's any suggestion that General Paxton wanted that recorded, is that true or false?
Objection, asked, and answered.
That was the first one. That was the first one that we referred to.
Overruled.
Go ahead.
It's false.
Was there anything new brought up in that meeting as far as you were concerned? You were in both meetings.
He and his lawyer again reiterated the complaints and their conspiracy theory as they had done in the first meeting. I advised them.
Objection. Excuse me.
What did you advise?
Excuse me, Dick. The objection is non-responsive. The question was there anything new? Now Ranger Maxwell is going into what he told them. That's a different answer.
Sustained. It's correct. And I was trying to meet his objection by going to the next question. So go ahead. The next question is, what happened?
What happened? So during the meeting, they continued to lay out their objections about what happened in the search warrants and the conspiracy theory about how all these different individuals came together and falsified a search warrant during the middle of the search. And I told them that if they believe that to be true, then why aren't they in the office of the Inspector General's office for the federal government, which has the authority to look into any of these complaints? And the FBI, the U.S. Attorney's Office, the federal magistrate has to cooperate with them. And I asked them, why aren't you in that office?
Did you get a satisfactory answer to that?
They danced around the answer, but they said they felt like they were in the right place with us.
Did you receive any kind of documents to corroborate or to support that the search warrant had been changed mid-search?
They gave us some documents. They were supposed to give us all the documents, but when we reviewed the documents they gave us, it was not very much. And it certainly wasn't enough for us to really make a determination.
Even still, did you submit those documents to some experts within your office?
I did.
And what's the expertise of the people that you submitted these documents to?
This is my forensics section who does all the forensics on computers and cell phones for criminal cases. And we do that work not only for ourselves, but for the Texas Rangers and others.
All right. By this time, which is, that meeting was August the 5th, by this time, had you become aware yet that General Paxton had ordered Josh Godbee and Mr. McCarty to push a charity to settle in a lawsuit?
No.
Objection.
And by that time,
excuse me, Dick. Objection, leading and assuming facts not in evidence through this witness.
just asking if he was aware.
Sustained.
Were you aware that Ken Paxton had asked Ryan Bangert to change the state policy?
No.
Were you aware that General Paxton had asked Ryan Vassar to release details of that very ongoing investigation?
Objection. That's a misstatement of the record, and it's assuming facts not in evidence through this witness.
Overruled.
You may answer.
No.
Did you later become aware of those things?
I did.
We'll get to that. Let's talk just for a moment about the records of a search. What is the general practice in, at least in federal courts, for the sealing, that is, making private the affidavit, the application for a search warrant?
They are sealed to protect people who are involved, may have given information about the crime that's being committed, and also for the purposes of protecting the investigation so it can be ongoing and find the truth.
Are you familiar with orders of federal courts to seal documents such as these?
Yes.
In this second meeting, what was Nate Paul and his lawyer's demeanor toward you and Mr. Penley?
I think that they were maybe not as gracious as they were during the first meeting. I think they understood by this point that...
Excuse me, Ranger. Object to what he thinks they understood. That's conjecture and speculation.
Sustained.
Well, what my answer is, my question is not what you thought they thought, but what was their demeanor. So what was their demeanor?
It was a little more animated than the first meeting.
Did anything happen at that meeting to change your initial assessment of whether this should be elevated to the level of an actual investigation?
No.
To clear that up, when you got this, did you start an investigation, as that term is understood?
Ask your question again.
Yes. Did you start an investigation? Did you initiate an official investigation?
No.
What do you do when you start an investigation?
When you start an investigation, you assign it to an investigator group. That is assigned an investigative number and is put into the record.
And the reason that even after this second meeting, it had not risen to the level of investigation, what's that reason?
The reason was that the allegations had no merit, and we weren't going to do the investigation if I had anything to say about it.
All right. Even though, and did you make that clear to not only now Mr. Paul and his lawyer, but also Mr. Penley.
Yes.
Even though that was your position, did you agree to submit their documents to your experts within the office?
Yes.
Okay. So was there a third meeting?
There was.
When was that third meeting?
It was on August 12th.
Was it clear to you by then what General Paxton wanted done?
Objection, conjecture, and speculation.
Was it, well, let me clear that up. Was it clear to you from what
conjecture and speculation?
Actually, no, Your Honor, it's under 801E2D.
Counsel, you're going to make me look at these numbers, aren't you?
Yes, yes, Your Honor.
He's just trying to throw you off.
801E2E says that a statement such as this is not hearsay, particularly
with respect.
When it is, excuse me.
I'm sorry, you did go ahead.
Particularly when it was made by the party's agent or employee on a matter within the scope of that relationship. And here it's what General Paxton told to either Mateer or to Penley that was passed to the witness.
With respect,
that is not hearsay.
I'm sorry. With respect, Your Honor, there's a difference between what General Paxton said and what Ranger Maxwell can opine about General Paxton's state of mind. Those are two different things.
Not asking that.
You just did.
Sustained.
Well, let me ask it again then, if that's how it was understood. What message was passed to you by either Penley or Mateer that General Paxton had ordered done?
General Paxton wanted to have a third meeting.
I'm sorry. Objection. Objection, conjecture, and speculation. I have no problem with Ranger Maxwell testifying as to what General Paxton said, but there's a difference between what he said and what he wanted. I know it's splitting a hair, but objection, non-responsive.
Sustained.
What did he say he wanted?
He wanted us to tell Nate Paul that we were not going to be doing an investigation due to the results of our forensic analysis.
So going into that third meeting, is that what you believed it was going to be about?
Yes.
Was that meeting recorded like the first two?
No.
Who was responsible for it not being recorded?
General Paxton specifically told us that he did not want that meeting recorded.
Okay, so as you're going into a meeting in which you believe it's just for you to tell Nate Paul that you're not going to do his bidding, what happened?
The Nate Paul was there along with his lawyer, Michael Wynn. I had my two forensics experts, Mark Penley, myself, and General Paxton. My forensics people explained to Nate Paul the results of their forensic examination.
And very briefly, what was that result?
That the metadata that he was talking about that had changed could have been changed by the fact that there were documents he received had been electronically redacted and encrypted, which would change the metadata.
Is that a long way of saying there was nothing there?
Yes.
So, your understanding that General Paxton was telling you tell him not that you're not going to have an investigation. What was General Paxton's? What did he say during that meeting?
during the meeting, he was supporting Nate Paul's position, which was that we need to do an investigation. And he was pretty adamant about it.
Was that meeting heated?
It became heated.
Who became heated?
Nate Paul.
Before that meeting started, were you aware of any public statements that Mr. Paul had made about whether there was an investigation?
Yes, I was.
And what were those public statements you were aware of?
He had done an interview with a business journal and told them that the Texas Attorney General was investigating the FBI and their handling of the search warrants again on his property.
Was that true or not?
That is false.
In fact, you had not started an investigation, correct?
We had not, and I specifically told Mr. Paul that we were not doing an investigation at this point, and our meetings were confidential.
And the response?
Oh yeah, he responded.
What was his response?
He was very angry, and he said that he still has a First Amendment right. And I told him that all you're doing is using the power and the prestige of this office for your own purpose, and I'm not going to allow that.
Whose side in that dispute between you and Nate Paul did General Paxton take?
Nate Paul.
So, what was the significance of Nate Paul making a public statement that the Attorney General's office was investigating a federal magistrate and the federal authorities and the state authorities that the Attorney General was investigating? What's the significance of that kind of public statement?
Excuse me. Objection, conjecture, and speculation.
Sustained.
All right. Why did you think, what was your state of mind about why such a public statement when it was not true about the Attorney General investigating these law enforcement people? What was your state of mind about why that was improper?
It was improper because Nate Paul was a criminal, and General Paxton was using the office to try to his benefit.
Can the very start of an investigation into a public figure be damaging to that public figure?
Yes, it can.
I'm sorry.
Is that?
Excuse me, Dick. Pardon me, Ranger. Objection, conjecture, and speculation.
Overruled.
You may answer.
Repeat the question.
Yes. Can the very public start of an investigation against a public figure be damaging, almost like a tattoo to that public figure?
I got to object to leading in the tattoo. I'm sorry. Objection, leading.
Well, I'll reverse it. I'll take
Sustained.
the tattoo out of it.
Take the tattoo
Sustained.
out.
If I take the tattoo out of it, may I ask the question again?
I just sustain that. You can try whatever you'd like to and see what he objects to or not.
Is there a danger to a public official's reputation by publicizing an investigation by the Attorney General, and especially when it's not true?
Yes, very much so.
Is that the reason you're very careful about having a criteria for starting an investigation?
Objection, leading.
Sustained.
What is the reason you're careful about
We're careful because we don't want to put a stain on anyone's reputation. It has to be an investigation that is viable, has probable cause, and could move forward. This was not that.
All right. So let's talk about what happened after that meeting. Did you ever have any further conversations with Attorney General Paxton?
No, Attorney General Paxton stopped talking to me.
And your assessment at that time of whether General Paxton was angry with you?
Excuse me, conjecture and speculation.
It's his state of mind.
Sustained. You can ask it differently if you'd like.
All right. Your state of mind after General Paxton and you left that meeting was what? About General Paxton?
Unless he said anything, conjecture and speculation. He's got nothing to base it on.
Overruled.
You may answer.
I know his state of mind because in the meeting he threatened to fire me. So I knew then what his commitment was to Nate Paul, and he was not going to be deterred from continuing to try and do things that benefit Nate Paul.
During this period of time with these 3 meetings, had you called upon any of your subordinates, any of your other investigators to, other than to look at this metadata, had you called on anyone to assist you in this review?
No.
Why not?
I told my people that this was going to get me fired. I was going to take the stand, and I was not going to jeopardize any of their careers by involving them.
Why did you think it was going to get you fired?
Excuse me.
He demonstrated his commitment to Nate Paul.
Witness, hold on a moment.
Your state of mind.
Your objection?
Objection, conjecture, and speculation.
Overruled.
Where is state of mind? Yes, you may answer.
I think that we should probably show you guys this right here. This is about the metadata. This testimony is going to have to do with the metadata. And I think it's important because they were saying Nate Paul's claim was baseless. Nate Paul was saying that he was not left with a physical copy of any of the warrants or a specific warrant. He was looking for a lot of information because the FBI was conducting raids on his property. And as we know from the Dolce Fino report, there was like a shark frenzy, to foreclose on Nate Paul's properties during COVID. And part of the articles of impeachment say that, Paxton issued an opinion that's saying that foreclosure sales should be halted. But that was the same opinion as the Governor Abbott and as President Trump at the time as well. So it's just totally made up. But this is important because Nate Paul suggested that the metadata was altered. One moment. This witness must have missed the order that everyone needs to be back in the courtroom by the time Patrick's set, even if Patrick's not there. I apologize. Them's the rules. The metadata is important because Nate Paul suggested that the metadata was different between specific files for the search warrants. He wasn't left with a hard copy search warrant. I'm not saying he should run, but he could walk with a purpose is all I'm saying. He could act like he's got somewhere to be. I was impatient the other day. Right. But
Mr. Harden?
Thank you, Your Honor.
This testimony will discuss a little bit of the metadata and
Mr. Penley,
over it.
By the way, as we move into the things that happened in the month of September of 2020, did you yourself ever produce any real extensive notes as to what you remember about the events that occurred during that time? Not only turn it on, but lean up. Okay.
Yes, the answer is yes.
Look, don't give him a reason to yell at you about the mic.
And I produced a 7-page memo.
And have you asked, and therefore have with you, if you could have those notes available to you as we talk about the matters that go forward?
Yes, sir. I have them right here.
All right. Now, what I'm going to instruct you and suggest to you is, if at any time you think you need to refer them to refresh your memory, you can refer to them, but then testify from what you believe at the time. If your notes tell you something that you can't remember exactly, certainly want to be telling the judge and the other side that, okay?
Yes, sir.
Now, let's go forward. I believe you were at the stage of talking in terms of trying to assure the Attorney General you were willing to continue to investigate, correct?
Yes.
And what was your hope that if you continued to investigate, what was your hope that would accomplish?
My hope was I could dissuade him from believing that this investigation had any merit and should be continued.
All right. Now, at that time, were you personally upset with the Attorney General?
No, sir.
What was your mindset as to what you wanted to try to do for him?
I thought he was misguided. I thought he was biased against law enforcement to his detriment. I thought he was too aligned with Nate Paul, whether through friendship or as time went on, I began to believe other things.
I don't want to as time went on, okay? So having said that, we'll get to that. My point is when we're in the narrative. At the end of the day, when you reached out to the Attorney General, can you tell me, after you found out about the fact that he wanted to appoint outside counsel, did you, if we get to the middle of August, at that time, were you aware as who he had decided that he wanted to retain?
Not in the middle of August, but in the middle of September, yes.
All right. Approximately when did you become aware of whom he wanted to do the investigation?
That would have been on the September 14th meeting with Jeff Mateer.
All right. And then once you found out who it was, what was that he wanted to hire? What was the next thing you did in your involvement?
Well, I found that out on the 14th. On the 14th, I also spoke to Michael Wynn and kept trying to get documents. Then the next day, the 15th, I emailed Michael Wynn and left him a voicemail, no response. On the 16th, the Attorney General called me to his office.
All right. Now, when he called you to the office, had you down for 2 straight days been trying to get documents from Michael Wynn?
Yes.
And did you personally talk to Michael Wynn either of those 2 occasions?
I spoke to him on the phone for 5 minutes on the 14th.
What did you tell him?
I told him I needed the rest of their documents. I said, I've realized I don't think I have everything you got from the judge. Would you please give me the documents? And then he promised to get back to me. He never did.
So the next thing you heard about it was on the 16th?
From the Attorney General, the next conversation was the 16th.
And where did you have this conversation? Do you recall whether it was in person or the phone?
It was in person in his office.
And how did it come about? I mean, how was it? Did he call you? You call him? What?
He called me.
All right. When he called you, what did he say?
He said, come to my office. I want to talk to you.
When you did come to his office, what happened?
He said, what are these documents you're asking Michael Wynn and Nate Paul for? I want you to write down a list of the documents on a piece of paper.
Wait, stop a second. How would he know that you were still asking Michael Wynn for documents?
Well, I only know of one way, and that would be Nate Paul was calling.
For speculation.
Well, let me ask you this. Do you know of,
Dane.
excuse me, I'm sorry, Judge. Do you know of any way else that was part of your conversation on the 16th, or really, what was it? Was it the 16th with Michael Wynn?
My conversation with Wynn prior to that was the 14th.
All right. Do you know of anybody else besides you and Michael Wynn that was involved in your conversation asking him for additional documents?
The only other party would be Nate Paul, because he told me he was going to meet with
Objection.
Nate Paul.
Hearsay.
All right. So other than Michael Wynn...
Mr. Hardin, hold on.
Excuse me.
Hold on. The objection was hearsay as to what Mr. Nate Paul told Mike Wynn.
I sustained it.
Thank you.
Sorry. I think we were 3 talking over each other.
Thank you. Thank you very much, Your Honor. Now, let me ask you this. When the Attorney General asked you to write down the names, did he tell you, and the documents, was it the documents he asked you to write down?
Yes.
Did he, go ahead with the rest of that conversation.
He asked me to write down the documents. He asked me for Michael Wynn's phone number. Then the Attorney General told me that they weren't likely to give me any more documents because they didn't trust me. They didn't like the way the August 12th meeting had gone. They felt I was too aligned with Director David Maxwell. And then he said, I'll try to get the documents for you.
Well, have you ever experienced a supervisor telling you that since the person who's asking you to do the investigation doesn't trust you, he wants you to get out of it, and he'll try another, and then he'll go get the documents?
Objection, leading.
I believe. Let me ask you this. Have you ever had an experience like that?
No, sir, never before.
Well, did he say why he was going to go get the documents instead of you?
He did not say.
Did he offer any support for you in their allegation that they didn't trust you?
No, and in fact, starting on August 12th, he had not supported me.
So now you've got your attorney generals against you on this issue.
Yes.
And you're still, what was your policy or procedure as you were advancing, trying to still continue to find out if you could head off the special, not the special, but head off the outside counsel?
Well, number one, I was keeping Jeff Mateer informed of everything that was going on. I was sharing my views with him. He was my immediate supervisor. And so I frequently talked to Jeff in person or on the phone and updated him on everything I was thinking and doing.
All right. So were you effectively taken out of the Nate Paul investigation
because he was a rat?
Yes. Later, I realized the Attorney General had cut me completely out of the loop.
I wonder why.
But even at the time he did, had you ever indicated in any way that you were not willing to continue to look into the matter if they would provide you the documents they claim to have?
Objection,
leading. That is not leading.
No, sir.
Overruled.
Pardon me?
No, I never told the Attorney General I would refuse to investigate if they would cooperate.
All right. Had you ever experienced before anything concerning continuing getting off of investigation because you, or in spite of the investigation? Let me put it another way. Have you ever had an experience in which an investigation continues to try to help somebody who won't cooperate with you?
No, sir. If someone won't cooperate, that's a giant stop sign.
All right. Now, if I want, after the 16th, in your conversation with the Attorney General,
I wish it was like that for
when
the
was the
FBI.
next time
I wish
you
the
had
FBI
any
saw it that
involvement in
way.
this case?
The next time was on the 23rd.
Not really, but
23rd of September?
You know, sometimes.
Actually, let me back up. I had the meeting with the Attorney General on the 16th. One other significant matter occurred on this case that day that related to me, and that was in my email. I received a DocuSign email requesting approval or declination for an executive approval memorandum for an outside counsel contract for Brandon Kamek.
All right, can I, Your Honor, at this time, I'll move to introduce Exhibit
And
236.
what upset you about Brandon?
I believe it is not in evidence.
It is not.
I show it's not. I'm going to check with the true person. Thank you, ma'am. Can I have one? No.
It's no mystery to anybody why this guy was taken off.
Any objection?
He's
briefly,
a gossip
if I may,
girl.
Your Honor.
He's a rat. He was feeding information to the people that Nate Paul and A.G. Paxton thought were mishandling the investigation.
House
and we're
Managers
being
236.
little assholes about
a
it.
partial
You know what I mean?
image of a DocuSign report, or what I'll call a completion report, but it doesn't go to the bottom and include Mark Penley.
Your Honor, if I may, this is the cover page or one of the pages that will reflect what was happening with the document. It's already, there is a draft of it in evidence. I'll get that. If they object to this, then
it's just simply incomplete. We can't see what Mark Penley did and the dates at the bottom of 236.
That's fine. In the interest of time, I'll be glad to
Sustained.
move. Thank you.
Have to do better than that. That was Someone's going to get chewed out for that one. Simply could have printed off an additional page, right? Whoa, I wonder what their point was.
Now,
we'll never know what their point was.
In the conversation that you had with him on the 16th, the other matter you said that you didn't complete was what?
The other matter on the 16th was I received the DocuSign email.
Right. And what was the significance of you receiving that?
The significance was it was office practice for certain contracts to be approved by a number of people in the chain of command. And since this matter involved a criminal investigation, it was routed through me, and it was to go on to other people. The last signer was to be Jeff Mateer, the first assistant.
Did you sign off and agree to this contract for Mr. Kamek?
I did not.
And on the 16th of September, did you do anything in relation to it?
No, I saw it was there. I knew I wasn't going to approve it. I didn't touch it.
And if you didn't touch it, does anything happen with the contract until you, the division involved, sign off on it?
It should not have.
All right. And then when's the next time you had any
That's
contact
just a policy.
with anyone
That's
about
not
it?
the law.
The next time I had any news
That's
about
just how
the
y'all
Nate Paul
decided to
matter
do
was
it.
on the 23rd.
And what happened on the 23rd, and what was your contact and with whom?
I had contact with Ryan Vassar. I got word that the Attorney General was asking where the
Section hearsay?
It is. You're absolutely right.
Sustained.
You're absolutely right.
Thank you,
I
Counselor,
got
for that
word.
help.
I
Thank
got
you.
word of it.
Thank you, Otter. So did you get a talk at all to the Attorney General during this time frame?
not between the 16th and 23rd, but I did on the 24th.
All right. On the 24th, where did you talk to him?
He called me on the phone. He told me he was at the White House. He said he just left a meeting in the Oval Office, and he wanted me to approve the DocuSign executive approval memo for the outside counsel contract.
What do you remember
Boy, it
about
sounds
that
like
conversation?
it sounds like you should have
I
signed
remember
it.
we talked for about 10 minutes, and that was the day that I drew the line with the Attorney General that I would not cross, and I never did. I said I would not approve the contract. I said,
hold on.
Object, non-responsive.
He does not have the authority to say that kind of shit to the Attorney General. What in
Just
the
as
world?
best you can remember, tell us exactly what and how he said, what he did, and then tell me your response to it.
He said, Mark, I'm at the White House. I just left a meeting in the Oval Office. I understand that the executive approval memo is with you. I need you to approve that contract.
At that time, were you aware one way or the other whether the contract had been signed by the Attorney General?
You should have signed it. Sounds like you should have signed it.
There you go. Did you
What
know?
other than a mutiny would have prevented
All
him
right.
from signing it?
And so at the time, what was your level of knowledge of the status of the contract?
That it was stuck in my email inbox and it had not been approved through the normal office procedure because I wouldn't approve it.
All right. What did you respond to the Attorney General?
I said, Ken, I cannot approve this, and respectfully, I will not. And I told him why.
He is not the Attorney General. Ken Paxton is the duly elected Attorney General.
What you told him as to why you were not willing to approve that contract.
I told him that Nate Paul and his attorney were not being cooperative with us by giving us all the documents that I believe they had. They had gone to the media. Furthermore, there was no evidence of any crime. We had absolutely no scintilla of evidence that any criminal activity had occurred on the part of the federal agents, the state agents, the federal prosecutor, or the federal judge. And I said, ethically, Ken, I can't proceed with this investigation. And I'm the senior prosecutor in the agency. And if it's not right for me to do it, it's not right for me to delegate it to anybody else. I won't sign this.
What was his response?
He said, well, we'll have to disagree on this. I've got to go to a press conference. We'll talk later.
What was your history with the Attorney General as to how he would handle
authority to hire him as the duly elected Attorney General
with you
of the great state of Texas?
Well, by this time, I'd realized he was very passive aggressive.
And what do you mean?
I mean, he'd say something was okay or indicate he accepted your opinion one day, and then you'd find out later he had gone around you or he was disagreeing with you, but he wouldn't
Whoa,
come and
he's not
tell me
allowed
that.
to disagree with you. So
So
he would
over
respectfully,
the months that this had been going on, had you become aware of anything involving Mr. Paul and the Attorney General? And this is as I'm really at the day of the 24th of September. Had you at that stage become aware of other incidents that were occurring, or were you pretty much just knowledgeable of about the events that were affecting you?
I had heard a little bit about.
I don't want to hear what you heard. Only that have you had heard things?
Yes, I'd heard some things, not much.
But as a practical matter, day by day, was your knowledge of things with the Attorney General and Mr. Paul pretty much generally restricted to the things that you've been telling the jury about that involved you?
Yes, my knowledge was siloed.
All right.
I didn't know about
I
these
don't
other issues until
believe
later.
that.
All right.
I do not
Now,
believe that.
on the 24th, when you told him that, and he said, we'll just have to disagree.
Yes.
When was the next time you heard from him?
He called me again on the next day, Friday, September 25th.
And do you know where he was at that time?
I don't know.
And what did he say then?
He said, are you available to meet with me tomorrow?
What did you tell him?
I said, yes.
What happened? So what happened?
I said, can I assume it's about the matter we discussed yesterday? And he said it was. And then we talked about scheduling.
Where did he want to meet and when?
He wanted me to come to McKinney. I told him I had an event to go to in Denton in the middle of the day. I said, I'll meet you before or after. He asked me to meet with him at 2:00 in McKinney. He said he would text me a location, which he did later that day.
All right. So then, did you meet with the Attorney General of the state of Texas regarding Nate Paul and the contract for an outside lawyer to investigate? Did you meet with him about that matter on Saturday, September the 26th?
Yes, sir.
What time of day and where did you meet?
The meeting was scheduled to begin at 2:00. I was there before 2. He arrived about 2:20 or 2:15. We met for an hour and 45 minutes.
And when he got there, where did you go? Where did you meet?
Well, he asked me to meet in one coffee shop, a Panera Bread, and I was there. He came inside and let's go sit outside. And he crossed the driveway. There was a Dunkin' Donuts across the driveway that had an outside table with an umbrella, and he wanted to sit there.
So unlike what we're experiencing so far right now in September, was it a September day with more normal weather that was cool enough to comfortably sit outside?
Yes, sir.
All right. And then who began the conversation?
He did.
What did he say?
He said he was frustrated. He said, I felt like I did when I couldn't get Chip Roy to do what I wanted him to do. My staff's not doing what I'm telling them.
Chip Roy was the previous first assistant. Is that correct?
That's correct.
Well,
what did you respond to that?
Well, he then went on to talk about he wanted me to approve the contract. He was upset that I hadn't approved it or that Jeff Mateer hadn't approved it.
I want to go back, if I can, to whether or not you did any preparation for this meeting.
Yes, sir, I did.
Tell the jury what you did in anticipation of this meeting.
Well, in all honesty, I woke up at 5:00 in the morning and I felt like the Lord woke me up and impressed upon me that I needed to get ready. This was a serious situation. Again, I felt like my job was in jeopardy. I didn't want to get fired. And I was hoping that I could get Ken Paxton to listen to reason. And so I did my morning Bible reading. There was a verse in there. It said, do true justice, Zechariah 7:9. And I wrote that on the top of my notes. And then I proceeded to write out a bullet point outline with all the problems with proceeding with the investigation of the Nate Paul matter. And I wrote down things that I felt like he needed to understand that were a danger to him personally.
This is very important. I believe God did tell him to make that list because it is very important to map out the dangers of navigating the deep state and their little mouse traps that they set up. I believe God did tell him to write
before the meeting. I have marked this as Exhibit 214. It's not in evidence, but I wonder if we have a copy we can show him that's clean. Mine's got all kind of markings on it.
Sure, I have a copy here.
Pardon me?
I have a copy.
I know, but I want to show you one that's got the exhibit.
Because regardless of what Nate Paul was doing, I want to know what was going on with that. But we need to have recourse
Identify it,
when the
but I don't want
FBI
you to
is
testify while
abusing
we're
our
doing
rights.
it yet. I want you to look and see if that is a true and
And
accurate
they can't
copy
impeach
of the
an
notes you
attorney
prepared
general
in
because we ask
anticipation of
for
meeting with
help.
the Attorney General.
Yes, sir.
All right. Would you look at, there's a 2-page notes? Well, it's 3 pages, really, isn't it?
It's front and back copies.
All right.
There are 3
We
pages.
need recourse, and they can't do this to people that try to help us get
I'm sorry,
recourse.
there are 3 pages.
I've done it much more times than you have. All right. And in do those notes accurately reflect your thoughts that you were reducing to writing in anticipation of discussing this subject with the Attorney General?
Yes, sir.
Your Honor, I'll move to introduce. These been produced. Both sides have these. Actually, I would think we received these notes from the Attorney General's office in the production. Or actually, we got them from Mr. Penley. Excuse me.
Any objection?
Yes, Mr. President. Mr. Hardin has not provided me a copy of the document, but I'm extensively familiar with it. It's hearsay. These were not notes from a meeting with the Attorney General. These were the out-of-court statements of Mr. Penley expressed in an outline prior to the meeting. And hence they are inadmissible hearsay.
Okay, but do we have a copy for the attorney, for the court?
Thank you very much, ma'am.
Does the court have a copy? Oh, thank you.
I'm going to sustain the objection.
Thank you. Now, these notes that you have, are these copy of these same notes that we've talked about, Exhibit 214. Do you have them up there with you?
I do.
Can you tell the jury in general, set from your own memory, all the things that you planned you were going to tell him?
Yes.
Hold on. I believe that Your Honor sustained my objection to hearsay, and so any testimony from this document would also be proof of that hearsay.
That's weird.
I didn't ask him to testify from it. In fact, I asked him the exact opposite. I said, simply put them down. Now tell us in your own mind. And if you need to refer to them to remind yourself or something.
No,
but my
another
questions to you are
backdoor way to
directed
get
to what you
hearsay
told
admitted
the,
into
what
court.
you planned to tell the Attorney
He's
General.
good.
Right.
In both tone and content for this meeting of the 26th.
Overruled. Continue.
Wow.
Continue.
Whatever. He's good.
Sir, what I planned to tell the Attorney General was, number one, this was a very dangerous investigation for him to continue. He was a friend of Nate Paul's. Nate Paul was a campaign donor to him. There was no
$25,000
evidence
and
of
Ken
any
Paxton
criminal
raises
wrongdoing.
millions and millions
There was no
of case.
legal basis to continue the investigation. There was no ethical basis to continue the investigation. In fact, I felt it was unethical to continue. I felt that Nate Paul was trying to manipulate me and Director Maxwell and the Attorney General to do an investigation that had no merit, and we shouldn't be doing it. And then I also told him there was great risk to him. This could look like bribery. This could turn into a criminal charge against him. I told him this could turn into a media scandal if it got out. I said, you should not be doing this. Please back away from this. Let me handle this my way. And then I had a section where I wanted to go over with him the practical difficulties of doing the investigation that he wanted us to do. As I explained previously, the issued set of search warrants were still under seal at the federal district clerk's office by federal court order. I had no way to get access to those. The original computer that the forensic experts
Mr. President, I need to object to the narrative testimony. This needs to be
He's
responded
basically
to.
just saying he wasn't able to fully investigate that, and he didn't know a mechanism that would allow him to. So we need to map this out so we can figure out a mechanism in order to be able to investigate the
Yes, I told him all of those things and many others.
And I'm about to ask you about the many others. So let's go now to the 26th itself. You get up in the morning, you write all these things out that you've been testifying about. What else did you tell him in an attempt to persuade him to drop the Nate Paul matter?
How do we investigate the investigators?
Number one,
when they're violating
I
state
told him,
citizens' rights.
I don't know Mr. Kampnick. I don't know his experience level. It's my understanding he's never been a prosecutor. I'm not going to supervise him. He told me at that meeting for the first time that Mr. Kampnick had already been hired and was working and had been working on this for at least 2 weeks. I did not know that.
What did you say in response to that?
Well, I said, I won't supervise him. And he said, don't worry, I will.
Well, did you know anything in the background of the Attorney General that would have qualified him to supervise a federal, or not a federal, but a state prosecution investigation?
Nothing whatsoever.
So when you said you wouldn't supervise him, he said, don't worry, I will. What did he say then?
Well, I think the conversation shifted at that point, and I was trying to tell him, stop Mr. Kamek. In fact, this was at the end of the meeting. I had two recommendations for him. Stop Mr. Kamek and talk to Jeff Mateer about a way to get Mr. Kamek paid for whatever he's already done. That was one of the Attorney General's big issues in the conversation. This guy's working and I've got to pay him, and you won't sign the executive approval memo, so I don't have money in the budget to pay him with. And then he threw out, I spent $50,000 on my personal lawsuit last month. And then he made comments about his distrust of law enforcement and his concern about.
What did he
Yeah,
say
we're
about
all
law
there.
enforcement?
We're all there
He
with
said,
him.
he said, you don't know what it feels like to be the target of a corrupt law enforcement investigation. I've spent $50,000 on my case, things of that nature. He made many comments to me, or several, I'll say several, during the course of these months that indicated he had a negative attitude and a distrust of law enforcement.
Did he
And
particularly ever focus on
And?
DPS in his negative attitude?
Yes, I've heard him make negative comments about DPS.
Like what?
He doesn't trust the director, and he feels like the DPS ran a corrupt investigation on him in the securities fraud matter.
all right, well, hey,
Did he have the same feeling about the securities board?
I did not hear him talk about the securities board.
All right. Were you aware one way or the other as to whether a representative of the securities board had been involved in his search warrant?
Yes, I knew at least one of their agents was a task force officer with the FBI on the searches.
And do you know who that officer was?
Yes.
Who?
His name is Rani Saban or Saban.
Will you spell Saban or Saban for the court reporter?
Sabban.
How would he know? Do you know who? Let me back up. In your meetings with him, back starting in July and into August, in one of those meetings, was there a conversation with him and these are the three meetings we talked about,
Yes, sir.
in which he specifically addressed the issue as to whether Agent Saban was actually the applicant for the search warrant?
Objection, leading.
Did you ever hear?
Sustained.
Did you ever hear anything from him during those meetings with you about Agent Saban?
Yes, sir. You talking about Nate Paul's comments?
Yes.
Yes, I did.
And in the meetings, did you ever hear him say that Agent Saban was the affiant in the application for the search warrant?
Objection, hearsay, as I understand this to be Mr. Paul's comments offer for their truth.
Sustained.
Did you discover at any time that Mr. Wynn and Mr. Paul knew the identity of the agent that signed the application for the search warrant?
Objection, hearsay. If necessary, I will take this witness on voir dire to establish that the basis for his knowledge is hearsay.
Sustained.
Did you ultimately discover that these folks in your meetings knew who had been the applicant in a search warrant that was sealed, application that was sealed?
Same. Objection, hearsay. And I'm happy to take this witness on voir dire to establish that.
I asked
I
if you
actually
ever
want to
became
know the
aware.
answer to this too.
Now, would anyone be able to know the identity of the agent that signed the search warrant, the application for the search warrant, if they had not had access to a sealed document?
Objection assumes facts not in evidence and calls for this witness to speculate on that topic.
Let me ask you
What
this.
are they trying to
Did you
establish?
review the grand jury subpoenas that were ultimately served by Mr. Kamat?
Yes.
Did you see the name of Agent Sabat on there?
Yes.
Would Agent Sabat's identity be known to anybody that had not seen the sealed document?
Objection calls for speculation
To
again.
your knowledge.
Sustained.
Now,
So they're trying to establish that Brandon Kimmick somehow obtained the sealed warrants and affidavit.
do you remember back when the presentations, you make it a PowerPoint
And
presentation?
sent a subpoena to the agent. He wouldn't have had the
Yes.
agent's name unless he had access to the sealed
And do you recall what that PowerPoint
affidavit.
presentation was called?
Yes, sir, I do. It was called
FBI
Operation
used to grant the warrant.
Longhorn.
Was that
That they used to search
PowerPoint
Nate
presented
Paul's
to you by Mr. Wynn and Mr. Paul?
Yes, Mr. Paul specifically.
Can I have the exhibit number, please, of the PowerPoint? It's in evidence. In fact, I think it was introduced by the other side. Oh, that's okay. I think she's bringing it up.
It's in evidence.
Could you put up exhibit 152, please?
We can open records request all of this. So I'm writing some stuff down that we want to request. Want the Maxwell interview, the second interview, and then the Nate Paul PowerPoint. That's exhibit 149,
Now,
156, and 152.
Go to the next page, please. Do you recognize this exhibit, please?
I do. That's the document Mr. Paul gave me at the August 5th meeting.
Fine.
One moment, please. Can you confirm, Mr. Harden, that everything has been redacted from this was the
Thank you very much. No, thank
piece
you
of
very much.
evidence that we paused to redact information?
I
Will
want
you
to make
confirm that?
sure.
I saw 2 thumbs up from Stacy.
Two thumbs up says it has been, Judge. And we've done that in light of the other presentation. Thank you very much. In this search warrant, if we could, search warrant discussion rather, it talks about when it was executed, all right? And it says down at the bottom, I'll read that to you. According to the filings with the court in the Western District of Texas, each of these warrants was signed and issued by Judge Mark Lane at 10 a.m. Is Judge Mark Lane one of the officials they wanted investigated?
Yes, he's a federal magistrate judge in Austin, and they wanted me to do a criminal investigation on him.
All right. Next page, please. Now, this sets out, does it not, that they have discovered through a forensic analysis of the metadata and what we've been talking about before. And it was emailed and given them by Alan Bew to the council's Chuck Meadows and Ayer Board. Those people were back in August 14th of 19 were representing Nate Paul, correct?
Yes, my understanding was at that time he was represented by Austin attorney Jerry Morris and the Dallas law firm of Meadows and Collier.
Next page. Now, they point out to you that below is pertinent to how we discovered through a forensic analysis in the document that had been mailed by the federal prosecutor. Alan Bew is the federal prosecutor, right?
Yes, he is.
Okay. Then they give us the data that they've got there as to where this server is located. Can I have the next page, please? They have the addresses where the search warrant was to be executed on, right?
Yes.
Next page. Now, do you have any idea how they would have all this information? Now, answer yes or no first.
Objection calls for speculation.
Do I have any idea?
Hold on, Mr.
The question was knowledge. I just have to add any knowledge of it.
If you can, answer yes or no.
Yes, I have some knowledge.
Can I have it talks, does it not, about Mr. Saban, does it not?
It does. It mentions his name at the top.
All right. Do you know if he appears in any of the document of the original search warrant itself? Have you looked at that to see of the part that was public, if his name appears at all?
Objection, lack of foundation for this witness's personal knowledge of that.
I asked if he has read the search warrant.
Sustained.
That was public. Let me try again, Your Honor. Have you looked at and reviewed the search warrant that was public information, is and was the search warrant that was ultimately given to the attorneys of Mr. Paul after the search?
Yes, sir.
On anywhere on that search warrant, does it mention the name of Mr. Saban?
No, sir, it does not.
Next page.
Because it was redacted? Is that why?
It lays out, does it not, the things that they're complaining about, right?
It does. And these were things we told them we had no jurisdiction over.
Next page. Now it has people of interest. And are these people that they wanted you to investigate?
Yes, they wanted us to investigate each of these people.
Would you go down the list and see why, and tell us what they told you, or what these people they were requesting to be investigated roles were?
Yes. Randy Saban was on the task force. He was at the search warrant that was executed at Mr. Paul's residence. Mr. Paul stated he had personal conversations with him during that search. Agent Joy of the FBI, he was mentioned. I don't know which location he searched. They represented that Ms. Sobravia Dent was a courtroom deputy clerk to a United States magistrate judge.
Yeah, can you explain to us why in the world you were supposed to investigate a courtroom deputy clerk of a federal magistrate?
I have no idea how there's a state interest in doing that. The federal authorities have full control over the federal district clerk's office, and their law enforcement and their inspector general's office has the full ability to go in and get all the documents needed to do such an investigation. We did not.
All right. Now, and if I have the next page real quickly, let's move through this. They give you information. This man that they want you to investigate was actually a member of the board of the agency that had brought the charges against the Attorney General, correct?
Yes, I became aware of that.
All right, that's it. That's all I need there. Did it have personal data about him that has been extracted from this?
Could I see that page again?
Yes. No, you have the page. If you know, if you don't know,
and I'm sorry, could you ask the question again?
Let's move on. You can take that down, but there were the code words in this thing, weren't there?
Yes, there were.
Well, did you have any idea what they were or what they were supposed to represent?
Oh, Operation Longhorn.
Hold on. Other than, well, on top of
Excuse me, try not to talk over each other for the court reporters.
Yeah, absolutely. Thank you, Judge. Your Honor. Were there different little code names like Longhorn and other things? You remember what any of them were?
Well, the only one I knew at the time was Operation Longhorn. I've learned some since this summer.
All right. Now, if I can, at the end of the day, on the 26th, when you were talking to him that Saturday, you've talked about almost 2-hour conversation.
Yes.
Do you recall at the end of the conversation, do you recall anything else that the Attorney General said to you in response to your urgings that you've described to the jury?
May I review my handwritten notes to refresh my recollection, because there were many other things discussed?
Yes, don't read from the notes, but you can look at them and see if that refreshes you.
All right.
To be clear, Mr. President, I do not know what notes he possesses up at the stand, and I would like to at least be able to review those.
I thought we gave him 214. If we did not, could we please?
214 are not notes, Mr. Harden. That is his outline from before the meeting. So if he's using that to refresh his recollection, he will be using a document that has been overruled as hearsay.
Which, in more years than I'd like to admit, a witness regularly does. So that is not
an expert witness.
Excuse me. That's not a legitimate evidence. This man has brought up his notes. They're not in evidence. They've objected to him. He is certainly allowed to look at documents not in evidence to refresh his memory. He just can't read from them.
Would you show counsel these notes?
And Mr. President, what I would like to do is take this witness on voir dire to establish that. Wait, hold on a second. You said 214. This is 216. So you're asking him to review 216? These are his notes. 216 is.
Pardon?
Okay.
I've got a bunch of voices around
Got a lot of
here.
people
I'm
talking
sorry.
to you.
Go
Are you
ahead.
asking him to review 216?
He was you're right. You're right.
These are his notes.
Excuse me, just so the court knows what we're talking about. 214 is the document that he planned of what he planned to talk about. He's right. 216 is what I'm asking to look at and what he was about to look at. So I just gave you the wrong number. If you want 216, well, if you have 216s produced, you have
No objection to 216. I plan to introduce it as well.
All right, neither one of them to answer your question earlier.
Have we settled this, councilors? No objection
I believe we have.
to what he's going to read from? Okay.
All right. Now, if you reviewed your notes from the day after, did you type up those notes, write those notes by hand before or after, during, when did you do it, the meeting?
I wrote these notes when I got home that evening after the McKinney meeting, and they're handwritten.
Have you reviewed them?
No, sir. If I could have a minute, I wanted to be sure I had permission
Go ahead.
to.
All right, that's enough time. That's enough time. I need the Jeopardy music. I do like his pumpkin.
Yes, sir. I've reviewed the notes.
All right. Was there anything else you called? Does that help refresh your memory as to whether there was anything else in your discussion that the Attorney General said?
Yes, there were several things. Number one, I asked him why he was so interested in this investigation when he was not interested in all the other criminal investigations and cases we had pending in the office.
All right. What was his response?
His response was, I don't know about the other cases, but I know about this one, and I'm concerned about corrupt law enforcement because of what's happened to me.
All right. Anything else you recall he said in that conversation on the 26th?
We discussed the fact that he had taken Nate Paul personally to the Travis County District Attorney's office.
Did you ask him or did he volunteer that?
I told him I had learned that. By this time, I had heard that.
And what was his response?
His response is, well, I didn't request the investigation from them. They had a conflict and they asked me if I wanted it, and I said yes.
All right. What else?
I told him there was no state basis for believing there was any state offense, and he kept bringing up Nate Paul and Michael Wynn's complaint that the agents hadn't left us a copy of the search warrant at the residence or the office, allegedly. I don't know if that's true or not.
Is that something he wanted the Attorney General's office to investigate about?
Apparently he did, because he told me that the fact that I didn't think that was serious, which I didn't, and I explained to him why. That's a federal rule of criminal procedure. That's not even a misdemeanor statute. And that's something the magistrate can deal with very easily if it's true. But he said
a really big no.
That
Not
was
if
a
they
red
changed
flag
it
to him that
afterwards.
indicated I was too biased in favor of law enforcement.
I agree
How was
with
the
him.
tone
I
of this
agree with that
conversation?
analysis. I agree
He
with
was
the duly elected
frustrated,
Attorney General.
and
Imagine
that was the most. It wasn't a hostile conversation, but it was a difficult conversation.
This fool is not the duly elected
I
Attorney
told
General.
him
Sorry,
that
let me stop.
I was trying to be a loyal subordinate and a friend.
No,
And I
that's not
still
what we're
considered
getting.
myself a friend, even up to that very day. And I was trying to walk him back from what I thought was a dangerous line he was trying to cross. And I told him all my reasons, that he could face criminal charges, bribery, other things. It could be a media scandal. He could get himself in a lot of trouble. He needed to leave this alone, to back away from it. I explained all the practical investigation difficulties, that we shouldn't be trying to investigate the feds. And there were many things we couldn't investigate. We didn't have the power. We didn't have a way to get at those sealed search warrants. And if I'd called the U.S. Attorney's Office and said, can I see your file with the original search warrants, they'd have laughed and hung up the phone, and I would have understood why. All that was under privilege at the U.S. Attorney's Office. They had an active investigation of Mr. Paul.
So how did when the conversation was over?
But the claims were that it was an unlawful investigation. It was abuse.
The way I left it was I made 2 recommendations, which he didn't object to and he didn't disagree with. But then I found out later he obviously didn't act on them. Number 1, I said, stop Kamek from working and talk to Jeff Mateer and figure out how to pay his invoice and don't let him work anymore. Number 2, let's you and I meet with Jeff Mateer. I can explain some options we've got. I don't think they're great options. You may want to pursue them, but
they
I
really
think they're a
wanted
risk
to
to the
stop
office.
Brandon Kamek
One
from
of those
investigating
options
this,
was
and that's
calling
weird.
the United States Attorney's Office, talking to one of the supervisors, see if they would just assuage our curiosity and tell us if there were any changes between the return version of the search warrant and the issued version.
Oh, that's funny. That is so funny.
He didn't say anything to that.
Funny.
He just said,
you
well, I've got to go. I've got
a
a dinner to attend. But he didn't agree or disagree.
After that conversation on the 26th, without going into what you said, did you call Jeff Mateer and update
That's how
him?
you wanted to handle it?
Yes, immediately after I left the meeting.
And then after the 26th, when was your next involvement with anything having to do with Mr. Paul?
That was on the morning of Tuesday, September 29th.
And without going into what people told you at this time, what happened on the 29th?
Mr. Kamek and Mr. Wynn served a search warrant in the name of Brandon Kamek, Special Prosecutor, Office of the Attorney General of Texas, on Independent Bank in Round Rock.
What was your reaction to that?
I was apoplectic.
Why?
Because it appeared to me that Mr. Kamek was working on behalf of Nate Paul's civil litigation interests and serving a criminal process, a grand jury subpoena on either a bank or a party to one of his civil lawsuits. He was seeking discovery through using criminal process.
Has the Attorney General ever said anything to you in his conversations that Mr. Kamek was a special prosecutor?
No, at this point in time, the only thing he'd ever told me was that he was working and beginning to gather information. He never told me a title.
All right. What happened on the 29th when you found out that a community bank had been served a grand jury subpoena?
Well, Jeff Mateer called a meeting in his office at 3 o'clock for the deputies involved that became the whistleblowers.
At the end of those conversations, did y'all make plans to go to the government?
No, not that day.
All right. And then what happened on the 30th?
On the 30th, in the morning, we got another message that a second subpoena had been served, this time on Amplify Credit Union in Austin.
Where are they getting these messages
what was your reaction to that?
being served from?
I was even more apoplectic. I was furious that this was going on and the Attorney General was allowing it.
And what was wrong with serving the grand jury subpoena on Amplify Credit Union?
Maybe they
Because again, this looked like Nate Paul was using the power and authority granted by the people of Texas and this legislature. He had turned it over to Nate Paul for Nate Paul to go after his business opponents.
I asked you what was his objection to it.
That doesn't seem like what Nate Paul was alleging at all. Nate Paul was alleging that the FBI was manipulating those warrants. They wanted to see the original warrant given to the bank.
What was wrong with what they were doing?
Number one, these banks had nothing to do with referral number one, which was the only referral we knew about. Number two, you can't use criminal process to conduct civil discovery. And that's what it appeared was going on because Mr. Paul's attorney was with Mr. Kamek at both banks.
In all your years, first of all, have you been involved with the prosecutor was the one serving the grand jury subpoena?
So if the executive branch agencies hide behind
usually the one serving
civil
grand jury
issues,
subpoenas?
A deputy, a federal marshal,
Then
depending.
we're not supposed to
And then,
consider what they're doing.
have you
criminal.
ever heard of the
And
lawyer
constitutional violations
for the
tend
person
to be civil
bringing
rights,
the
right?
complaint who's also under a federal investigation accompanying the prosecutor serving the subpoena?
No, in fact, the Code of Criminal Procedure doesn't allow that.
Non-responsive.
I'll get to that.
Sustained.
What is the law in terms as to whether or not a person representing the complainant can be involved in that circumstance?
The law says you can't. An interested party cannot be involved in serving a grand jury subpoena.
Now, after this, on the 30th,
Brandon
did
Kamek
you,
was
as a
investigating on
group,
behalf of the
ultimately
Attorney
go to
General's
the
office
to
based on
go
a
to the
complaint that was
FBI?
referred to them by
Yes,
the
after we
Travis,
learned about the second grand jury
Travis County
subpoena
DA.
being served,
He
we
was
were
not doing it for
extremely
Nate Paul.
concerned as a group. I was extremely concerned personally, and we decided we had to go to law enforcement.
And why did you go to law enforcement?
Because this had to be stopped. The Attorney
Because it
General
was a
obviously
mutiny,
wasn't
because they
listening
were
to anybody.
mutineers.
He had turned Mr. Kamek loose. We didn't know what Mr. Kamek was going to do. It appeared that Mr. Paul was
So
controlling
get
this.
AG Paxton arrested and impeach him. Really?
I asked him why.
Really?
I asked him why he went. What was in his mind? Let me ask you this: what did you expect the consequences being of your going to the FBI?
I feared we would get fired.
And was that the sense and mood of the whole group?
I think so. I think we all knew this was an incredibly dangerous and unique but outrageous situation. We were the only ones that could stop it, and we had to.
It was
When
a
you went
mutiny.
to the FBI,
There you go. There you go.
did you take any documents?
Did not take any documents.
Would the documents all been the property of
They
the
had
AG's
no
office?
evidence, no
So
documents.
is that
they
why
didn't
you
take
didn't
anything.
take any documents? Just yes or
Objection
no?
leading.
Why did you not take any
Sustained.
documents? Excuse me. Why did you not take any documents?
I didn't take any because I felt like we were making the initial report based on our eyewitness personal knowledge of what we believed at that point to be criminal behavior by the Attorney
How
General.
rich is this?
And
Nate
so,
Paul
and when
brings
you
them
went,
evidence of what he thinks
did
the
you
FBI
take
is doing
evidence
to him.
with you?
They
I
don't
took
treat it
my
take
personal
it
knowledge
seriously.
and the others
Then
took
they take
theirs.
All right.
gossip
Is
and
that
hearsay.
evidence?
Absolutely. We were eyewitnesses.
So
No.
if a person is the victim of an
No, because
aggravated
they
robbery
no. Mm-mm.
and reports it to the police,
Eyewitnesses, but not of what you're
would
reporting.
it quit being evidence if just they report it as opposed to taking documents?
No, but if they
Objection
witness a
leading
robbery and then
Their
report,
personal experience.
Hold on.
you know,
Sustained.
a murder
What
and
did you
afraid the
take
Attorney
with
General,
you
that's the problem.
that would first of all of y'all going,
Yes.
did you take evidence in the meeting of evidence?
Yes.
What did you take with you that was evidence?
Our personal eyewitness knowledge, our personal experiences, our personal conversations with the Attorney General, our personal experience
You
of him
took your
being
plan
of
to
him
overthrow the
pressuring
Attorney
us
General
to
to
do
the FBI,
things
who was
that were
already targeting the
improper,
Attorney General and Nate
unethical,
Paul.
and illegal.
In your experience, how often is the initial report by a citizen of something that they consider criminal conduct? How often is that where the witnesses come in without any documents just to tell you what they believe, they saw, they know that they think is improper? How often is that the way it gets to your desk?
Objection relevance.
Oh, it's very relevant.
Overruled.
I actually
Yeah,
think
thank
it is. I think he's
That
building
is very
Paxton's
common.
case right now. This is kind of crazy
So
to
if a
watch.
person walks in to report what they believe is a criminal offense or improper conduct that should be investigated, do you send them away if they don't have paper?
No, sir.
So what is your testimony as to whether or not, how much, from how many people,
But if
evidence
there's
was
no
presented
evidence,
to the
yeah.
FBI with the request for them to investigate?
The meeting lasted almost 4 hours. It consisted of us sitting around a conference table with 2 FBI agents, and our attorney, Johnny Sutton, was present. The FBI agents asked us to go around the table in turn, starting with Jeff Mateer, and tell our entire story. And as I said, it took almost 4 hours. That was 4 hours of eyewitness personal knowledge from people directly involved with the Attorney General, the events I've described, and the events the others were involved in, the
Hey,
others
guys,
being the whistleblowers.
Imagine if they cared this much about securing the border,
Mr.
you know,
Penley,
for example.
after that meeting, did you yourself file any documents to attempt to or to quash the subpoenas that you had learned had been filed?
Yes.
Yes or no? That's all I'm asking you.
Yes.
And why was it that you filed a motion to quash those subpoenas?
Because those subpoenas were improper and they had to be stopped.
And what was improper
If they
about
put
those
half
subpoenas?
this energy
Number one, Brandon
into fighting
Kamek
for
was not a
Texas,
special
then we could have secured the
prosecutor,
border
yet that's
already.
how he
Biden
represented
administration.
himself to the Travis County DA's office.
Now, at the end of the day, after
But as
those
we
subpoenas were
see,
quashed,
instead of fighting the deep state,
what
they're
happened as far as
effectively
with
protecting the
you
deep state.
in
This
terms
is
of
incredible.
whether or not you went to the media or anything else? Did you?
I've never gone to the media other than I think our attorneys filed, may have written in a editorial sometime
other than
earlier
that one
this
time.
year.
Was at that time, what was the Attorney General's response in the media that you folks felt obligated to respond to?
The following week, the week of October the 5th, the Attorney General's office issued 2 press releases that made negative comments about the group of whistleblowers, claiming that we had impeded an investigation, claimed that we were rogue employees, and later the Attorney General claimed we'd even committed crimes.
You did. You did.
What was your group's response to that?
Well,
Y'all did some of these things you're trying to impeach him for. It's hilarious.
everybody was outraged.
All right. Let me ask you this. Are you
Yeah, things
one of
weren't
the
going y'all's way.
plaintiffs in the
Were they?
whistleblower lawsuit?
Yes, sir. I'm one of 4 plaintiffs.
Why did you decide to sue?
I sued because I was damaged by the office's actions in violation of the whistleblower statute.
Y'all were the ones putting up a fight.
What financial impact did this all have on you?
Against the
Well, it had a big
investigation that should have
impact.
been being investigated. That was
Number one, I
referred
was
to
put
them
on
by the Travis
investigative
County
leave on
DA.
October the 2nd by order of the Attorney General. On November 2nd, a month later, I was fired illegally under the Whistleblower Act. I was given ridiculous reasons
Was he
for the
fired or was he
firing.
resigned?
What were the reasons you were given?
Maybe he
The
was
reasons
fired.
I
The other ones
recall,
resigned.
and these came from the new first assistant who got rid of all 8 of us within 45 days. He said I'd lost the Attorney General's trust. I violated.
I asked the reasons he was given for firing.
Overruled.
He said I'd lost the Attorney General's trust, number one. Number two, he claimed I used an insubordinate tone when he demanded to have my cell phone handed over to him so he could examine it without a search warrant.
What is that? What is that about?
He claimed there were public information requests to the Office of the Attorney General, and he demanded to see my text messages.
Yeah, I would have too, as we
Now,
saw in
did that all
the
become part
testimonies
of
yesterday and the day
litigation later?
before that y'all
That
were
became part of the
deleting
litigation. And then
your
the third
messages.
reason was,
You were deleting
What was the third?
public
reason number
records.
3, he claimed that I had violated a direct instruction
already
from the
been
Attorney
established.
General when I filed the motion to quash and when I sent a cease and desist letter to Brandon Kamek, and that is untrue. He claimed that on September 16th, when the Attorney General asked me for information about the documents I wanted from Michael Wynn and Nate Paul, at the end of that meeting, the Attorney General said, "Don't do any more on this." The context was, don't ask.
That's okay. Hold on. I really, really want to finish up here with you to ask you this. After all you've been telling the jury about, after all you've been doing differently,
Y'all give me a 5x5 if you can hear me over on
would you do
Phil.
anything differently?
No, sir, I'd do the same thing all over again because it was the right thing to do and the
Over
only
on
thing we
Rumble,
could
yeah,
do
y'all are paying attention. Y'all are
other
talking.
than stand by silently and let crimes be committed. The agency was being abused. The laws were being abused.
Yeah, good luck
The
filing a report
behavior
to the
and the
sheriff with no
conduct
evidence.
of the Attorney General of Texas
Object
was
to the narrative.
outrageous.
Object to the narrative.
Sustained. Sustained.
I'll pass the witness.
Mr. Little?
Okay, finally, we get Ken
Thank you,
Paxton's
Mr.
attorneys
President.
up here.
Just for planning purposes, when do you intend to break? I believe it's 11:55.
Take a break at 12:15. Does that work?
All
Or
right,
would you
they're going to
prefer
take a break in
break
about.
now and start anew after lunch?
I'd like to take a few minutes and get started if we might. Thank you.
You're a witness.
All right, they're going to take a break at 12:15. So we'll talk about a few things and then we'll take a lunch break at 12:15.
Mr. Penley, I'm going to hand you some of your notes here. so that you've got them. You need something, Rusty? Left your cup of water. All right. Documents for you. Thank you. At this time, Mr. President, I'm tendering to the witness exhibits 1009 to 1021. This is a series of notes in Mr. Penley's hand. May I approach?
Yes. Have they already been admitted or you're admitting them? Okay.
Now, Mr. Penley.
Do they have a copy?
They do. I've handed them to Mr. Hardin. We move for admission of exhibits AG 1009 to 1021.
Any objection?
Yes, I think these are, to repeat a famous objection, these are all hearsay. Every one of them. They're the same kind of thing we offered to introduce to him, and he objected to his hearsay. If he withdraws his objection to the notes of our witness, then I'll withdraw my objection to these. Otherwise, sauce for the goose and the gander and all that jazz works.
Mr. President, may I respond?
Yes, you may.
These notes that I've handed to Mr. Penley are notes of his present recorded recollection from the meetings with the Attorney General in various formats. Mr. Hardin has already offered House 216, which is his notes from September 26. These are all of Mr. Penley's notes, and they are extensive.
I'm sorry, I don't know how there's any different than what we just talked about.
I'm not sure I understood your reply.
Recorded recollection is an exception to hearsay. And these are his notes, just like House 216, which was admitted and offered earlier.
If I may be heard, I think his memory is incorrect. 216 was not admitted. I asked and he objected to hearsay.
I remember he did not object. He said they were going to use those notes, is my recollection. We can check the
That's right. And it
record.
was offered and admitted.
Offered and admitted. He did not object.
I think that was 214.
No, that's when there was confusion between 214 and 216.
Yes.
So the 214, if my recollection is correct, were the outline before the meeting, and 216 is the recollection after the meeting. And he did not object to that.
All right.
I may have not, maybe the court did not admit them into evidence, but you did not object. I remember you saying you were going to use those.
That's right.
In cross.
That's fine. If it's admitted, then that's great. If he wants to admit these under the same theory, then I have no objection.
Great.
Okay. So these notes are admitted under evidence, which the numbers are
1009 to 1021.
1009 through 1021.
Thank you. Now, Mr. Penley, just to be clear, we need to clarify something for the ladies and gentlemen of the jury, and I'm almost positive you have the answer. You conducted an investigation, right?
Yes, I did.
And it wasn't a review, right? It was an investigation.
Technically, the office called it a review. I'm using the term investigation the way I mean the term investigation. We met with a witness. We looked at the evidence they gave us. We drew a conclusion, and that was the end of it.
Sounds like an investigation to me. Don't you agree?
I do. It's semantics.
You just never opened a file, right?
No, I didn't open a file. There was no basis to open a file and pursue any charges.
David Maxwell, well,
oh my
hold on a
God.
second. Let's be super clear for the jury. You don't, if you could, Mr. Hardin, he's beeping over there. Let's be clear for the jury. You do not need to bring charges to open an investigative file at the Office of Attorney General, right?
No.
And you didn't open a file, and David Maxwell did not either, did you?
I know I didn't open a file.
There
well, you
was
know David
no
Maxwell didn't open a file either,
investigation
did you?
done at all.
I've heard that.
Yes. And
They
to be
just
clear,
took the word of
this
the
was
FBI,
not an
saying
inquiry.
metadata change.
It was not a review. You call it an investigation, yes?
That's my term. David Maxwell's term was review.
Wow.
There was nothing illegal about conducting the investigation that you conducted, was there?
We didn't take any illegal actions, no.
Object now responsive. Just so I can get a yes, no.
Sustained.
There was nothing illegal about the investigation you conducted. True?
That I conducted, that's true.
That anyone at the OAG's office conducted. True?
No.
Let's be clear about this. Did you see Mr. Maxwell break any laws in conducting this investigation?
No, I did not.
Did you break any laws in conducting this investigation?
Absolutely not.
Were you asked to
This
do
was not
anything
an
illegal?
investigation.
Yes.
Tell the ladies and gentlemen of the jury about that.
We were asked to obstruct a federal investigation. That's a federal felony.
Interesting. Are you aware of Fifth
Really?
Circuit and Ninth Circuit precedent that says you cannot obstruct an FBI investigation because it is not an official proceeding, Mr. Penley? You're familiar with that authority, aren't you?
No, I'm not familiar with that authority.
Well, you worked at the U.S. Attorney's Office for 17 years. Surely you came across the fact that you cannot obstruct an FBI investigation as it is not an official proceeding,
Oh my gosh.
right?
I'm sorry, I lost your question there. What are you asking me?
Yeah, in your 17 years working at the Office of the U.S. Attorney in the Northern District of Texas, did you ever come across the precedent, legal precedent, that one cannot obstruct an FBI investigation because it is not an official proceeding?
I was never presented with that issue, and I was there 16 years, not 17, just to be correct.
Did you ever once in your 16 years prosecute obstruction of justice relative to an FBI investigation?
No, that was never presented to me as a case.
Not
Really?
one time.
In
True?
16 years.
No.
Really?
No,
So I guess
mean,
it's-
your statement
huh.
is true. I did not do that.
Ooh.
Want to be clear, you gave us a timeline. We're going to go back
This
through
is
the timeline in detail in a
spicy.
minute. But in September, you became concerned that the Attorney General might fire you, correct?
I think I became concerned after the August 12th meeting when he did a total reversal on me.
Non-responsive.
Sustained.
You testified on direct that in September of 2020, you became concerned that the Attorney General was going to fire you, true?
I don't agree with the way you're wording the question. I was concerned in August and September.
Okay.
I'm only asking you about September.
Okay.
I'm going to ask you about August in a minute. In September of 2020, were you concerned the Attorney General was going to fire you?
Yes.
And isn't it interesting that you came up with these theories of your boss's criminal escapades after you thought he was going to fire you, right?
What theories are you talking about, sir?
Well, you and David Maxwell got together and you asked a series of questions, right? Is Ken Paxton being bribed was one of them, true?
Yes, we wondered about that.
Is Ken Paxton being blackmailed? That was one of them, true?
Yes, we discussed that.
Does Ken Paxton owe Nate Paul any money? True?
I'm sure that's something that came into my mind.
Does Ken Paxton or does Nate Paul have some kind of information on Ken Paxton? That was one of the things you talked about, right?
It's certainly something I thought about.
But you only started talking about those things with David Maxwell when you became after you became concerned that Ken Paxton was going to fire you. True?
No, that's not true.
Councilor, may I hold you? Do we know where this music is coming from, bailiff?
The bagpipes?
Yes.
It's coming from the rotunda. I think now probably would be a good time for a break, Mr. President.
I thought I was just very Irish. I was
We will
like,
take
no,
a break
the
now.
pipes are
We will
calling.
return here at 1 p.m. sharp.
This is high quality television, you guys. Thank you for being here. The pipes are calling. That was funny. All right, y'all. So
I did speak with their investigators.
but you were not
Did
under
you review
oath.
the video of your meeting with the investigators before testifying here today?
No.
And during that proceeding, isn't it true that Ms. Therese Buse, who was hired as one of the investigators, told you that there was a legislative privilege that covered your testimony in that proceeding?
I don't know that she told me that. It was my understanding there was a legislative privilege.
Just to be clear, when you testified there on video, did you tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, that was my intent.
Yes, and it was your intent.
Yeah, I mean, I may have gotten a date wrong. I may have gotten an event occurred one day instead of another day, but it was my intention to tell the truth, the whole truth, and nothing but the truth. Yes, sir.
Of course. So if we have your statement from that interview that was conducted by the House Board of Managers and their investigators, we can rely on it as being true, correct?
I believe so. That was my intention.
All right. At this time, Your Honor, I'm going to introduce AG Exhibit 68. May I approach the witness?
Yes, you may.
Thank you.
It's just, that's why it was so rich for the House managers to make any sort of point at all about Nate Paul not being under oath, which it's like, yeah, everybody should be putting people under oath.
So you'll have
Why
to
are we not putting
submit it
people
at
under
the
oath?
right time.
The House didn't put any of their witnesses
we move
under
for
oath
admission
for
of
their
AG Exhibit
articles,
68.
Any
for
objection?
the construction of those articles.
No objection, Your Honor.
Admit AG 68 to evidence.
Eric, Exhibit 68, if you would. Thank you so much. All right. To be clear, Mr. Penley, this is the referral that came to your office from the Travis County District Attorney's Office, and it was dated June 10 of 2020, correct?
That's correct.
It's received in your office sometime around June 17 of 2020, correct?
That's my understanding, yes.
And when you got this, neither David Maxwell nor you were excited about the assignment at all, and neither one of you really wanted to move forward with it, correct?
That's true.
And what Nate Paul was accusing these people here, or at least complaining about,
Asking for an investigation.
if true, it was a 20-year felony. You would agree with that, correct?
An alteration of a federal or a document, yes, it would be a 20-year felony.
And there's a state analog to the federal statute concerning alteration of government documents, true?
Yes, I believe that's 3710.
So there was a state offense that had been alleged in this referral, true?
Wow.
He was claiming there were state law offenses, yes.
Yes, that's what I said. There is a state offense alleged in this referral, true?
And actually, the witness just
Yes,
named
if you
it.
believe what Nate Paul was saying.
Yes, and it wasn't a crime to follow up on this.
God.
It wasn't obstruction of justice. It wasn't interference with an FBI investigation, true?
To a certain point, I agree.
Very good. In fact, when you were working at the U.S. Attorney's Office, there was an FBI employee in the U.S. Attorney's Office, or I'm sorry, in the Northern District of Texas. His name was Jeffrey Fudge. Do you remember that person?
I don't.
He was an FBI employee who was accused, indicted, and convicted of plugging other people's information into government databases and letting them know if there were investigations about them. You familiar with that?
I'm not.
It happened your first year at the U.S. Attorney's Office.
Pardon me, Your Honor. You were talking about something he doesn't know anything about. Now he's testifying about it, and I object to that.
Overruled. He can ask the question, but be careful of your line of questioning.
I certainly will. Have you ever heard of an FBI employee named Kevin Kleinsmith?
Yes.
I believe so.
Yes. At the same time that you were doing this investigation, an FBI employee was being investigated and subsequently indicted for providing false information in pursuit of a FISA warrant. Correct?
I've heard that.
Operation Crossfire Hurricane, you've heard of that before, correct?
That's correct.
I have.
Yes. And so the allegations that are being made here, it's not a crime to follow up on them, and a state offense is alleged. True?
I felt it was appropriate to do an initial review.
Object now responsive.
Sustained.
True?
Could you ask the question again, please?
Yes. The state offenses that are alleged here, it wasn't a crime to follow up on them, was it?
No, it wasn't a crime to follow up.
No. But
it was not.
Your testimony earlier was you hope to slow walk it.
Yes.
Did you tell Michael Wynn that?
No.
Did you tell Nate Paul that?
No.
Did you tell your boss, Ken Paxton, that?
No.
Piece of shit.
And in fact,
Now I know why
between
he
June
got
17
fired.
and July
Oh.
6, 2020, you
Excuse me.
only talked to David Maxwell about it, right?
Between what dates?
June 17 and July 6 of 2020, you only talked to David Maxwell about it.
That's not correct.
That was your testimony on direct. Would you like to correct it?
I would, if I may.
Please.
I'm sure I talked to Jeff Mateer as well. In fact, we talked to Jeff
the
Mateer
Mean
when
Girls
he handed
Squad.
us the referral on June the 18th, probably.
We may be talking past one another. You did no investigation between June 17 and July 6. True?
We didn't do any, no.
Didn't do any work.
Wow.
True?
That's true.
Okay.
So this
I'm going
is
to show you what's been marked as AG Exhibit 88.
this is the crew fighting against Paxton, and this is what they do when you bring them complaints of alleged state and federal statute violations. They slow walk it, and they hope that the attorney general will forget about it or choose to just ignore it. Okay. and they genuinely wonder why Paxton hired outside counsel to look into something.
We move for admission of AG 88.
Any objection, Mr. Harden?
No, Your Honor.
Pathetic.
It's admitted to evidence, AG 68. I'm sorry, say that number. 88. I see it. Thank you.
Mr. Arroyo, if you could publish AG 88 on Bates page HBOM 181004.
I like his
So move
fuchsia
ahead
tie.
3 pages from there. And blow up all the text and writing at the top, please. These are your notes, Mr. Penley, from your meeting with Ken Paxton on July 6th of 2020. True?
Yes.
And in that meeting, at the top, you write, tampering with docs is a state issue per Mindy of Travis County. Who's Mindy?
Mindy Monford, the first assistant at the Travis County District Attorney's Office.
Did she tell you that?
No.
You didn't know enough state law to know that there was a state offense alleged at this point in time, did you?
That's incorrect.
No,
So
he
you
does
knew
know.
there was
He
a
knew
state
then and he
offense
knows
alleged.
now.
You didn't need Ken Paxton or Mindy Monford to tell you that.
That's
True?
right.
I
That's
believe
right.
I discussed that with David Maxwell.
Yes.
You learned it from David Maxwell, right?
I believe so.
Did you look up the law yourself?
I did.
Good. Next line says he alleged they changed the search warrant. The next line after that, if you would read that to the ladies and gentlemen of the jury, please.
Ken just wants the truth, period.
Ken just wants the truth. And
Wow.
to be clear for the ladies and gentlemen of the jury, who is Ken?
Impeach
That's
him.
Attorney General Ken Paxton.
He told you he just wanted the truth.
Absolute
True?
clowns.
He said he did.
Yeah, and you believed him at the time. True?
He said
True?
At
that.
the time, I believed him, yes.
Yes, at the time you believed him.
That's right, but not later.
And so when you made these notes, you were making notes of what Ken Paxton was saying, and he was telling you he just wanted the truth.
That's right. I wrote down what he said.
The truth about what?
About what happened with Nate Paul.
Okay. Now we're getting somewhere.
And did you tell him you would get right on it?
We did. We started trying to schedule a meeting.
I don't think so.
No.
Let's move on to
Object
our
to the
next exhibit.
sidebar.
No,
Withdrawn.
because that's
Sustain.
wow. Okay, whatever.
This is another portion of Exhibit AG 88.
Nope, he was slow walked it, and he even so he admits that he believed Paxton at the time when Paxton said he just wanted the truth, and he still slow walked the investigation and hoped that Paxton would stop. So the whole slow walking the investigation, that was not
Mr. Roy,
because
if
he
you could
didn't
move to the
believe
next page.
Paxton
.5.
was genuine. That was because he didn't want to do it. What the
Mr. Finley,
F
these are your notes of a subsequent
going
meeting with
on?
your boss, Ken Paxton. True?
Yes.
And if you could, Mr. Arroyo, blow up the bottom half of that page, please.
What were they doing to Nate Paul that
The
they're
date
going
of
to
this
do
meeting
all
is
of
on or
this
around July 16.
to protect themselves?
Yes?
Well, that's my best belief. I didn't date this page, and I don't know specifically when it was, but from looking at other information, that's my belief. This happened on July 16th.
And how long had you been working at the Attorney General's office at this point?
About 9 months.
About 9 months, less than a year, certainly. True?
Yes, I only worked there a year.
And you wrote the word Ken and you bolded it, correct?
Yes.
Mr. Arroyo, can you bold that? Can you highlight that for me? And to the right of it, you wrote an asterisk and it says, he's embarrassed.
That's what he said.
He was embarrassed with you and David Maxwell. True?
He was embarrassed at the lack of progress on the Nate Paul matter.
Because you hadn't done anything. True?
Right.
That's true.
Wow.
Below it says, we've had this for 6 weeks, exclamation point. And Ken Paxton was upset with you that in 6 weeks, you and David Maxwell had done nothing. True?
With a
Which
complaint?
part of the question you want me to answer first? You asked me if we'd had it for 6 weeks. That is true. And it's also true we had done no investigating in that 6 weeks.
Ken Paxton was upset that you had done nothing for 6 weeks on a referral from Travis County that he was aware of. True?
That's true.
Anyone would be embarrassed about that.
If you would, there's some discussion about
when
Texas
they're trying to run
Monthly.
an office
Do
that's
you
supposed
see
to be
the
looking
all
into these
caps
things.
statement that you wrote in your notes?
I do.
And Mr. Arroyo, if you would highlight that portion and the portion below it and the line below it, you're on it. And below it, it says, seek the truth, 2 exclamation points. And that's what your boss, Ken Paxton, told you to do. True?
That's what he said. I wrote down what he said.
And what he said was to tell you to seek the truth. Yes?
Yes, that's what he said, and that's what we did.
And below that, it says, let results be what they are. True?
That's what he said, and that's what I wrote down. True.
And at that point in time, in that day, he did not tell you to interfere with an FBI investigation, did he?
Not that day, no.
He did not tell you to obstruct justice, did he?
Not that day, no.
No, he didn't. Mr. Arroyo, if you would, please bring up Exhibit 1, AG 1009. This has already been entered into evidence, Mr. President, before the break. Exhibit AG 1009 is on the screen here, and these are your notes from July 23, 2020, true?
Correct.
And these are notes from your review of Nate Paul's earlier meeting with David Maxwell, of which you are not a participant, true?
That's true.
Yes. And in the middle, Mr. Arroyo, it says the agents didn't. If you can highlight that portion. It says the agents didn't leave search warrants behind. Violation of the law. True?
No, it's not a violation of the law.
Is the Federal Code of Criminal Procedure the law or not?
Yeah.
It's a procedural code. It's not a statute.
Okay.
They
Hey,
broke
I
the
love
law
that.
as
I
expressed
love
in the Code of Criminal Procedure. True?
They broke the procedural rules of the Federal Code of Criminal Procedure, if that was true.
Let's turn
Oh
the
my
page.
gosh, I love this actually.
Next
This
page,
is
Mr.
so
Arroyo.
good. Is he saying that procedural
In the middle of
rules
the
are
page,
not
there's a
state
section that says
or federal
metadata on
statutes?
PDF.
Excellent point, actually. This is so good for patriots.
You could zoom in on that.
We need to talk about some of these policies. Now, this one is crazy. They're supposed to be leaving a copy of the warrant. I believe we'll find the constitutional violation.
Actually, don't zoom in on that whole thing.
that
Just
is,
get the
but
line below that as
I
well.
love the distinction that the
created
witness
on
just made under
9/6.
oath.
Can you read that okay, Mr.
On
Penley?
the record.
I can. Thank
Right,
you.
very good. It says metadata on PDF was created on 9/6.
Yes.
You would agree with me if someone was manipulating federal search warrants after they had already been served or after they had already been created, that is a problem. Yes.
Could you repeat the question? You said manipulated.
Wow.
I don't understand what you mean.
Oh my gosh.
If someone were changing search warrants after a judge signed them, that would be bad. True?
I'd agree if they were changing the text.
Yes. Not just redactions, but changing the actual text, right?
If they were changing the text that the magistrate judge had approved, that would be a crime.
And the next
Okay.
page, if you would, Mr. Arroyo.
That's what was being alleged. Hello? It's like,
About 3/4 of the way down, there's a paragraph that says claim above an asterisk. If you could zoom in on that for us.
some of these
No,
people,
above that, please.
I don't know if they're acting or
next
if they're,
paragraph
if they're
above.
genuinely this dense, or I usually refer to them as otherwise intelligent people, but
Yeah,
good
the
Lord.
allegation here is that the search warrant for the file storage company, Contigo, was fabricated after the fact. Yes?
That was Mr. Paul's allegation, yes.
All right. Next page, please. And on the last page, you wrote the notes, Ronnie Saban, TFO. That stands for Task Force Officer. Yes?
Yes.
State Securities Board. Yes?
Yes.
How did he get the name Ronnie Saban?
Well, I know that he met Ronnie Saban because he claimed that Ronnie Saban had been executing the search at his residence and they spoke to each other.
Well, there
So
you
what
go.
you're saying is, I don't want to put words in your mouth. Nate Paul knew Ronnie Saban was involved with the search warrant because he met him during the execution of the search warrant, correct?
Hello.
Yes, he had personal knowledge of Ronnie Saban because he met him during the search.
Not because Nate Paul got some secret document from someone else, true?
No, that's absolutely false, and you misstated my testimony.
No. It can't be both. It can't be
Jeff
that.
is not responsive to everything after no.
Yeah, it can't.
Sustain.
It can't be both.
Now,
They tried
We're
to
gonna look
say
at
that
AG
Paxton
Exhibit
supplied
110.
Nate Paul with stuff he shouldn't have had access
Mr. Royo,
to.
if you would.
Oh, how
AG
would he have
Exhibit,
had
I'm sorry, not
the
110,
agent's name if he didn't have
1010.
access to
There we
the
go.
unredacted
All right. These are
warrant
your
and
notes
affidavit?
from a meeting with
Because
Michael
that
Wynn
guy
on July
fucking
28th
raided
of
him.
2020, true?
Good Lord.
Those are my notes from a phone call with Michael Wynn. That's correct.
Yes, a phone call. And at the top it says, wants to come to Austin to explain papers. Yes?
Yes.
And below that says the agents didn't leave copies at the premises, but you already knew that. True?
I knew that from reviewing the first meeting, the July 21st meeting video. Yes.
Next line down says inconsistent signatures and stamps. Yes?
That's what I wrote down because that's what Mr. Wynn told me. Yes.
Yeah. And these notes are from a phone call in advance of an August 5, 2020 meeting with Mr. Wynn and his lawyer. Yes?
Correct. We set that meeting date during this call.
Yes. And by this point in time, Mr. Penley, had you done any investigating at all?
Yes.
And what did that include?
Well, it included watching the video of the July 21st meeting where Mr. Maxwell met with Mr. Wynn and Mr. Paul, listened to their complaints, listened to their theories. So I'd reviewed all that, and he wanted to come have a second meeting, and I agreed to it.
All you did was listen to them at this point in time, true?
Yes, that was an initial report
Object
by...
not responsive to everything after yes.
Can the witness finish his answer, please?
No, he cannot.
Sustain the objection. Rule your objection.
I'm going to show you what.
Please let him have time to finish.
I will do my best.
Sure.
Now we're going to look at Exhibit 1011, AG Exhibit 1011. And these are your notes from a meeting with Nate Paul and Michael Wynn, true?
Yes, that's the August 5th meeting.
And you can see there by your first asterisk, hold on, it says thumb drive of docs produced.
That's true.
Thank you guys.
They
Please
gave you a
like
thumb
and
drive.
share.
They
Yes?
did. Yes.
And I want you to scroll down. Do you see the line that says J Lane?
Yes, I see that.
This J Lane said he didn't have the original search warrant. Yes?
Well, I don't know if he did or he didn't. That's what Michael Wynn told me.
Yes. And so what Michael Wynn told you in this meeting is that the magistrate, the federal magistrate judge informed them that he did not have the original search warrant. True?
That's what Michael Wynn said. True.
And if that were true, that would be really surprising if a federal magistrate, for whatever reason, did not have the original search warrant. Yes?
Yes, that would surprise me.
Did you ever look for the original search warrant?
How would I do that, sir?
Did you call anyone?
Wow.
I raised that with the Attorney General and the First Assistant that was an option.
Object non-responsive. That was not my question.
What?
Sustained.
Did you call anyone at the magistrate's office, a clerk, a deputy clerk, the magistrate himself? Yes or no?
No, I never called the
You
federal
used the authority of the
magistrate or
Attorney
his
General
staff.
to say, hey, we're
Did you
looking into
call
something.
Alan Bowie, perhaps?
Can I see
No, I
this
did not.
Did you call
unredacted
any of his
original warrant?
deputies at the U.S. Attorney's office?
I did not.
How hard would that have been to do?
It would have been problematic in my view.
It would have damaged your reputation and the office's reputation potentially, true?
Not my reputation. I wasn't concerned about that. I was concerned about the reputation of the office and our work with the federal authorities in the state of Texas.
For you to call the feds, you
Yeah,
would
I
have worried
believe that.
that would have harmed the reputation of the office.
Not to make a phone call, but to
Then
make
why didn't you do it?
because a phone call about this seemed to be high risk to the functioning of the Office of the Attorney General when we needed to work with federal authorities or appear in federal
Wow.
court, which our attorneys did all the time.
Y'all
That
didn't
would
want
have
to
been
piss
high
off the
risk to make a
feds.
phone call.
You
You're
didn't
going to
want to
tell these
piss off the
senators it was
feds.
high risk for the Office of the Attorney General for you to pick up the phone and
Please.
make a phone call. Yes?
Not to make a phone call, no. But to
To
make a
look
phone
into
call about
this.
this, yes.
No. No.
Well, why didn't you do it?
The reason I didn't do it is because Nate Paul was claiming there was a grand conspiracy between a federal judge, 2 federal prosecutors, at least 2 state agencies represented as task force officers, and a number of FBI agents. Nate Paul filed a civil suit against 100 law enforcement agents in federal court in Austin over this.
Wait till
And I
Trump
thought
files
to
against
call
all
the
the ones
U.S.
that raided
Attorney's office
Mar-a-Lago.
and say, we have any belief
that career AUSAs would be altering search warrants is crazy, especially when they have an ongoing investigation that's privileged.
In any event, you didn't make the phone call.
I
True?
did not, for the reasons stated.
Yeah. Isn't it true that in these videos, first in the meeting with David Maxwell and Nate Paul and his lawyer, and then with you also, Nate Paul's own lawyer said, we're not trying to interfere with the FBI investigation. Didn't he say that?
He may have, I don't have a specific recollection.
Isn't it true that Nate Paul's lawyer, Michael Wynn, also told you, we don't necessarily think that these are evil people. It may have been a comedy of errors, or they may have just made some bad choices and not been able to get out of it.
I remember him.
Pardon me, is he soliciting hearsay? Surely not.
It's testimony from the video that you put in evidence about 2 hours ago, Rusty.
It doesn't matter. I just simply asked, are you asking what somebody else said out of court? Isn't that what you've been arguing about?
No, what they said in evidence, which has been accepted and admitted into the court.
You remember the videos you put in this morning and the transcripts? It's from there. I hope that clarifies it.
Overrule.
All right. Now, let's go back to Exhibit 8. So, just to be clear, hold on.
Which exhibit?
We're going to go to AG 1012, please. If you could, Mr. Arroyo.
In fact, I remember Paxton's attorney saying he was going to cite the same thing that he was
Criminal
entering
Investigation
earlier.
Division's forensics team, true?
Correct, and David Maxwell.
And these are your notes, yes?
Yes.
And you're talking about metadata, true?
Yes.
And they told you that the results were inconclusive, true?
That was their words, yes.
Yes. They didn't tell you that there was no proof of a crime, or that no crime had been committed, or that a crime had been committed.
Exactly.
They didn't tell you any of those things, did they?
They said the metadata was inconclusive.
And they didn't tell you that a crime had or had not been committed, true?
That's right, and I wasn't asking.
Object non-responsive to everything after that's right.
Because then he went and said there's no evidence.
Focus with me. Inconclusive means we don't know, doesn't it?
It means it doesn't prove anything. That's what it means.
It doesn't disprove anything either, does it?
That's right.
It seems like if something is inconclusive, it might require further investigation, right?
It's possible.
Oh my gosh.
I'm going to show you what's been marked as Exhibit AG 88. Eric, if you can go back to that. I'm going to bring the page to you so you can see it.
This is exactly what I was saying earlier. They did not debunk anything. They said that they can't tell because if it was redacted, that would change the metadata too. Whether it was changed afterwards and then redacted, the metadata is different and we don't know what it's from. It could be from the redaction. They could have changed something.
If you would, Eric, go to the page ending in 7.
Unless we have the original ones, the original warrants. You know, this is all crazy. And they didn't even leave a copy at with Nate Paul.
All right,
which is weird, which is against the procedure, which he admits is not the law, but is the procedure for.
Mr. Finley, you got out of the meeting
now
and
Nate
you
Paul
had
has
Tina
standing.
McLeod, who works in IT, said
to be concerned.
She sent you an email. Metadata is, quote, data that provides information about other data.
Yes, she sent me this email, and because I'd sent her one.
He didn't even look for the original copy
said, Hope this
that
helps.
was not left with Nate Paul.
That's what she wrote.
You asked her to send this to you, yes?
I did.
Because you didn't know what the heck metadata was before you walked into that meeting, right?
That's not correct. I had a general impression of what metadata was. Nate Paul was making specific allegations that he could understand the metadata, and he claimed it proved the search warrants had been altered. And I was trying to go to our IT director, who was at the deputy level, and see if I could get a more definitive definition of metadata that would help me analyze his claim.
Of course. And so what had happened was on this same day, you had met with Nate Paul and his lawyers, and no?
No.
Okay.
This was August the 6th. This was the day after the meeting.
Yes. So you met with your team, your forensic team.
On August 6th, yes.
And then you got out of the meeting and said, hey, Tina, can you send me a definition of metadata, please?
I don't remember if I sent the email before we met with the forensics team or after. Metadata was the central core of Nate Paul's complaints about the search warrant. That was the evidence that he and Mr. Wynn pointed to that would prove that state violations had occurred in the
this
alleged
is
alteration of
Finley.
a court document.
And in order for you to assess those claims, you needed to know what metadata was, right?
Of course, yes.
May I approach the witness?
So the impeachment's going well. Paxton's team is once again eviscerating the witness. They did not debunk Nate Paul's claim. They didn't even investigate it. They admit that on the stand. He admitted he was slow walking it,
Mr. Arroyo,
hoping
back to
Paxton would
exhibit
drop it.
AG 88.
They didn't conduct any investigation into it
The
at
page
all.
ending in '03, please.
And then they stage a mutiny when Paxton hires outside counsel to look into it, because the inside counsel had already made up their fucking mind without doing
What
an
is this
investigation.
list, Mr. Penley?
Deep state bastards.
It's a document that apparently.
Sorry.
We're on the wrong page up on the
Sorry.
screen.
Maybe this was just a mistake,
page.
but
Mr. Arroyo, 003, please.
big mistakes, you know,
Other way.
could be fixed. I don't.
Okay, what's this list?
Your Honor, may I inquire?
I'm glad we're having this out and exposing
Ask
this,
the
some of
witness
this
if
stuff.
these are his notes or his typing.
No, it's in evidence. It was offered, admitted.
We need
over your
legislation
objection. No
to
objection,
have
actually.
recourse.
I don't believe this was prepared by him. So I don't know if he is going to ask him about it. I'd like the record to reflect he's out talking to him about something he did not prepare.
He produced it in response
It
to our.
doesn't matter whether we produced it. It matters as to whether this witness had anything to do with it.
I'll try to lay a proper predicate.
It looks to me like we received it from the Attorney General's office.
Mr. Harden, you can take the witness on voir dire and ask him.
Yes. Mr. Penley, of this particular exhibit, did you have anything to do with preparing it?
I don't recognize this document. I don't recall preparing this.
Oh, whatever.
I don't believe it's mine.
Okay. That's all I have, Judge.
Whatever.
Do you remember ever seeing it?
I've seen it in the documents for this trial. I've seen it in the discovery.
You produced it in response to your subpoena, yes?
I don't know that.
He didn't produce.
Hold on. I'm asking the question.
I don't know that I did.
Okay, we can go back and look.
And if I did, I don't know that I prepared it. Perhaps I received it some other way.
The suggestions on this list are suggestions of things that the office might do, questions it might answer in connection with the investigation, right?
I agree with that.
Yeah. And it says, can we talk to the AUSA Alan Bowie, right?
Correct.
And you've already testified you didn't do that, yes?
Right, I did not do that.
And none of the other questions, how was the document created? How was the document encrypted? What did he encrypt it with? What application did he use? You never got the answers to any of those questions, did you?
No, I did not.
Doesn't that seem like important information you might want to know?
No, not based on what I learned on August the 6th.
Okay, so I want to fast forward in your mind now to August 12th. We're going in chronological order if you couldn't tell. August 12th, you believe, and your testimony on direct was, you believe Ken Paxton was no longer supporting you. True?
That's true.
Yeah, and you came to that conclusion after the meeting with Nate Paul and his lawyers at which the Attorney General was present, yes?
Based on what the Attorney General said, that was opposite of what he had told me 3 or 4 days earlier.
And now, if you would, let's take a look, Mr. Arroyo, at AG 1013. You and the deputies on August 13th, the day after you say you no longer felt supported by Ken Paxton, you got in a circle with your deputies, yes?
I didn't get in a circle. I briefed Jeff Mateer on what had happened the previous day.
When you produced this document in response to a subpoena, you blacked out the top, you whited out the top of it, right?
Yes, because
I just need an answer to my question.
Yes, I did. I redacted it.
Yes, and we don't know what's under there because you didn't show us, correct?
That's true.
Now we go to the rest of this item. These are your handwritten notes from a meeting, true?
Yes.
And below that, Mr. Arroyo, if you can blow up the text to the right below that. It says, call Dan Cogdell.
Yes.
That's what you wrote, right?
Absolutely.
We're talking about that guy?
Yes, the guy in the good-looking sport coat over here.
Says, ask him if Maxwell and
Oh
I
my
say
God.
go no further with this. Did you call Dan Cogdill?
No, we did not, but we considered it.
Object non-responsive to anything after no.
Sustained.
Below that, Mr. Roy, if you could highlight that, it says possible bribery.
Yes, I wrote that.
On August 13th of 2020, you had absolutely no evidence, physical, documentary, eyewitness, or circumstantial, that Ken Paxton was being bribed by anyone, did you?
I disagree with your statement. I had circumstantial evidence.
Oh, you had circumstantial evidence.
Yes.
Well, at some point on August 13th, did you go to your boss, Ken Paxton, and say, Attorney General, I'm concerned. I have circumstantial evidence that you've taken a bribe. Did you do that?
Not on the 13th of August. I did
You
it later.
didn't do that because you knew you would get fired, right?
I said possible bribery. I didn't have evidence to confront him with, not at that time.
Oh, but you just told the ladies and gentlemen of the jury you had circumstantial evidence.
Yeah.
So did you confront him with the circumstantial evidence?
No, the circumstantial
Object
evidence.
now responsive to everything
Mr.
after
Kennedy,
no.
Please be allowed to respond. I'm just begging.
Sustained. Your objections.
Thank you. Mr. Penley, below that it says, if you can zoom back out, Mr. Arroyo, he's using OAG/playing KP. Did you tell your boss you thought that Nate Paul was playing him?
Not on August the 13th.
Why not on that day? You had his phone number, right?
I'm sorry?
You had Ken Paxton's phone number, right?
Yes, I did.
Why didn't you confront Ken Paxton with your circumstantial evidence of bribery and the idea that Nate Paul was playing him on August 13th?
Because I was trying to find a way to convince him to listen to reason and get away from this investigation, which I thought was highly dangerous to him and harmful to the office and injurious to the respect for the law in the state of Texas.
But also because if you had done that, you should expect to get fired, don't you think?
I could have been, and I was concerned about getting fired ever since Ken Paxton did a 180 and turned against me in the August 12th meeting all the way to the end.
Okay. So just to be clear for the ladies and gentlemen of the jury, your concerns about bribery did not arrive until you thought Ken Paxton might fire you. Yes?
No, that's not correct. You're misstating what I thought.
I have your notes here.
Yes.
This is the first document I've ever seen where you've written the words possible bribery. Will you agree?
I don't have all the documents I've written. I've written a lot, so I can't agree to that unless you want to show me all the documents. I began to be very concerned about what was going on in his mind when on about August the 8th, more or less, I told him I recommended closing the investigation. He looked me in the eye and said, okay, fine. All I ask you to do is meet with him and tell him. And then 2 days later, he told me he wanted to attend the meeting. And then in the meeting, when I announced to Mr. Paul and Mr. Wynn, I recommended we close the investigation because the metadata theory didn't prove a crime. Ken Paxton began making negative comments
I'm going to object to the narrative.
Sustained.
Appreciate your answer, Mr. Penley, but my question was a little bit different. On August 12th, by August 12th, you thought this guy might fire me. Yeah?
I did.
On August 13th, you wrote down, maybe he's being bribed. Yeah?
Yes, because I thought that.
And you didn't confront him that day because to do so probably would have resulted in you being fired, yes?
Could be.
The safer strategy is to wait a month and go to the FBI with whatever circumstantial evidence you have and adopt whistleblower status for the same information, right?
No, I don't agree with your characterization.
Okay. In any event, in this memo, you say that the metadata is inconclusive, right?
I'm sorry, where are you pointing me to?
Zoom back out, Eric, if you would, please. Yep, metadata is inconclusive. No proof of crime. No disproof of crime either, right?
I wrote down metadata is inconclusive, no proof of crime, and that was my belief at that time, and it still is.
In any event, I think you can tell the jury, and that we'll agree, you didn't do any investigating after that, right?
No, that's not true. I tried to investigate. I tried to get the rest of the documents that Nate Paul and Michael Wynn had told me they had on August 5th.
But what they told you they didn't
told me
have was
they'd
the
gotten a bunch
original
of documents
warrant,
from Judge
which is
Lane,
what you should have
and
been
I
looking
never felt
for.
like they'd given me all the documents.
He should have been
You had
looking for the
already told
original
Nate Paul
warrant.
and his lawyer the day before that you were going to close the investigation before you had those documents. True?
That's true.
Well,
And the Attorney General didn't accept
Jack
it.
not responsive to anything after truth.
I wonder why the
Sustained.
Attorney General didn't accept
Right.
it.
I'm going to show you what's marked as Exhibit AG 1014, please. We're going to move ahead in time from August 13th of 2020 to September 4th of 2020. Can you see this document in front of you on the screen or in your hand? You've got a copy of it physically.
Yes, I think I can see it better on the screen if you'll blow it up. Thank you.
This is an email from General Counsel. This is Leslie French at the OAG, and she's sending it to FLD Contracts. It says, FLD, please see the attached partially executed contract and disclosures from Mr. Kamak. I have reviewed the disclosure statement of Brandon Kamak and am satisfied with the choice of outside counsel for this matter. You see that?
I do see that.
Okay. And on September 4th, you got the DocuSign
Sorry,
that
I'm
day.
moving stuff around.
Yes?
I've said in writing that I
Oh, no, don't you freeze up.
got it that day, but now that I've reviewed a lot more evidence, I think I made a mistake, and I believe I've got it for the first time on September the 16th is when it reached my email inbox.
Well, that's not what you testified to under oath before the House Board of Managers, is it?
That's why I said I made a mistake.
Yeah.
You're correct.
And when you, and I think you'll agree, I'm not gonna have to pull your transcript out. You testified to the House Board of Managers and their investigators that you got it on September 4th. And then you went on vacation and said, I'll take care of that when I get back. That's what you told them, yes? And now you're telling a different story, yes?
Well, he doesn't remember.
Well, you've asked two questions at least. I'll answer it this way if I may. Yes, I told the House managers I thought the date I first received the executive approval memorandum was on September the 3rd or 4th, whatever date is in the transcript. I don't argue with that. I now believe I first received it on September the 16th, so I'm correcting my testimony.
Okay, you're correcting your testimony that you gave to the House Impeachment Board's investigators, yes?
Yes, that's true.
We should believe what you're saying today and not then, yes?
Yes.
Well, he's under oath now. Remember, guys, the House didn't put any of their witnesses under oath before they drafted those articles and
Our next exhibit in
filed,
time,
passed,
if
and
you
voted
would,
on them.
we're going to go back to Exhibit AG 88. I'm going to show you the next page.
That's why we're asking for due process with this Senate hearing, because it was not afforded in the House. I'm actually glad that we kept all of 20 of the articles in, because it's allowed for Paxton's team to show, again, just the sheer
Your Honor,
amount
because it was,
of bullshit
if I may,
that
because
these
this was
people
a
are doing,
group
that these people are
offer,
willing to go to.
they're
The
all,
links,
of course, Exhibit 88. If counsel
links
could, on
these
each one of
people
these
are willing to
pages
go
where he
to.
does it for us, give it some type of identifying so we can know and be able to pull back up later.
Some of them are corrupt, some of them are stupid,
I'll
some
identify
of them
by
are paid
Bates
off,
number if that's okay.
some of them are blackmailed.
So, Mr. Arroyo, if you'll go to the Bates ending in 8.
I realize they're in evidence, but I would like is a Bates number each time so I know which one to look for.
Would you accommodate him, please?
We'll do our best. Yes. Mr. Arroyo, go to page ending in 8. Give me all the text, Eric, if you would. This email is sent from Mark Penley to Brittany Hornsey, copying Drew Wicker. Hi, Brittany. I received a voicemail from the general today. He is requesting that all documents I have on the Nathan Paul matter be copied and given to Elise. Did I read that correctly?
You did.
The Attorney General just sent you to the showers, didn't he?
I'm sorry?
He just came to the mound and took the ball out of your hand. Said, give me the file. I'll take it from here. Yes?
He didn't say that.
That's what you should have inferred from that, right? The Attorney General came and got the file from you. Yes?
You're asking me to speculate. I don't know what was in his mind. I know I got a voicemail from him while I was on vacation asking me to get the file to one of the executive assistants on the executive floor, which I did.
You knew that was not a good sign, right?
No, I'd been given a warning that he was working up an outside counsel contract, and that was consistent with the idea that he was going around me and David Maxwell and trying to hire outside counsel.
He's taking the ball out of your hands, yes?
That's your phrase. I'll accept it if you want me to.
Okay, I do. You gonna accept it? He took the ball out of
I'll
your
accept
hands.
that he was trying to take the case out
It's
of
like,
my
yeah,
hands.
that's what I'm
There was
trying to
no
get you to
ball.
say.
Very good. Let's move to Exhibit AG 1015, if you would. And these are your notes from a side huddle with Jeff Mateer, Blake Brickman, and Ryan Banger. Yes?
Yes, that's correct.
And at the bottom, we've got more redactions. Yes?
Yes, they were irrelevant topics that came up in a meeting that had nothing to do with this case.
Well, I guess we'll have to take your word for it, won't we?
Sure.
Yeah.
Below that, it says NP, file returned. Joe Brown, Cliff Strickland, outside counsel contract. So you knew about it.
Yes, the purpose of the meeting with Jeff
Let me guess, it
was
was
so
all
he
about your
could
daughter's
update
wedding.
me on things that had gone on during the week I was gone. And he told me that the Attorney General had considered hiring Joe Brown, a former United States attorney and former district attorney in Sherman. He'd been the U.S. attorney in the Eastern District of Texas. He also, I believe, had conducted a phone interview with Cliff Strickland, an attorney in Denver.
All right, let's move ahead in time a little bit. May I approach the witness, Your Honor? Mr. Penley, I'm showing you what's been marked as Exhibit AG 124. Eric, would you bring that up, please? This is the second referral from the Travis County District Attorney's Office to Brandon Kamak on September 23rd of 2020, yes?
Yes.
And when you made your report to the FBI, you didn't know about this, true?
That's true.
And when you, I believe the word you used on direct was apoplectic.
Yes.
When you were apoplectic about the grand jury subpoenas being served by Brandon Kamak, it was because you believed they were being used for civil discovery in a criminal matter, true?
That's true.
But in fact, they were related to this second referral in a bid rigging investigation that had been referred to the Travis County District Attorney's Office over to Brandon Kamak.
You lost me on the second question. Could you repeat that, please?
Yeah, let me try again. The grand jury subpoenas Mr. Kamak was serving were relating to this referral in a bid rigging investigation that had been made from Travis County District Attorney's Office to Brandon Kamak. True?
That's not completely true. It's partially true.
It's a lot true, isn't it?
It's partially true. I'll explain if you want me to.
You can do that on redirect, I bet. We'll try. But here's what I want you to understand and I want you to appreciate and agree with me on. You didn't know about this, and the subpoenas that Mr. Kamak was serving were related to this referral. Yes?
A, I didn't know about this. I agree. B, all of the 39 grand jury subpoenas he obtained from Travis County did not relate to referral number 2. Part of them referred to referral number 1.
Thank you. We're going to move to Exhibit AG 92.
I do not believe 124 was admitted previously.
We move for admission of AG 124.
Any objection? That's the document Mr. Hardin, he had been working from before that one you were just handed.
He has seen 124, and this is 92.
I have no objection.
I'll show that Exhibit 124 is admitted into evidence. And now are you offering another?
AG 92, Mr. President.
Any objection on this one, Mr. Hardin?
No, Your Honor.
I'll show that Exhibit 92 be admitted into evidence. Continue.
Mr. Penley, after 10 days here in Exhibit AG 92, you admit, or you finally state, I'm not signing the outside counsel contract. Yeah?
You said after 10 days. What? You lost me at 10 days.
Your testimony today was that you got the outside counsel contract DocuSign on September 14th. You told them you got it on September 4th. Whether you've had it for 10 days or 20 days, you are now finally telling someone, I'm not signing it. Yes?
I received it on September the 16th, as I previously stated. So 8 days later, after the Attorney General called me and asked me to sign the outside counsel contract, I told him I could not and I would not, and I gave him all the reasons why. He told me to talk to Jeff Mateer and to forward this contract to Jeff Mateer, which I did.
Let's move to Exhibit AG 1017, Eric. These are the notes that have already been entered in evidence, I guess, on
Paxton
both
hadn't
sides.
realized there's
But
a
these are
full-on
your
mutiny
notes
at
from
that point.
September 26, right?
Yes, these are my after meeting notes on September 26 from McKinney.
Okay. This is discussion about hiring outside counsel, at least in part, yes?
Yes, that was discussed.
Okay, Eric, zoom in on the last half of the page, please. Higher, there you go, stop. Do you see the line about 4 lines down? It says, I said. Do you see that?
Yes.
It says, I said I don't need him, and we shouldn't be spending money on him when we can't give raises to our employees.
Yes, I see that.
You said that, didn't you?
I did.
None of that is your business or decision or authority at the Office of the Attorney General, is it?
I don't totally agree with you. I don't have the ultimate authority, but I have a duty to tell him about things going on in my area of responsibility. We couldn't give raises to our people. I felt like he was wasting money on outside counsel on an improper investigation, and I was trying to express that to him.
Do you understand that there are 900 outside counsel contracts every 2 years at the Office of the Attorney General?
I didn't know that, but I'll take your word for it.
And your explanation here, for one reason, Ken Paxton shouldn't hire Brandon Kamak is, I don't need him. We shouldn't be spending money on him when we can't give raises to our employees. That was what you said, yeah?
That's what I said.
And Ken Paxton got upset and he said, so you're going to exercise veto powers over the budget for the agency?
He said that, yes.
That was his response to you, yes?
Yes, it was.
At the bottom, it says there's a chance of media exposure.
It was for $50,000, by the way, that's all.
Yes.
You expressed you were worried about that, right?
I was worried for his sake, yes, and I warned him.
Go to the third page if you would, Eric.
$50,000 for outside counsel to look
Again, we see on the
into
third
whether
page
the
the word
FBI was abusing
inconclusive. The
Nate
theory
Paul's
advanced
rights.
by NP was inconclusive, yes?
I'm sorry, could you tell me, can you direct me to the part of the page you're looking at?
Yes, can you highlight that for the jurors?
Yes, it's about 3/4 of the way down. You see the word inconclusive? It says theory advanced by at the beginning of the line. Lower, Eric, right there. This theory, in about a third of the way down.
Yes,
theory advanced by NP was inconclusive, yes? You see that?
Give me, if I may have just a moment to read the paper copy.
Yeah, take your time.
Yes, I wrote that.
And toward the bottom of the page, and just leave it there, Eric, it says, I'm willing to hit the reset button and start fresh if they will produce docs, right?
Yes, I told him that.
You're 3 months into this referral, yes, and you're now telling your boss, I'm willing to hit the reset button, General Paxton.
That's
Yes?
what I told him on September the 26th, yes, after repeated requests for all the documents.
Turn the page if you would. Eric, give me the bottom half. You said, I told him this is a dangerous case. A dim DA or U.S. attorney could charge him with a play-for-pay scheme if they learned about the investigation, since Nate Paul is a campaign donor. Yes?
Yes, I wrote that.
Okay. You don't have any evidence that Nate Paul ever paid any type of bribe to Ken Paxton, do you?
I disagree with your statement.
Tell the ladies and gentlemen of the jury what evidence you have
Wait, what?
that Nate Paul paid Ken Paxton any type of bribe. Go.
I've read the evidence that was filed in response to the motion for summary judgment that your team filed. I've read.
Hold on a second. This is legal analysis based on what you've read?
Is that right?
You asked me if I had any evidence. I'm trying to answer the question, sir.
No,
Yes.
You're analyzing what evidence other people are offering in this case. On September 26, did you have any physical evidence, documentary evidence, eyewitness evidence, or circumstantial evidence that Ken Paxton had committed or been bribed by Nate Paul?
I had circumstantial evidence.
Anything else?
I had his behavior.
Anything else?
The campaign donation.
Anything else?
His absolute refusal to listen to common sense and reasoned legal positions. He wouldn't listen to anybody on the executive staff.
Y'all were trying to push the investigation under the rug
4,000
instead
pages
of doing
filed in
it. Y'all were
response to the summary
pretending to do an
judgment. There's stuff
investigation.
in there.
Did you have any of them?
I didn't have it on September 26. I know about it today.
They were pretending to do an investigation. Of course he wasn't listening to them. They were playing games. Fucking clowns. They were playing games.
The bottom portion of that bottom paragraph says,
That's
I
why
gave
we
him the
voted for Ken
scenario that
Paxton.
NP, if indicted, could make up a story and throw him under the bus to the feds. That's what you told him, right?
Whoa.
I did.
You told him the risk was Nate Paul would manufacture false information that could harm Ken Paxton, yes?
That's the way I phrased it, yes.
That's what you said and that's what you wrote, yes?
Yes.
That's bold. And rich.
We get to September 30th or 29th and 30th, your head explodes. Yes?
That's true. Figuratively speaking, I hope.
My head.
That's what you said under the. That's what you said to the House Board of Managers, right?
I did, and I was extremely upset when I found out about the grand jury subpoenas. Yes.
I'm going to show you what's marked as Exhibit AG 50. May I approach, Mr. President? Thank you. Mr. President, we move for admission of AG 50.
Any objection, Mr. Hardin?
No objection.
Eric, if you would put that up for
Admitted
me.
to evidence, please, AG 50.
You signed this, yes?
I did, yes.
It says, we have a good faith belief that the Attorney General is violating federal and/or state law. Yes?
Correct.
You had a good faith belief on October 1st,